ಅದೇ ಒಂದು ಅಯ್ಯೆ ಅವತ್ತು ಸಾಹೇಬ್ರ ಮೇಲೆ ಸಬ್ಮಿಟ್ ಮಾಡ್ಬಿಟ್ಟು ಅಯ್ಯೆ ಹಾಕಿದ್ದಾರೆ ಅಂದ್ಬಿಟ್ಟು ಕೇಳ್ಕೊಂಡು ಹೋದ್ರಲ್ವ ನೀವು. ಅದು ಬರಲ್ಲ, ಪರ್ಟಿಕ್ಯುಲರ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು, 27th ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು ಅಂದ್ಬಿಟ್ಟು ಮತ್ತೆ ಇವತ್ತಿಗೆ ಡೇಟ್ ಕೊಟ್ರಲ್ವಾ, ಹಾಕ್ಸಿ ಅದನ್ನ, ಪರವಾಗಿಲ್ಲ ಅಂತ ನೋಡಿ ಹಾಕೇ ಇಲ್ಲ. ನೀವು ಒಂದು ಕೆಲಸ ಮಾಡಿ, ಏನ್ ಹೇಳಿ ನೋಡಿ ಹೆಂಗ್ ಮಾಡ್ತಾರೆ ನಂಗೆ ಗೊತ್ತಿಲ್ಲ. ಇವಾಗ ತಾನೇ ಬಂದು ಹೇಳ್ತಾರೆ ಇವ್ರು. ಅವ್ರು ನೋಡ್ಕೊಂಡಿಲ್ಲ, ಇವಾಗ ಕಾಸ್ ಲಿಸ್ಟ್ ನೋಡ್ಕೊಂಡಿದ್ದಾರೆ. ಸರಿ, ನಾನು ನಾಳೆ ಹಾಕ್ಸ್ಕೊಡ್ತೀನಿ ಬಿಡಿ, ನಾಳೆ ಹಾಕ್ಸ್ತೀನಿ. ನಂಬರ್ ಹೇಳ್ಬಿಡಿ ನನಗೆ, ನಂಬರ್ ಕೊಡಿ. ನಂಬರ್ 141. ಅದೇ ಯಾರು ಹೇಳಿ? ಹಾ, ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್. ಅದೇ ಮಾಡಿಫಿಕೇಶನ್ ಆಫ್ ಹೇಳ್ತೀನಿ ಬಿಡಿ. ಓಕೆ, ಹೇಳ್ತೀನಿ, ನೀವೇನು ಇದನ್ನ ಮಾಡಕ್ ಹೋಗ್ಬಿಡಿ, ಮತ್ತೆ ಹೇಳ್ತೀನಿ. ಏನ್ ಮಾಡ್ತಾರೆ ಇಲ್ಲ, ಗೊತ್ತಿಲ್ಲ, ನಂಗೇನ್ ಗೊತ್ತು. ಅದೇ ಇವಾಗ ಕೇಳಿದ್ದಲ್ವಾ.
ಕ್ರಿಮಿನಲ್ ಆರ್ ಪಿ ಇದೇ ಕೋಟಿಗೆ ಬರುತ್ತಲ್ಲ, ಕ್ರಿಮಿನಲ್ ಆರ್ ಪಿ ಇದೇ ಕೋಟಿಗೆ ಬರುತ್ತೆ. ರಿವಿಷನ್ ಪಿಟಿಷನ್, ಕ್ರಿಮಿನಲ್ ರಿವಿಷನ್ ಪಿಟಿಷನ್ ಆಗ ಕೊಡ್ತೀವಿ. ಅದಕ್ಕೆ ಕೇಳಿದೆ, ಕ್ರಿಮಿನಲ್ ರಿವಿಷನ್ ಪಿಟಿಷನ್ ಅಪೀಲ್ ಅಂತೀರ, ಕ್ರಿಮಿನಲ್ ಆರ್ ಪಿ.
ಮೆಮೋಸ್ ಕೊಡಿ. ಇವತ್ತಿದೆಯಾ ವಿಡ್ರಾ? ಎಲ್ಲ ನಾಳೆಗೆ ಪೋಸ್ಟ್ ಆಗಬೇಕು.
Lordship's kind permission. There is a warrant on this particular case. So for recall of that, as well as there is urgency of this.
ವಾರೆಂಟ್ ಇಶ್ಯೂ ಆಗಿರೋದು ಎಲ್ಲಿ?
ಇಲ್ಲ, ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. We have come for a revision petition.
ಆಯ್ತು,
Kindly have it on tomorrow or Monday.
ವಾರೆಂಟ್ ಅಂತಂದ್ರೆ ಇಲ್ಲಿ ಸ್ಟೇ ಇಲ್ಲ.
ಇಲ್ಲಿ ಸ್ಟೇ ಇಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದೀವಿ. ಸ್ಟೇ ಇಲ್ಲ.
ವರ್ಷ ರಿವಿಷನ್ ಹಾಕಿರೋದು ನೀವು
24 ಅಲ್ಲಿ.
24.
ಹೌದು,
ಹಾ,
ಹೊಸ ಮ್ಯಾಟರ್.
ಆಯ್ತು, ಟುಮಾರೋ.
ಗ್ರೇಟ್ಫುಲ್.
ನಾಳೆ
ಸೀರಿಯಲ್ ನಂಬರ್ 52
ವೇಟ್ ಮಾಡಿ, ಪೇಜ್ ವೈಸ್ ಕರೆಸ್ತೀವಿ, ವೇಟ್ ಮಾಡಿ.
ಮೆನ್ಷನಿಂಗ್ ಫ್ರಮ್ ಪೇಜ್ ನಂಬರ್ 7, 42 to 45. ಮೇಡಮ್ ಹಾಕ್ತೀವಿ, ಹೇಳ್ಬಿಡಿ. 46 to 54.
ಹಾ, ಹೇಳಿ.
Kindly 1 week time maybe.
Why one time?
My senior is not well, my
Senior is not well. ನೀವು ಚೆನ್ನಾಗಿದ್ದೀರಲ್ಲ ಅಷ್ಟೇ. ನೋ ಡೇಟ್. You assist the court, that's all.
55 to 62, 63 to 65, 66 to 73, 74 to 78.
52 ಸೀರಿಯಲ್ ನಂಬರ್ 52.
78 ಏನಾಗಬೇಕು ಹೇಳಿ ಮೇಡಮ್. You are appearing for whom, madam? Petitioner. Date given matter, no date. Date given matter, no date. Inconvenience ಏನು ಹೇಳಿ? whether any death in the family or if he is suffering from any ill health, ಎರಡು ಇಲ್ಲ. ಎರಡು ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ ಡೇಟ್.
Serial number 52, sir. Serial number 52. Kindly have it next.
ಆಗ್ಲೇ ಕರ್ಸಿದ್ರೆ ಯಾಕೆ ಹೇಳಿಲ್ಲ 52 ಅಂತ
ಅದು
ಮೊದ್ಲೇ
settlement.
ಮೆನ್ಷನ್ ಮಾಡಿರಿ. ಏನಾಗ್ಬೇಕು ಹೇಳಿ ಜಗದೀಶ್ ಕೆ ಎನ್.
ಹೌದು ಸರ್, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೊಡಿ ಸರ್.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಏನಕ್ಕೆ ಹೇಳಿ
ಅದು
ಡೇಟ್.
ಸೆಟಲ್ಮೆಂಟ್ ಮಾತುಕತೆ
ಹಾ?
ಸೆಟಲ್ಮೆಂಟ್ ಮಾತಾಡಿ
ಇದರ ಜೋಸೆಫ್ ಆಂಟೋನಿ
ಇಲ್ಲಿ ಬಂದೇ ಇಲ್ಲ, ಫೋನ್ ಮಾತಾಡಿದೆ ಸರ್,
ಫೋನ್ ಮಾಡಿ
ಹೇಳಿದ್ದೇವೆ ಸರ್.
ನೀವ್ ಹೇಳಿದಿರಾ?
ಹೌದು ಸರ್.
ಮತ್ತೆ ಬಂದವರು ಇಲ್ಲ ನನಗೆ ಹೇಳಿಲ್ಲ ಅನ್ಕೊಡುದು.
ಇಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮೇ ಹೇಳಿದ್ದೇವೆ ಸರ್.
ಲಾಸ್ಟ್ ಟೈಮ್ ಬೇಡ ಇವತ್ತಿಂದ ಹೇಳಿ.
ಇವತ್ತು ಹೇಳಿ ಲಾಸ್ಟ್ ಟೈಮ್.
ಹೇಳಿಲ್ಲಲ್ಲ
ಇಲ್ಲ
ಹೇಳಿ ಆಮೇಲೆ ನೋಡೋಣ.
Malaj,
ಹೇಳಿ ಆಮೇಲೆ ನೋಡೋಣ.
pardon me, Malaj. 63 Malaj, ಅದು ಮೊನ್ನೆ ಪಾರ್ಟೆಡ್ ಆಗಿದೆ.
ಆಯ್ತು ಹೇಳಿ.
ಅದು ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ. ಮೊನ್ನೆ ಎಲ್ಲ ಮಾತುಕತೆ ಎಲ್ಲ ಆಗಿ ಮುಗಿಸೋಕ್
ಯಾವ್ದು ಹೇಳಿ.
63 ಸೋಲ್. ಆ ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ನಾನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದೆ ಬಿಟ್ವೀನ್ ಬ್ರದರ್ಸ್.
63.
ಹೌದು ಸರ್.
ಹಾ
ಅದು ಸೆಟಲ್ಮೆಂಟ್ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ.
ಹಾ
ಮೋಡ್ ಆಫ್ ಟರ್ಮ್ಸ್ ಸ್ವಲ್ಪ ತಮ್ಮ ಮುಂದೆ ಒಂದು
ಆಯ್ತು ಯಾವಾಗ ಬೇಕು ಹೇಳಿ.
10 days ಬೇಕಾಗಿತ್ತು.
ಆಯ್ತು ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ?
ಆಗಿದೆ sir.
Appellant counsel submits that already matter has been settled, going to report the settlement and hence list this matter on 10 days ಬಿಟ್ಟು ಕೊಡಿ ಮೇಡಮ್. 20th
21,
21
Please, Malaj.
My lord, serial number 77, my lords.
77 ಹೇಳಿ ಏನಾಗ್ಬೇಕು?
Come for the petition.
Huh?
I seek for small accommodation, my lords.
ಏನ್ ರೀಸನ್ ಏನ್ ಹೇಳಿ.
My lords, actually, I'm not well aware with the criminal matters. I need some time to get prepared, my lord.
ನಾಟ್ ವೆಲ್ ಅವೇರ್ ಆಫ್ ದಿ
Criminal matters.
ಕ್ರಿಮಿನಲ್ ಮ್ಯಾಟರ್.
Please, so I
ಹಾ,
need
ಯಾರು
some
ಇವತ್ತು
time for,
ನೀವ್ ಯಾರಿಗೆ ಅಪೇರ್ ಆಗೋದು?
ನನ್ನ petitioner ಗೆ.
ಆಯ್ತು ನಿಮ್ಮ ಕೊಲ್ಲಿಗೆ ಯಾರು ಸೈನ್ ಹಾಕಿದಾರೆ? ಯಾರು ರಾಮಸ್ವಾಮಿ?
My lords, I need some time. Next.
No date, madam, no date.
Next week.
ದಟ್
my
ಕೆನಾಟ್
lord.
ಬಿ ಎ ಗ್ರೌಂಡ್. ವಕಾಲತ್ ಹಾಕಿದ್ಮೇಲೆ ನನಗೆ ಐ ಆಮ್ ನಾಟ್ ಅವೇರ್ ಆಫ್ ಕ್ರಿಮಿನಲ್ ಮ್ಯಾಟರ್ ಅಂತ ಹೇಳಂಗಿಲ್ಲ. ಬಿಫೋರ್ ಅಕ್ಸೆಪ್ಟಿಂಗ್ ದಿ ಬ್ರೀಫ್. ಹಾ
non-compliance at first time, seal number 1, Sandesh Kumar M.
ಹೇಳ್ರಿ.
I am for the petition. Short, within a week I will comply, my lord. Yes.
Week time granted as sought.
2, Jagdish
ಜಗದೀಶ್
KG.
ಕೆಜಿ ಇಲ್ವಾ? Petitioner counsel absent. 1 week, 2 weeks time granted to comply with office objection.
3, Nanjun Swami N.
Petitioner my lord.
ಹಾ ಎಷ್ಟು ದಿವಸ ಬೇಕು ಕಂಪ್ಲೈನ್ಸ್? ಕಂಪ್ಲೈನ್ಸ್ ಎಷ್ಟು ದಿವಸ ಬೇಕ್ರಿ? ನಂಜುಂಡ ಸ್ವಾಮಿ ಮ್ಯೂಟ್ ಆಯ್ತು ನೋಡಿ, ಮ್ಯೂಟ್ ಆಯ್ತು. ಹಾ
2 days my lord, 2 days.
2 days granted as sought.
4,
Great.
Samir SN.
ಸಮೀರ್ ಎಸ್ಎನ್ ಇಲ್ಲ, absent 2 weeks time granted.
5,
ವಾಗೀಶ
Vagish N.
absent 2 weeks time granted.
6,
ಶಿವಕುಮಾರ್ ಜಿಎಸ್ absent 2 weeks time granted.
7,
ವಸಂತ ಮಾಧವ absent 2 weeks time granted.
8, Arvind Babu.
ಅರವಿಂದ್ ಬಾಬು
2 weeks, my lord, I comply.
council seeks 2 weeks time granted as sought.
9,
ಯಾರ್ ನಾಗರಾಜ್?
K.R.
Lord.
Nagraj.
I appeal for the petitioner.
Yes.
Lord, there are 2 office objection.
ಹೌದು.
One office objection regarding the proof of address. Lord, I am ready with the Aadhaar card. Regarding second office objection, my lord, in the affidavit, I have clearly stated, my lord, though he is a resident of Channapatna, now at Bangalore. Lord, that second objection, my lord, it needs to be overruled. I pray your lordship.
Second office objection.
At Bangalore, where the party is residing at.
ಚನ್ನಪಟ್ಟಣ.
Yes, I have stated, my lord, now at Bangalore.
Now at Bangalore.
Yes,
Noted.
my lord.
The office objection is overruled regarding the second office objection. Regarding first office objection,
I am ready with Aadhaar card, my lord, I will
ready ಇದ್ರೆ
produce.
ಕಂಪ್ಲೈಂಟ್ ಮಾಡ್ರಿ, ಅಲ್ಲಿ ಕೊಡ್ರಿ ಕಂಪ್ಲೈಂಟ್ ಮಾಡಿ.
ಮಾಡ್ತೀವಿ sir.
And
My lord,
permitted to comply the office objection number 1 during the course of the day. List this matter ಯಾವಾಗ ಬೇಕು?
my lord, if you.
ಯಾವಾಗ ಬೇಕು ಹೇಳಿ.
Ready, my lord.
ಮಂಡೆ ಅದ್ ಮಾಡಿ ಕಂಪ್ಲೈಂಟ್ ಮಾಡಿ.
Ready ಇದೆ ಸ್ವಾಮಿ, ಅದೇನಿಲ್ಲ ಅಡ್ರೆಸ್.
ಏನಿಲ್ಲ ಅಂದ್ರೆ ಅದ್ನ ಎನ್ಕ್ಲೋಸ್ ಮಾಡ್ಬೇಕ್ರಿ, ನೀವು ಕೊಡ್ಬೇಕು ಅದನ್ನ, ಅವ್ರು ಸ್ಯಾಟಿಸ್ಫೈ ಮಾಡ್ಬೇಕು.
ಸರಿ ಮೇಡಮ್.
ಅವ್ರು ಕೊಡಿ.
Convenient.
ಮಂಡೆ ಆಗ್ಬೋದಾ?
ಆಗ್ಬೋದು ಸ್ವಾಮಿ.
13th.
10, Rohit PJ.
I will comply
Wait,
in 2
wait.
days, my lord.
Huh?
I will comply in 2 days, my lord.
Yes, 2 days time granted as sought for
It may be
compliance.
taken up on 15th, my lord.
Huh?
50, it may be taken up on 15th, my lord. I will.
15th.
15th.
ಆಯ್ತು, list this matter on 15th.
Second time non-compliance.
Benjamin,
My lord,
time,
2 weeks time.
2 weeks time granted as sought.
12, K.S. Ganesh.
Absent 2 weeks time granted. Finally,
Kemparaju.
Lords, I'll comply with it during the course of the, kindly have it tomorrow.
Council
Lords.
submit that during the course of, ಅಲ್ಲ second time list ಆಗಿದೆ, urgency ಏನು ಈಗ?
My lords, ಅದು certified copy.
2 days
one-
time
one-
granted to comply with office subsection, list this matter on 13-1. ಮಂಡ್ಯಕ್ಕೆ ಹಾಕಿದೀನಿ ನೋಡಿ.
Third time non-compliance.
Third time non-compliance, Jairamaya D. Council absent, finally 1 week time granted. If office subsection not complied, list the matter for dismissal. Date ಕೊಡಿ.
16 plus 17-1.
17-1.
Orders matter 15.
Mohammed rules 9. 15, yes madam, cost.
My lord, I have paid cost 1,000 rupees. For non-compliance of office objection, we have cleared.
ಏನಕ್ಕಿದೆ ಮೇಡಮ್ ಅದು?
We have cleared the office objection, my lord.
Along with office note ಅಂತ ಏನಿದೆ, ಕಾಸ್ಟ್ ಕಟ್ಟಿದ್ರೆ?
We have cost.
ಹಾಕಿದ್ದು office application apply ಮಾಡಿದ್ದು. 1000 rupees
ಕಾಸ್ಟ್ ಕಟ್ಟಿರ್ಲಿಲ್ಲ. ಆಯ್ತು. The petitioner council submits that she has paid the cost today
Yes, I
In the
paid
office.
today along with memo.
and filed the memo along with receipt,
This is the receipt, my lord. This is the receipt.
memo
This is the receipt I paid.
and copy of the receipt. ಅದ್ರ ಜೊತೆಗೆ ಸೇರಿಸ್ಕೊಳ್ಳಿ, ತಗೊಳ್ಳಿ. And then post the matter for admission. When do you want, madam? Any urgency?
No, my lord.
No.
No.
List the matter in the next week ಅಂತ ಹಾಕ್ಬಿಡಿ.
16.
Memo for retirement filed by the petitioner council Manjunath ND.
He is depositing 10,000 today, blood.
ಏನ್ ಡೆಪಾಸಿಟ್ 10,000?
Warrant recall ಮಾಡಿ.
Details of balance amount of rupees 10,000.
Depositing to recall the warrant.
ಏನು?
Bond was 10,000 ಹಾಕಿ.
Taking note of the same, the non-bailable warrant is recalled on payment of cost of rupees 20,000 as the fine amount. Rupees 10,000 is paid by the region petitioner today and seeks for a short accommodation to pay the balance amount of rupees 10,000. ಈಗ ಕಟ್ಟಿದಾರಾ?
ನೀವು ಇವತ್ತು ಕಟ್ತಾರೆ, ಇನ್ನು 10 ಕಟ್ಲಿಕ್ಕಿದೆ, ಮೊನ್ನೆ 10.
ಅದೇ ಎಲ್ಲಿ ಕಟ್ತಾರೆ?
ಹೌದು, ಈಗ ಕಟ್ತಾರೆ.
ಹೈಕೋರ್ಟ್ ಅಲ್ಲ?
ಹೌದು,
ಕಟ್ಟಿ ಬರ್ಲಿ,
ಇದು ಕಟ್ತಾರೆ.
ಕಟ್ಟಿ ಬರ್ಲಿ, ಪಾಸ್ ಅವರು. Balram ML, production of petitioner. ಇದೇನ್ರಿ production awaits report in respect of focus notice issued to the surety.
Third, my lord.
Postal tracks status with respect to Tumkur, item delivered, address C. The same is placed at B. ಹೇಳಿ ಏನಾಯ್ತು?
17.
Notice, sir.
17. ಹೌದು ಹೇಳಿ.
Recently, the advocate earlier counsel appearing for has expired.
ಏನಾಗಿದ್ದಾರೆ ಆರ್ಡರ್?
We have filed a wakalat in this case. The name of counsel. And for petitioner. Yunus Ali Khan. ಮತ್ತೊಂದು ದಿನಾಂಕವನ್ನು ನೀಡಬೇಕು.
ಎರಡು ಯಾಕೆ ರಿಪೋರ್ಟ್? ಎರಡರಿಂದ ಇಬ್ರು ಇರ್ಬೇಕು ನೋಡಿ. ಶೋಕಾಸ್ ನೋಟಿಸ್ ಇಶ್ಯೂ ಟು ದಿ ಸೂರಿಟಿ ಕೂಡ ಹೋಗಿದೆ ಮೇಡಮ್.
ಆಗಿದೆ ಸರ್, ಸರ್ವ್ ಆಗಿದೆ.
ಸರ್ವ್ ಆಗಿದೆ ಅಂತಿದೆ.
ಇವರು ತಲೆಮರೆಸಿಕೊಂಡ, ಇವರು petitioner ಗಳನ್ನ ಅವರು.
ಅವ್ರು ತಲೆಮರೆಸ್ಕೊಂಡವ್ರೆ. ಸೂರಿಟಿ ಇದೇನಾಯ್ತು?
ಜಾರಿ ಮಾಡಬೇಕು.
ಆಯ್ತು ಹೇಳ್ರಿ ಏನ್?
My lord, earlier counsel appearing for petitioner has expired. Earlier counsel appearing for.
ಕೌನ್ಸಿಲ್
Yes.
ಯಾವಾಗ ತಿರ್ಕೊಂಡಿರೋದು ಅವರು?
I don't know exact date, my lord, but he has expired, but we got, a wakalat recently, we have filed a wakalat in this case, my lord.
ಆಯ್ತು, ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋಬೇಕಲ್ಲ. ಈಗ ಸೂರಿಟಿ ನೋಟಿಸ್ ಆಗಿದೆ, ಶೋಕಾಸ್ ನೋಟಿಸ್ ಟು ಸೂರಿಟಿಗೆ ಇಶ್ಯೂ ಆಗಿದೆ, ಅದು ರಿಕಾಲ್ ಮಾಡೋದ್ ಬೇಡ ಆರ್ಡರ್?
We will recall, my lord.
ಯಾವಾಗ ಮತ್ತೆ?
A short
ಇವನು
of-
ನಿಮ್ಮನೇನ್ ತಲೆಮರೆಸ್ಕೊಂಡವನಂತಲ್ಲ?
No, my lord, he is a driver because he is traveling throughout the country.
ಆಯ್ತು, ಅದಕ್ಕೆ ತಲೆಮರೆಸ್ಕೊಂಡಿದ್ದಾನೆ ಅಂತ ಯಾಕೆ ಬರುತ್ತೆ? ಸೂರಿಟಿಸ್ಗೂ ನೋಟಿಸ್ ಆಗಿದೆ, ಸೂರಿಟಿ ಸರ್ವಿಸ್ ಆಗಿದೆ, ಏನಿಲ್ಲ ಫರ್ಫೀಚರ್ ಆಫ್ ಬಾಂಡ್ ಈಗ ಅಷ್ಟೇ.
We filed a wakalat recently, my lord, so we are.
ರೀಸೆಂಟ್ಲಿ ಅಂದ್ರೆ ಯಾವಾಗ ಹಾಕಿರೋದ್ರಿ ವಕಾಲತ್ತು? ಹಿಂದಿನ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಮೇಡಮ್. ಡೈರೆಕ್ಷನ್ ಇದೆ, ಪ್ರೊಡಕ್ಷನ್ ಆಫ್ ಪಿಟಿಷನರ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್ ಅಂತ ನಾನ್ ಬೇಲಬಲ್ ವಾರೆಂಟ್ ಆಗಿದೆಯಾ? Earlier, the region petitioner was represented by Yunis Ali Khan. Since he is no more, court notice came to be issued. Court notice is served on the region petitioner. Court notice serve ಆಗಿದೆಯಲ್ರಿ ಅವನಿಗೆ? Who remained absent. Accused has been convicted for the offence mentioned so. Issue non-bailable warrant to the region petitioner and show cause notice to the surety as to why bond amount should not be confiscated.
A short accommodation may be given, we will.
ಏನ್ ಶಾರ್ಟ್ ಅಕಾಮಡೇಷನ್? ವಕಾಲತ್ ಹಾಕಿದ ಅವಾಗ ಹೇಳ್ರಿ ಅಂದ್ರೆ ಏನ್ ಹೇಳಕ್ಕಾಗಲ್ವ ಅದನ್ನ? ಏನಕ್ ಬರ್ತೀರಿ ಕೋರ್ಟ್ಗೆ? ಯಾವಾಗ ಹಾಕಿದಾರೆ ಮೇಡಮ್? ನೀವೇ ನೋಡ್ರಿ ಹೋಗ್ಲಿ. ಇಲ್ಲಿ ಹೆಸರು ತೋರಿಸಿದ್ರಲ್ಲ, ಬಲರಾಮ್ ML ಅಂತ. ಬೆಳಗ್ಗೆ ಹೋಗಿ ಫೈಲ್ ನೋಡಕ್ಕಾಗಲ್ಲ ಆಫೀಸಲ್ಲಿ. 1812 ಇಂದ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? NBW ಇಶ್ಯೂ ಆಗಿದೆ, ಶೂರಿಟಿ ನೋಟಿಸ್ ಆಗಿದೆ, ಶೂರಿಟಿ ನೋಟಿಸ್ ಸರ್ವಿಸ್ ಆಗಿದೆ. ನಾನೇನ್ ಮಾಡಕ್ಕಲ್ಲ, ಈಗ ಫರ್ಫೀಚರ್ ಮಾಡ್ಬೇಕು ಅಷ್ಟೇ, ಸರ್ವಿಸ್ ಆಗಿರೋದ್ರಿಂದ ತಗೊಳ್ಳಿ.
My lord, kindly pass over. We will.
ಎಲ್ಲಿ ನಿಮ್ ಪಿಟಿಷನರ್ ಅಲ್ಲಿ ಕೋರ್ಟ್ ನೋಟಿಸ್ ಹೋದ್ರೂ ಬರಲ್ಲ, ಅವನಿಗೆ ನಾನ್ ಬೇರೆಬಲ್ ವಾರಂಟ್ ಇಶ್ಯೂ ಮಾಡಿ ಕೋರ್ಟ್ ಮುಂದೆ
Kindly
ಕರ್ಸ್ಕೋಬೇಕಾ?
pass over, my lord.
ಹಾ ಹೊಸೂರು ವಕಾಲತ್ ಹಾಕುವಾಗ್ಲೇ ನೋಡ್ಬೇಕು ಏನಾಗಿದೆ ಕೇಸು ಅಂತ. ನಾವೇ ಎಲ್ಲ ನೋಡ್ಬೇಕು ನೀವ್ ಯಾವಾಗ ವಕಾಲತ್ ಹಾಕಿದ್ರಿ ಅಂತ. ಬಂದ್ ನಿಂತ್ಕೊಬಿಡಿ.
80.
Awaiting report in respect of bailable warrant issued against the petitioner. ಏನಾಯ್ತು ನೋಡ್ರಿ? Item delivered address C and the same is placed at back. ಏನಾಯ್ತು?
I'm appearing for the petitioner, my lord.
ಹಾ
The petitioner is present before the court.
ಎಲ್ಲಿದ್ದಾರೆ?
Idare open court ಇದೆ.
ಹಾ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, on the last date of hearing, my lord, the counsel and record for the petitioner was absent before the court, my lord. Due to their personal illness, they could not able to appear before the court, and for that reason, my lord, the petitioner got the NOC.
ನಿಮ್ಗೇನಾಯ್ತು?
Now I got the NOC from the previous counsel, my lord.
None appears for the revision petitioner. Even on the last date of hearing, there was no representation on behalf of the revision petitioner.
Idರಲ್ಲಿ yesterday they got NOC.
Suffered an order of conviction under so issue bailable warrant to the revision petitioner in a sum of rupees 20,000 returnable by 9/1/25. ಹೇಳಿ.
Yesterday they got NOC from the previous.
ಸ್ಟೇಟ್ ಇಲ್ಲ ಯಾವುದೇ ಇಲ್ಲ 2016 ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಬಂದು ಕೋರ್ಟಿಗೆ ಬರೋದಿಲ್ಲ, ವಕಾಲತ್ ಹಾಕ್ತೀರಿ, ಕೋರ್ಟಿಗೆ ಬಂದು ಕೇಸ್ ಅಪಿಯರ್ ಆಗಕ್ಕಾಗಲ್ಲ.
Can I make one submission, my lord?
ಇಲ್ಲ ಏನು ಬೇಲಬಲ್ ವಾರಂಟಿಗೆ ಜಾರಿಯಾಗಿದೆ.
Yesterday they got the NOC from the previous counsel, my lord. I am ready to address the argument. Can tomorrow yesterday, my lord.
ಯಾವಾಗ ನೀವು ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇಲ್ವಾ?
ನನಗೆ ಇವತ್ತು ಬೆಳಿಗ್ಗೆ ತಂದು ಕೊಟ್ಟಿದ್ದಾರೆ, ನಾನು ನಾಳೆನೇ ಮಾಡ್ತೀನಿ.
ರಾಜಶೇಖರ್ BGR
ಅಲ್ಲ, the previous counsel, my lord, he has issued the NOC, my lord.
NOC ಕೊಟ್ಟಿದ್ದಾರಾ?
NOC ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದಕ್ಕೋಸ್ಕರ
ನಿಮ್ಮ ಹೆಸರು ಹೇಳಿ ಹೋಗ್ಲಿ.
VR Balaraj.
The petitioner is present. Counsel Sri
VR Balaraj.
VR Balraj.
Please, ma'am.
VR Balraj submits that he is going to file wakalat with NOC from previous advocate and 6 weeks time. And this is the criminal revision petition of 2016. And this court also issued a bailable warrant when the counsel did not appear in the previous occasion. And petitioner is also present before the court, and hence 1 week time granted to file a NOC wakalat and directed to argue the matter without fail in the next date of hearing. List this matter on ಯಾವ ಕೊಡ್ತೀರಾ ಮೇಡಮ್? 21.
Grateful.
90. Akram Pasha.
This the matter.
On furnishing of
Petitioner.
PF and petition copy to
ಇದರಲ್ಲಿ
notice to the respondent. ಏನ್ರಿ ಇದು?
ಇದರಲ್ಲಿ ಪಿಟಿಷನರ್ಗೆ ಸ್ಟೇ ಮಾಡಿದ್ರೆ ತಾವು
ಹಾ?
ಪಿಟಿಷನರ್ಗೆ ಸ್ಟೇ ಆಗಿತ್ತು. But
Petitioner
ಅವರು
stay ಆಗಿದ್ದಾರೆ.
he is-
done within a week.
yes
issue
lordship,
notice to the
he has not deposited and thereby he is from Calcutta. Instructions ಏನು ಸರಿಯಾಗಿ ಕೊಡ್ತಾ ಇಲ್ಲ ನನಗೆ. ಸೊ ನಾನು ರಿಟರ್ನ್ ಮೇಲೆ ಮೆಮೊ ಹಾಕೊಳ್ತೇನೆ ಸರ್.
ರಿಟೈರ್ಮೆಂಟ್ ಆಗಿ
ಇನ್ನೂ ಹಾಕಿಲ್ಲ
ನೋಟಿಸ್
ಅಲ್ಲಿ
ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಡ್ತೀನಿ
ಹಾ?
ಸರ್. ಟುಡೇ ಅದು ಕಲ್ಕಟ್ಟ ಸರ್, ಕರೆಕ್ಟ್ ಅಡ್ರೆಸ್ ನಲ್ಲಿ ಅವ್ನು-
ಸರ್ವಿಸ್ ಆಗಿಲ್ಲಲ್ಲ 2018 ಇಂದ ಯಾಕೆ? PF ಕೊಟ್ಟಿಲ್ವಾ?
ಇಲ್ಲ ಇಲ್ಲ sir.
ಒಂದ್ಸರಿ ಇಲ್ವೇ?
ಇಲ್ಲ
ಒಂದ್ಸರಿ
Yes.
PF ಕೊಟ್ಟಿಲ್ಲ?
ಕೊಟ್ಟಿಲ್ಲ sir.
ಮುಗ್ದೋಯ್ತು, ಡಿಸ್ಮಿಸ್ಡ್.
ಇಲ್ಲ ಅದು ಒಂದು ರೆಫರೆನ್ಸ್ ಮಾಡ್ಬಿಟ್ಟು ಇದು ಮಾಡಿ.
ಅಲ್ಲ ರೀ 2018
ಅವನು ಈಸ್
State
ನಾಟ್ ಫ್ರಮ್
ಯಾವ-
ಬ್ಯಾಂಗ್ಳೂರ್ ಸ್ವಾಮಿ, ಈಸ್ ಫ್ರಮ್ ಕಲ್ಕಟ್ಟ.
ಎಲ್ಲಾದ್ರೂ ಆಯ್ತು. ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು ರೆಸ್ಪಾಂಡೆಂಟ್ ಆನ್ IA as well as on the main petition. Pending consideration of IA. ದುಡ್ಡು ಕಟ್ಟಿದ್ದೀರಾ ಹೋಗ್ಲಿ?
ಇಲ್ಲ ಕಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ, ಅದಕ್ಕೆ
ಅದು
ಇನ್ಸ್ಟ್ರಕ್ಷನ್
ಕಟ್ಟಿಲ್ಲ.
ಕಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ಹೇಳ್ತಾರೆ.
ತಗೊಳ್ಳಿ. The petitioner counsel submits that the petitioner is not cooperating in spite of this court.
ಪ್ಲೀಸ್
State the matter subject to depositing of suspended the sentence subject to depositing of 50% void order dated 8/8/24. Could not comply with the order. And also even PF also not paid. And when such being the case, the petition is dismissed.
20. Kumara KG.
petitioner.
Hmm.
2012
Non-filing of necessary application by the counsel for petitioner to bring the LRs of deceased respondent on record. ಹೇಳ್ರಿ.
2020 ಆರ್ಡರ್ ಮೇಲೆ ಸಸ್ಪೆನ್ಷನ್ ಸೆಂಟರ್ ಅದು
ಹಾ?
ಡೆಪಾಸಿಟ್ ಮಾಡಿಲ್ಲ. ಲಾರ್ಡ್ಸ್ ವಿ ಹ್ಯಾವ್ ನಾಟ್ ಕಂಪ್ಲೀಟ್
37/24 ಬರ್ತಾ ಇಲ್ವಾ?
ಅವರು ಬರ್ತಲ್ಲ, ಈಗ ನಾವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಆಲ್ಸೋ ಡೈಡ್.
ಹ್ಮ್.
ಅವ್ರ ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಳೋದಕ್ಕೂ ಮೆಲಾಸ್ ದೇರ್ ಇಸ್ ನೋ ಇನ್ಸ್ಟ್ರಕ್ಷನ್.
Respondent, ನೀವು accused ನಿಮ್ಮವನು.
ನಮ್ಮನ್ನ accused.
ಹಾ.
Petitioner accused.
The respondent is no more.
No more.
Despite sufficient opportunity having been given. Respondent of petitioner failed to do so, therefore it is appropriate to direct learned counsel of the petitioner to bring the legal representative of the deceased respondent on record. Tole, though this court granted time on 37/24 to bring the legal representatives of the deceased respondent on record, steps have not been taken, and counsel for the petitioner also submits that the petitioner is also not cooperating with him. And also even not complied,
Order. Even first session.
not complied, the order dated 26/8/21. ಏನ ಸ್ಟೇ ಇತ್ತ, ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಆಗಿತ್ತ? ಇಲ್ಲಲ್ಲ,
ಆಗಿತ್ತು.
ಯಾವಾಗ? ಆ ದುಡ್ಡು ಕಟ್ಟಿಲ್ವಾ?
ಕಟ್ಟಿಲ್ಲ.
ಇವಾಗೇನ್ ಮಾಡಿಲ್ವಲ್ರಿ? ಆರ್ಡರ್ ಬರೀ ಬಾಂಡ್ ಬರ್ಕೊಡು ಅಂತ ಮಾಡೋರಲ್ರಿ. Sentence passed by trial court is hereby suspended until further order subject to the following conditions. ಏನ್ ಅಫೆನ್ಸ್ ಏನು?
138.
ಇಲ್ಲಿ ಇದೆಯಲ್ಲ 50% ಕಟ್ಬೇಕು ಅಂತ. And also not paid the amount of 50% from 26/8/21, and when such being the case, petition is dismissed for non-depositing of 50% as well as not taking any steps.
21.
Kavita MS, complaints of office objection for recalling the. ಏನ್ recall? ಯಾರಿಲ್ವಾ? ಎಷ್ಟು ಸರಿ ಬಂದಿದ್ ನೋಡಿ.
ಇದು ಡಿಸ್ಮಿಸ್ ಫಾರ್ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಆಗಿತ್ತು.
ಹಾ.
ಅದಾದ್ಮೇಲೆ ಒಂದ್ಸತಿ
Though this court granted 1 week time to comply with office objection, as last chance wide order dated 1/8/24 till date not complied, and hence IA is dismissed for non-compliance.
22.
Sarvana P. Office objection along with counsel submission. ಇಲ್ವಾ? ಎಷ್ಟನೇ ಸರಿ ಬಂದಿರೋದು ನೋಡಿ. ಏನ್ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ನೋಡಿ.
The order mentioned that the preamble of the judgment copy at page number 10 in criminal appeal. Case number mentioned that the operative question of the judgment copy at page number 14 is not tallying with the date of the order.
ಆಯ್ತು.
The last page of the
ಅವ್ರು ರಿಪ್ಲೈ ಕೊಟ್ಟಿದ್ದಾರೆ.
Date of the order at page number 10 is 8/2/23.
Hmm. 8/22. ಆಯ್ತು. There is a typographical mistake in mentioning the year. ಹೌದಾ? In the order of the criminal appeal.
Is CC number 46.
CC number 24646 ಅಂತಿದೆ. ಎಲ್ಲಾದ್ರೂ ಇದೆಯಲ್ಲ? CC 24646 of 2016 ಅಂತ ಇದೆ. ಎಲ್ಲಾದ್ರೂ ಲಾಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಅದೇ ಇದೆ.
Page number 24.
And the same and other objection is also a typographical error, and hence counsel submission is accepted. Post the matter for admission on 21.
23.
Abhishek NN. Awaiting service of notice. ಯಾವಾಗ ಇಶ್ಯೂ ಆಗಿರೋದು ನೋಡಿ. Item delivered ಅಂತಿದೆ. Address C. The same is placed at B ಅಂತಿದೆ ನೋಡಿ. Notice issued against the respondent held sufficient in view of delivery of endorsement of item delivered to the addressee. This is the matter for admission on 21.
23, 24.
I appear for petitioner, my lord.
Awaiting service of notice to the respondent. ಏನಾಯ್ತು?
Lord, I have filed NOC ವಕಾಲತ್ yesterday itself, my lord.
ನೀವ್ ಯಾರಿಗೆ?
Petitioner ಗೆ.
ನಿಮ್ ಇದೆಯಲ್ಲ ವಿದ್ಯಾ ಜಾಗೀರ್ದಾರ್.
I am ಮಂಜುಳಾ ಕಮಡೊಳ್ಳಿ, my lord.
ನೀವ್ ಹಾಕಿದೀರಾ?
ನಾನ್ ಹಾಕಿದ್ದೀನಿ. ನೆನ್ನೆ ಹಾಕಿದ್ದೀನಿ.
Counsel Manjula submits that he has filed wakalat ತಂದ್ಕೊಟ್ಟಿದಾರಾ on behalf of the petitioner, and hence registry is directed to show the name of the counsel and delete the name of Vidya Jagirdar. ಹೌದಾ?
Yes, my lord.
Notice issued against the respondent is also served. And hence held sufficient. List the matter for admission on 21.
ಅಲ್ಲ, my lord, 21/1, my lord, it is posted for orders in the DV Act, my lord, for the trial court. It may be posted tomorrow or Monday, my lord.
20 ಕೊಟ್ಟಿದ್ದೀನ್ರಿ. ಆರ್ಡರ್ಸ್ ಇರೋದು ಯಾವಾಗ? 21
21ಕ್ಕೆ ಆರ್ಡರ್ಸ್ ಆನ್ ಮೇನ್ ಇದೆ. I have challenged the
ಆಯ್ತು.
order.
15/1.
Please, my lord.
Srinivas V, furnishing of petition copy and process fee for issue of notice to the respondent.
Needful done, my lord.
ಯಾವಾಗ?
Already done.
ಯಾವಾಗ ಅಂದೆ?
ಇವತ್ತಾಯ್ತು. ಇವತ್ತು ಬೆಳಿಗ್ಗೆ.
ಅದನ್ನೇ ಹೇಳಿ, ಅದನ್ನ ಹೇಳಕ್ಕೇನು?
DD ರೆಡಿ ಇದೆ, my lord. Weeks time.
ಏನ್ DD ರೆಡಿ ಇದೆ? ಏನಕ್ಕೆ DD?
ಡೆಪಾಸಿಟ್ ಮಾಡಕ್ಕೆ. ಇದು ಡೆಪಾಸಿಟ್ ಮಾಡ್ಬೇಕಿತ್ತು, my lord.
ಸಬ್ಜೆಕ್ಟ್ ಟು ಕಂಡೀಷನ್ ಆಗಿದೆಯಾ? ಕಂಪ್ಲೈ ಮಾಡಿಲ್ವಾ ಆರ್ಡರ್ನ?
ಆರ್ಡರ್ ಕಾಪಿ ತಗೊಂಡು ಹೋಗ್ಬೇಕು, my lord ಅಷ್ಟೇ. DD ರೆಡಿ ಇದೆ. Weeks time ಬೇಕು.
ಯಾವಾಗ ಸ್ಟೇ ಆಗಿರೋದ್ರಿ? ಪೀರಿಯಡ್ ಆಗೋಗಿದೆಯಾ ಏನು?
ಇಲ್ಲ. 11 ಆಗಿದೆ. 8/11.
8/11/24 4 weeks ಅಂತ ಕೊಟ್ಟಿದೆ. ಈಗೇನ್ DD ಇಟ್ಕೊಂಡು ಏನ್ ಮಾಡ್ತೀರಿ? ಆಗೋಯ್ತಲ್ಲ ಟೈಮ್, ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್ ಬೇಕಲ್ಲ.
One week.
ಪಿಟಿಷನ್ ಕಾಪಿ ಇವತ್ತು ಕೊಟ್ಟಿದ್ದೀರಾ?
Petition
ಅಲ್ಲ ರೀ,
copy
ನೀವು ಇಲ್ಲಿ ಸ್ಟೇ ತಗೋಬಿಟ್ಟು TFA ಕೊಡಲ್ಲ ಅಂದ್ರೆ ಏನು? ವೆಕೇಟ್ ಮಾಡೋಣ ಬಿಡಿ, ಎಂಟ್ರಿ ಮಾಡ್ರು. ಅಂಡ್ ಆಲ್ಸೋ ಯು ನಾಟ್ ಕಂಪ್ಲೀಟ್ ವಿತ್ ದಿ ಆರ್ಡರ್.
weeks time.
ತಗೊಳ್ಳಿ. The council has not paid the PF and submits that he has paid the PF today.
ಪೇ ಮಾಡಿದ್ದೀವಿ.
Today in the office, and also order discloses that the sentence is suspended subject to deposit the 50% of amount within 4 weeks by order dated 8/11/24. And the same is also not complied with. And hence sentence
Week or 3 days.
suspended is vacated.
My lord, a week or 3 days time, my lord.
PF ಕೊಡಲ್ಲ, ಕಂಪ್ಲೈನ್ಸ್ ಮಾಡಲ್ಲ, ಇನ್ನೇನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ವೆಕೇಟೆಡ್.
My lord, DD ರೆಡಿ ಇದೆ, my lord.
DD ರೆಡಿ ಇಟ್ಕೊಂಡು ಪೂಜೆ ಮಾಡಿ.
One
ಮುದ್ಗಡೆ
week
ಹಚ್ಚಿ.
time ಕೊಟ್ಟು.
ನೆಕ್ಸ್ಟ್
26 ಪ್ರತೀಪ್ ಕೇಸಿ.
await notice. ಏನಾಯ್ತು ಇದು?
ಸರ್ವಾಗಿದೆ.
ಆಗಿದೆಯಾ?
Sufficient.
Postal track status item delivered.
Delivered.
Notice issued against the respondent is served. And hence held sufficient.
Lord, IA for the delay is there 77 days.
Delay ಎಷ್ಟು ದಿವಸ ಇದೆ? 77 days. Heard on A number 1 of 24 and there is a delay of 77 days and the delay is condoned. ತಗೊಳ್ಳಿ.
Suspension.
Heard on A number 2 of 24. ಎಷ್ಟಿದೆ ಅಮೌಂಟ್?
Lord, amount ಚೆಕ್ ಅಮೌಂಟ್ 3 ಲಕ್ಷ. ಫೈನ್ ಅಮೌಂಟ್ 4,05,000.
4,05,000. 5,000. 50% ಕಟ್ಟಿ within 4 weeks.
ಅಲ್ಲ, inclusive of the amount deposit.
Inclusive of the amount only.
ಆಯ್ತು.
And execute a bond for rupees 1 lakh with 1 surety before the trial court within 4 weeks. This is matter after 1 week ಆದ್ಮೇಲೆ 1 month ಆದ್ಮೇಲೆ ಕೊಡಿ.
10/2
ಆಗ್ಬೋದು.
27 ಹೇಮಂತ್ ಕುಮಾರ್.
Unserved postal return cost.
ಅದೇ ಅಡ್ರೆಸ್ ಮೇಲೆ, ಯಾಕಂದ್ರೆ ಪೇಜ್ ನಂಬರ್ 27
And as no such person in this door number, hence return to sender. ಹೇಳಿ.
ಪೇಜ್ ನಂಬರ್ 24 ನಲ್ಲಿ ಅವ್ರ ಹಾಕಿರೋ CC ಎಲ್ಲ ಇದೆ.
ಅವ್ರ ಹಾಕಿರೋ CC ಬಿಟ್ಬಿಡ್ರಿ, ಈಗಿನ ಅಡ್ರೆಸ್ ಹುಡುಕಿ.
ಈಗಿನ ಅಡ್ರೆಸ್ ಬಂದ್ಬಿಟ್ಟು ಈಸ್ ಮೈ ಸನ್ ಇನ್ ಲಾ ಮೇಲೆ. ನನ್ನ ಅಳಿಯ ಅವನು.
ಈಗೆಲ್ಲ ಅವನ ಗೊತ್ತಿರುತ್ತಲ್ಲ ಅಡ್ರೆಸ್.
ಅಮ್ಮನೆ ಹತ್ರನೇ ಕೇರಳದಲ್ಲಿ ಇರೋದ್ ಮೇಲೆ. ಇಬ್ರು ಕೇರಳ ರೆಸಿಡೆನ್ಸ್ ಆಫ್ ಕೇರಳ ಮೇಲೆ. ಅವ್ರ ಅಡ್ರೆಸ್ ಸುಮ್ನೆ ಡ್ರಾಗ್ ಮಾಡೋದಕ್ಕೆ ಮೈಸೂರಲ್ಲಿ ಬಂದ್ ಕೇಸ್ ಹಾಕೊಂಡು ಇದ್ ಮಾಡ್ತಾ ಇರೋದ್ ಮೇಲೆ.
ಅದ್ ಬಿಟ್ಬಿಡಿ, ಸರ್ವಿಸ್ ನೋ ಸಚ್ ಪರ್ಸನ್ ಇನ್ ದಿಸ್ ಡೋರ್ ನಂಬರ್ ಅಂತ ಕಳ್ಸವ್ರೆ.
ಅವ್ರು ಹಾಕಿರೋ ಪಿಟಿಷನ್ ಇರೋ ಅಡ್ರೆಸ್ ನಾನ್ ಹಾಕಿದೀನಿ, ಆದ್ರೆ ಇದ್ರಲ್ಲಿರೋ ಅಡ್ರೆಸ್ ಚೇಂಜ್ ಮಾಡಿದ್ರೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಆಗುತ್ತೆ ಅಂತ ನಾನು ಮಾಡಿಲ್ಲ. ಮೇಲೆ ಹೊಸ ಅಡ್ರೆಸ್ ತಗೊಳ್ತೀನಿ.
ಹೊಸ ಅಡ್ರೆಸ್ ತಗೊಳ್ಳಿ ಅಂತಲೇ ನಾನು ಹೇಳ್ತಾ ಇರೋದು. ಅಸರ್ಟೈನ್ ದಿ ಕರೆಕ್ಟ್ ಅಡ್ರೆಸ್ ಅಂಡ್ ಟೇಕ್ ಸ್ಟೆಪ್ಸ್ ಅಂತ ತಗೊಳ್ಳಿ. ಕೌನ್ಸಿಲ್ 6 weeks ಟೈಮ್ 2 ವಾರ ಬೇಕಾ?
ನಾನು ಅವ್ರನ್ನ ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡ್ಬೇಕು, ಯಾಕಂದ್ರೆ ಕೇರಳದು.
ನೀವ್ ಹೇಳ್ರಿ ಎಷ್ಟು ದಿವಸ ಬೇಕು ಅಂತ.
2 weeks ಮೇಲೆ.
2 ವಾರ. Petitioner counsel seeks 2 weeks time to ascertain the correct address and take press steps against the respondent and hence 2 weeks time granted. List this matter on date ಕೊಡಿ ಮೇಡಮ್.
23/1.
23/1.
28 ಗೋವಿಂದರಾಜ್ ಕೇಜೋ.
Await service.
For the petitioner in this case, madam.
ಏನಾಯ್ತು?
Notice serve ಆಗಿದೆ.
Delivered ಅಂತಲ್ಲ.
ಸರ್ವ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
Notice is delivered.
Advocate ಗುನು ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ.
Track. And hence held sufficient. ಏನಾಗ್ಬೇಕು? ಡಿಲೇ ಇದೆಯಾ?
ಡಿಲೇ ಇದೆ ಸ್ವಾಮಿ.
303 days ಇದೆ.
ಹೌದು ಸ್ವಾಮಿ. ಅವರು ಪೋಸ್ಟಲ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಿದ್ರು. ರಿಟೈರ್ಡ್ ಆದ್ಮೇಲೆ ಅವರು ಗದಗದಲ್ಲಿ ಅವರು ನೇಟಿವ್ ಅಲ್ಲಿ ರಿಸೈಡ್ ಮಾಡ್ತಿದ್ರು.
ಯಾವಾಗ ಡೆಲಿವರಿ ಆಗಿ ನೋಡೋಣ ಬರ್ತಾರೇನ ಅವರು?
ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲೂ ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ.
IA 1 of 24 is kept pending. However, IA 2 of 24 is considered and sentence is suspended subject to depositing of 50% of amount inclusive of the amount already been deposited before the trial court or appellate court.
And also paid last month 50,000 deposit.
The amount within 4 weeks from today.
ಅವ್ರಿಗೆ
ಎಷ್ಟಿದೆ ಅಮೌಂಟ್?
1,60,000.
ಆಯ್ತು. Directed to execute a bond for rupees 50,000 with 1 surety before the trial court.
ಅದ್ರಲ್ಲಿ 50,000 ಅವ್ರಿಗೆ ಕ್ಯಾಶ್ ಆಗಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ ಪಾರ್ಟಿಗೆ. ಕಂಪ್ಲೇನೆಂಟ್ ಗೆ 50,000 ಕೊಟ್ಟಿದ್ದೀನಿ ಅಪಾರ್ಟ್ ಫ್ರಮ್ ಡೆಪಾಸಿಟಿಂಗ್.
ಕೊಟ್ರೆ ದಾಖಲೆ ಇರುತ್ತಲ್ಲ,
ಹೌದು ಅದು ದಾಖಲೆ ಇದೆ, ಅದು 50% ಅದನ್ನು ಪ್ಲೀಸ್.
ದಾಖಲೆ ಹಾಕಿ ನೋಡೋಣ.
ಆಯ್ತು.
29.
Petition, my lord.
Petition copy,
yes.
emergent notice to the respondent. PF ಕೊಡ್ಲಿಲ್ವಾ?
ಇವತ್ತು ಕೊಟ್ಟಿದ್ದೀನಿ sir. ಇವತ್ತು ಕೊಟ್ಟಿದ್ದೀನಿ.
ಇವತ್ತು ಯಾಕೆ ಕೊಟ್ರಿ? ಸೆಂಟೆನ್ಸ್ ಸಸ್ಪೆಂಡ್ ಆಗಿದೆ ಇಲ್ಲ?
ಇಲ್ಲ, ಇದು DV Act ಇದೆ.
ಏನ್ DV Act?
interim order ಏನಿಲ್ಲ
He has paid the PF today and hence issue emergent notice as ordered earlier.
Hearing on IA 30.
483 days in filing. Issue notice on IA number 1/21 and also on main against the respondent.
31.
47 days delay. Issue notice on IA number 1/24 and also on main.
32. SPP.
Issue notice on IA 1/23 and also on main.
serial number 31 ಅಲ್ಲಿ ಆಲ್ರೆಡಿ ಇದೆ.
31 ಆಗೋಯ್ತಲ್ಲ?
ಅಪೇರ್ಡ್ ಸರ್.
ಹಾ?
ಅಪೇರ್ ಆಗಿದ್ದಾರೆ ಸರ್.
ಯಾರು ಅಪೇರ್ ಆಗಿದ್ದಾರೆ?
ರೆಸ್ಪಾಂಡೆಂಟ್ ಸರ್.
ಅಪೇರ್ ಆಗಿದಾರೇನ್ರಿ? ಯಾರು ಇದೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು? SPP for R1, Tejas
R2.
R2. ಹೇಳ್ರಿ, ಏನ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ಐಎಗೆ? 47 days ಡಿಲೇಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡದಲ್ಲೇ ನಿಮ್ಗೆ ವಕಾಲತ್ ಹಾಕಿದ್ರಾ?
ಹಾಕಿದ್ದಾರೆ ಸರ್ ನೋಟಿಸ್ ಎಲ್ಲ.
ನೋಟಿಸ್ ಬರ್ದಲ್ಲ ಹೆಂಗ್ರಿ ವಕಾಲತ್ ಹಾಕಿದ್ರಿ? ಕಾಪಿ ಎಲ್ಲ ಕೊಟ್ಟಿರ್ತಾರ ನೋಡಿ. ಡಿಲೇ heard on IA number 1/24 and there is a delay of 47 days in filing the revision petition and for the reasons stated in the accompanying application and approved delay of 47 days is condoned. ಏನ್ ಮ್ಯಾಟ್ರ್ ಏನ್ರಿ ಇದು?
Offense under 506 ಕಂಪ್ಲೇನೆಂಟ್ ಅಪೀಲ್ ರಿವಿಷನ್.
ಕಂಪ್ಲೇನೆಂಟ್ ರಿವಿಷನ್ ಇದು?
506 both the courts are acquitted.
ಅಕ್ವಿಟ್ ಮಾಡಿದ್ರ ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಬೋದಿದ್ದೀರಾ?
ಹೌದು.
ಆಯ್ತು, ಲಿಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಫಾರ್ ಅಡ್ಮಿಷನ್ ಆನ್ 21.
21 25
20 ಬೇಡವಾ?
20
ಹಾ
20 21 ಎರಡು ದಿನ
20 21 ಬೇಡ, ಮುಂಚೆನೆ ಕೊಡಿ. 17 17th ಆಗ್ಬೋದಾ?
ಆಗ್ಬೋದು
ಅಥವಾ 22nd ಆಗ್ಬೋದಾ?
22nd.
22 1. ಓಕೆ.
32. SPP.
32 SPP ಏನ್ರಿ ಇದು ಡಿಲೇ? Issue notice against the respondent on IA and also on main. Mahesh CM. Extension of time filed by the petitioner counsel. ಏನ್ರಿ ಅದು extension of time?
On
Shamanna
21/2/2024, this honorable court has granted an interim order.
On what date?
21/2/2024.
21/2/24.
ಅಲ್ಲಿ 30% deposit ಮಾಡಿ ಅಂದ್ರು. It amounts to 6 crores above, my lord.
Within 4 weeks.
ಸ್ವಲ್ಪ ಅದಕ್ಕೆ 6 crores.
ಯಾವ ಕ್ರೋರ್ಸ್ ಆದ್ರೂ ಅಷ್ಟೇ. 21/2 ಆರ್ಡರ್ ಆಗಿರೋದು. ಈಗ ಆಲ್ರೆಡಿ 11 ತಿಂಗಳಾಯ್ತು. 11 ತಿಂಗಳಾಯ್ತು. ನೋ ಎಕ್ಸ್ಟೆನ್ಷನ್.
ಶಾರ್ಟ್ ಓನ್ಲಿ.
ಈಗ ಹೋಗ್ಲಿ, ಎಷ್ಟು ಕಟ್ಟಿದಿರಿ ಹೇಳಿ?
ಇಲ್ಲ ಕಟ್ಟಿಲ್ಲ, ಅದಕ್ಕೆ
ಒಂದ್ ಪೈಸಾನು ಕಟ್ಟಿಲ್ಲ.
ಪರ್ಮಿಷನ್ ಕೊಟ್ರೆ ಮಾತ್ರ ಅಲ್ಲಿ ತಗೋತಾ ಇದ್ದಾರೆ, ಇಲ್ಲ ಅಂದ್ರೆ ತಗೋತಾ ಇಲ್ಲ.
ವೆಕೇಟೆಡ್.
ಸ್ವಾಮಿ ಇಲ್ಲಿ ಪರ್ಮಿಷನ್ ಕೊಟ್ರೆ ಮಾತ್ರ ಅಲ್ಲಿ ತಗೋತಿದ್ದಾರೆ.
IA is rejected and vacated. ಮತ್ತೆ 11 ತಿಂಗಳು ಮಲ್ಕೋಬಿಟ್ಟು ಈಗ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡ್ರೆ 28/12 ಟೈಮ್ ಕೊಟ್ಟಿದ್ದು ಎಷ್ಟು ದಿವಸ ನಿಮಗೆ?
4 weeks ಕೊಟ್ಟಿದ್ರಿ. 4 weeks
6 weeks in February.
Correct.
You have filed an application in 2012.
Correct.
24.
I do agree, my lord, but ಅದು 6 lakhs above ಇರೋದು ಸ್ವಲ್ಪ ಅಮೌಂಟ್ ಅಡ್ಜಸ್ಟ್ ಮಾಡಕ್ಕೆ ಟೈಮ್ ಬೇಕಾಯ್ತು. ಈಗ ರೆಡಿ ಆಗಿದೆ.
IA number 1/24 for extension of time filed by the petitioner counsel. And this court passed an order on ಹೇಳಿಲ್ವಾ ನೀವು? On 21/24 to pay the 30% of the amount while suspending the sentence within 4 weeks. And the same is not complied, but the application is filed in the month of December. Expressing difficulty in making of the payment, except the said reason, no other reasons are stated, and hence no reasons to extend any time, since the very application is belated and the same is filed almost up to 10 months. And the order also passed in the month of February, and no attempt is made to file such an application immediately after the expiry of 4 weeks from the date of order. And hence no reasons are made out, and hence the order suspending the sentence is hereby recalled.
For the respondent. ಅಮೌಂಟ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿರೋದು ರಿಲೀಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅರ್ಜಿ ಹಾಕಿದ್ದೇವೆ ಸ್ವಾಮಿ ಅವರ.
ಕಳ್ಳಿ ಪಾಸ್ವರ್ಡ್
ರಿಲೀಸ್ ಹಾಕಿರೋದ್ರಿ
ಹೌದು ಸ್ವಾಮಿ, ಹೌದು ಸ್ವಾಮಿ.
ಡೆಪಾಸಿಟ್
Release, ಅದನ್ನು
ರಿಲೀಸ್ಗೆ
release
ಪಾಸ್ ಅವರು
35.
ರಿಲೀಸ್ ಆಫ್ ಅಮೌಂಟ್ ಫೈಲ್ಡ್ ಬೈ ದಿ ಕೌನ್ಸಿಲ್ ಇದು ಅಷ್ಟೇನೆ. ಹ್ಮ್
application for release of
ಹ್ಮ್
93,000 was deposited in the trial court.
ಎಷ್ಟು ಡೆಪಾಸಿಟ್ ಮಾಡಿದಾರ?
93,000.
93,000. ಹಾ ಹೇಳ್ರಿ, ಏನ್ ತಕರಾರು ನಿಮ್ಗೆ?
93,600.
ತಕರಾರು ಏನಿಲ್ಲ, ತಗೊಳ್ಳಿ. Heard the respondent counsel and also the counsel appearing with the petitioner on A number 3 of 24 and this court and in amount of rupees 93,000.
93,600.
93,600. 600 is deposited before the trial court in pursuance of the order passed by this court.
Yes.
Houda? And seeks for release of the amount and counsel for the petitioner also says no objection to release the amount. And hence,
ಅದರಲ್ಲಿ 50% ಮಾಡಿದ್ರೆ ಒಳ್ಳೇದಿರುತ್ತೆ.
okay?
ಇನ್ ಕೇಸ್ ಟುಮಾರೋ
ಮಾಡಿರೋದೇ 50% ಅಲ್ವಾ?
50
ಒಂದು 97, 87 ಅರ್ಧ ಕಟ್ಟಿದೆ ಅಷ್ಟೇ. ಹಾ. And hence directed to release the amount on proper identification in favor of the respondent. ಹಾ.
ಪ್ಲೀಸ್.
35, 36.
ನಾಗರಾಜ್ ಹೆಗ್ಡೆ. Delay of 34 days in filing. Appear ಆಗಿಲ್ಲಲ್ಲ? Issue notice against the respondent on IAS and also on main.
37. Girish Balagam.
Production of certified copy of the trial court judgment. ಹಾ ಏನಾಯ್ತ್ರಿ?
Dispense ಕೇಳ್ತಾರೆ.
ಹಾ?
Dispense ಕೇಳ್ತಾರೆ.
ಡಿಸ್ಪೆನ್ಸ್ ಗ ಏಕೆ?
Certified copy misplace ಆಗಿದೆ. And it is a
ಯಾವ್ದು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ನೀವು ಕೇಳ್ತೀರಿ?
CC certified copy.
ಸಿಸಿದು
CC.
ಅಪೀಲ್ ಕಾಪಿ ಹಾಕಿದೀರಾ?
Appeal copy ಹಾಕಿದ್ದೀನಿ.
ಆಯ್ತು. IAS
Convicted for the offense punishment under section 324 for the period of 6 months, my lord.
ಹ್ಮ್
There is a dispute between the adjacent landowners with regard to the usage of the road.
ಹ್ಮ್
In that event, spur of the moment incident has been taken place.
ಏನು ಹೊಸದಾಗಿ ಅಪ್ಲೈ ಮಾಡಿದಿರಾ ಏನು
ಇಲ್ಲ ಹೊಸದಾಗಿ ಅಪ್ಲೈ ಮಾಡಿದ್ವಿ sir.
ಮಾಡಿದಿರಾ?
Seeking for suspension of sentence and bail. And he was in bail. They, all the petitioners are bail throughout the
Heard
trial.
on A
and
number 2 of 24 for dispensation of production of certified copy of the trial court judgment. In CC number 219 up to 14 and the reason stated in the ಅಲ್ಲ ರೀ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನೀವು ಈಗ ರಿವಿಷನ್ ಅಲ್ಲ ಅಪೀಲ್ ಹಾಕ್ಬೇಕಾರೆ ಅಲ್ಲಿ ಇರುತ್ತಲ್ಲ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಅಲ್ಲಿ ತಗೊಂಡಿದ್ರೆ ಇಲ್ಲ ವಾಪಸ್
ಅಲ್ಲಿ ತಗೊಂಡಿಲ್ಲ ಸರ್ ವಾಪಸ್ ಆಗಿ ಮತ್ತೆ ಅಪ್ಲೈ ಮಾಡಿದಲ್ಲಿ ಸಿಕ್ಕಿತ್ತು ಎಲ್ಲ ಮಿಸ್ಪ್ಲೇಸ್ ಆಗಿದೆ.
ಕಳೆದೋಗಿದೆ ಅಂತ ಹೆಂಗ್ ಹೇಳ್ತೀರಿ?
ನನ್ನ ಹತ್ರ ಸಿಕ್ಕಿತ್ತು.
And the same is misplaced and applied for certified copy and hence the same is dispensed for a period of 4 weeks.
Suspension of sentence.
ಹೇಳಿ ಏನು?
The convicted for the offense punishment under section 324, 323, 147 and
ಫೈನ್ ಅಮೌಂಟ್ ಎಲ್ಲ ಕಟ್ಟಿದ್ದೀರಾ?
ಎಲ್ಲ ಕಟ್ಟಿದ್ವಿ.
ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ
ಫೈನ್ ಇಂಪೋಸ್ ಮಾಡಿಲ್ಲ ಸರ್.
ಫೈನ್ ಇಂಪೋಸ್ ಮಾಡಿಲ್ಲ ಮತ್ತೇನ್ ಮಾಡಿದ್ದಾರೆ?
Which is in page number 58, my lord. The convicted for the offense punishment under section 326 for the period of
sentenced to undergo simple imprisonment
yes, my lord.
for 2 months.
2 months for the other offenses and
1 month.
6 months for the
3 months. 1 month. Maximum is 3 months.
6 months.
6 months for 324.
Yes, my lord.
ಯಾವ್ದ್ರಲ್ಲಿ ಫೈನ್ ಹಾಕಿಲ್ವಾ?
Fine ಹಾಕಿಲ್ಲ.
ಯಾವ್ದ್ರಲ್ಲಿ ಫೈನ್ ಹಾಕಿಲ್ಲ? ಆಯ್ತು. Heard at the revision petitioner counsel and challenge is made against the conviction and dismissal of the appeal and having considered the grounds urged in the revision petition, matter requires for consideration and hence the sentence is suspended subject to executing a bond for rupees 50,000 with one surety before the trial court within 4 weeks. Call for records and list the matter for admission on 10th of February. ತಗೊಂಡಿಲ್ಲ ಅವ್ರ ನೋಟಿಸ್. HCGP is directed to take notice.
Parted in admission 38.
MFA Shashikant Abhishek.
And appeal filed with the ESI. For the period 19.
ಮೊನ್ನೆ ಹಿಯರ್ ಮಾಡಿದ್ವಲ್ಲ ಅದೇ ಅಲ್ಲ ಇದು?
ಸ್ವಲ್ಪ ಮಾಡಿದ್ರೆ ಅದು original application is barred by limitation. There is no provision for continuation of delay. Under wrong provisions applications was filed and it was allowed. It is barred by limitation. That point I want to urge in the beginning.
No condemnation can be done anta.
Please, my lord, it is like original suit, original application. Kindly see, my lord, under ESI Act, under various provisions, various limitations are prescribed. And in some provisions, continuation of delay is also permitted. But under this provision, limitation is prescribed and no continuation of delay provision is provided. Your lordship is aware under section 29 of the Limitation Act, if there is a special enactment and special limitation is fixed, Limitation Act section Section 5 is not applicable. My lord, what has happened is, he has given sickness benefits for nearly 2 years. My lord, thereafter, he applied for extended benefit of sickness benefit from 19/10/2007 to 21/8/2008, around 10 months. My lord, it was not given. He approached the ESI court for grant of sickness benefit for this period. Kindly see, my lord. Application.
That is allowed and also review petition also dismissed.
Correct. My lord, application is filed under, my lord, continuation of delay application is filed under Rule 20B, which is not applicable, read with section 78 of the ESI Act, read with section 5 of the Limitation Act. My lord, kindly see the application copy, my lord.
Records ಬಂದಿಲ್ಲ ಮೇಡಮ್? ರೆಕಾರ್ಡ್ಸ್ ಇದೆಯಲ್ಲ?
Please. ನಮ್ಮ ಕೈ ಧೂಳ್ ಮಾಡ್ಕೊಳ್ಳೋದು ಬೇಡ ಅಂತ ನಾನು
ಹೇಳಿ.
Kindly see, my lord, this is application filed under 20B.
ESI rules ಕೊಡಿ ಮೇಡಮ್. ESI rules 20B. 20B of the ESI rules. Read with section 78 of the ESI Act.
My lord, this is original application is filed under section 75(1)(e) and G. Kindly see, my lord. See the provision, section
75(1)(e) and G.
75(1)(e) and G. For non-grant of sickness benefit, he approached, this is the
Yes,
correct
Act.
provision. Section 75. May I read, Mala? Section 75. Matters to be decided by Employees Insurance Court. If any question or dispute arises as to whether any person is an employee, etc., then come to E, Mala. The right of any person to any benefit and as to the amount and duration thereof. And G. Any other matter which is in dispute between the principal employer and the corporation, etc. This is the correct provision under which he has approached. Then kindly come to section 77. Please, ma'am. The proceedings before an employees insurance court shall commence, shall be commenced by application. Every such application shall be made within a period of 3 years from the date on which the cause of action arose. But this is the period of limitation. Therefore, kindly, my lord, there is no condonation of delay provision under section 77. Then, my lord, kindly see, I will show similar other provisions. Section 78 of the ESI Act.
Powers of Employees Insurance Court.
Please, my lord, please come to section 82. My lord, for this limitation is prescribed, condonation power is prescribed. Save as expressly provided in this section, no appeal shall lie from an order of the Employees Insurance Court. An appeal shall lie to the High Court from an order of the Employees Insurance Court if it involves a substantial question of law. The period of limitation for an appeal under this section shall be 60 days. The provisions of section 5 and 12 of the Limitation Act shall apply to appeals under this section. Like this, my lord,
Matra.
appealing matra.
Hmm.
Like this, for under various sections, limitation is prescribed and provision for continuation of delay is also prescribed. Wherein under section 77, limitation is prescribed and there is no continuation of delay provision at all.
Hmm.
Therefore, my lord, the various courts have come to the conclusion that this delay cannot be condoned.
Hmm.
Kindly come to Rule 20B of the ESI rules. Central rule. May I read, Mala?
1 second. 20.
Mala, this is employee ESI central rules.
1950 rules or ಯಾವ rules?
1950 central rules.
1950.
Yes, 20 capital B.
20B.
Yes, the insured person.
Appeals to employees insurance court ಅಂತಿದೆ.
Correct, correct.
Ah.
The insured person or the corporation may appeal to the employees insurance court by presenting an application within 3 months from the date of communication of the decision of the medical board and medical appeal tribunal to the insured person or the corporation as the case may be, provided that the ESI court may entertain an application after the period of 3 months if it is satisfied that the applicant has sufficient reasons for not presenting application within the said period. Well, and here also limitation can be condoned under this section.
Hmm.
Then kindly come to the application for continuation of delay, a copy of which is handed over to my lord just now.
Hmm.
Kindly see, my lord, is filed under section 75(1)(e). Let us see. Sorry, I am sorry.
Hmm.
No, not that. Is filed under section 20B of the ESI rules. Continuation of delay application is filed under 20B of the ESI rules.
Yes.
Just now I read this is not applicable for section 77 at all. Then section 78 of the ESI Act. Let us see section 78 whether it is applicable. This also I have read. This is powers of employees insurance court. The employees insurance court shall have all the powers of the civil court for the purpose of summoning, enforcing attendance of witnesses, compelling discovery, production of documents, material objects, administrating oath, etc., etc. The employees insurance court shall follow such procedure as may be prescribed by rules made by the state government. All costs incidental to the proceedings before the employees insurance court shall subject to the rules as may be made in this behalf by the state government in the discretion of the court. An order of the employees insurance court shall be enforceable as if it were a decree passed by the passed in a suit by a civil court. There is no provision at all for continuation of delay. Then section 5 of the Limitation Act. But section 5 of the Limitation Act is not applicable because of section 29 of the Limitation Act, which says if there is a special enactment and if there is a special provision for limitation and condonation, such applications are governed by special statute and not the section 5 of the Limitation Act.
Hmm.
May I read section 29, Mala?
Hmm.
Please.
Section 29 of
Limitation Act.
Hmm.
Under this provision, Mala, various courts have rendered judgment saying that this is not applicable for ESI Act. Mala, section 29. Nothing in this act shall affect section 25 of the Indian Contract Act, etc., where any special or local law prescribes for any suit, appeal, or application a period of limitation different from the period prescribed by the schedule. The provisions of section 3 shall apply as if such period were the period prescribed by the schedule and for the purpose of determining any period of limitation prescribed for any suit, appeal, or application, by any special or local law, the provisions contained in section 4 and 24 shall apply only insofar as and to the extent to which they are not expressly excluded by such special or local law. Therefore, my lord, Limitation Act section 5 is not applicable. Kindly see, my lord, say, the continuation of delay application, page 2, para 6, last line. However, the matter was never referred to the medical board and monetary benefits from 1910-2007 to 21/8/2008 was stopped. Therefore, the limitation has started on 21/8/2008. Within that date, within 3 years, he should have presented, wherein in this case, he has presented the application after 5 years. Then, my lord, kindly come to page number, para number 7, last line. However, the matter was never referred to medical board. Again, the same sentence is repeated. My lord, then para 8, last line. However, the period in question, that is from 1910-2007 to 21/8/2008 was not paid and remains to be unpaid to this day. Therefore, my lord, the cause of action at the most can be said to be have commenced on 21/8/2008. Kindly see the date of the application in the bottom of the same page, 26/9/2013. That means nearly after 5 years after the cause of action, he has filed this application. Thereafter, my lord, kindly see the reasoning given by the trial judge regarding continuation of delay. My lord, kindly take my appeal memo. My lord, kindly come to page number 24. Ink page number 24. That is internal page 14 of the impugned order. Kindly come to line 4, last word, he was suffering from the illness, and it is argued that, may I read, Mala? Last word of the 4th line, he. Internal page 14 of the impugned order. 4th line, last word, he. One.
He ಇಲ್ವೇ ಇಲ್ಲಿ?
Well, it's
ESI court order only. 14.
Yes.
Ink page 24.
24. Please, Milad. Second line, last word, but not. Second line, last 2 words, but not. Milad, I will start from the first line itself. Letter from the medical board. Please, Milad. Letter from the medical board that he may call from medical board for medical examination but not received any letter. And again, he approached the ESI authorities to refer the matter to medical board. He was suffering from illness, and it is argued that nobody to take care of him, and he is having only one son. Well, this is also false. Now his LRs are on record, and there are 2 sons and a daughter. He is having only one son who is studying. His wife is illiterate. The efforts put by him from 2006 to 2009 clearly discloses that he made sincere efforts to get the certified sickness certificate, but his efforts went in vain. His old age person, aged about 61 years, suffering from various ailments, may not have been possible to approach the court of law in time, maybe because of his difficulties. The learned counsel for the applicant has quoted the citation with regard to law of limitation reported in so and so, wherein their lordship incited case Puttayamma so and so in the head note held that ESI Act 1948 Section 52 and 77(1), appellant's husband died while on duty. Claim petition rejected on account of delay of 12 years. Act a beneficial and social legislation held application to be restored and disposed of on merits. Therefore, their lordship have held that he should bear in top of its mind that social justice is our constitutional scheme, and as such, duty is cast on it to act fairly, justly, further liberally, so that the courts act is always involved to impact social justice to the parties before it. The sacred word social justice mentioned in the preamble of the Constitution, which is mother of all laws. Therefore, in the light of the above decision and also reasons mentioned above, the court is court of the view that the application is not barred by time in the context of social justice to the parties, and the applicant is beneficiary workman when he suffered sickness injuries during the course of employment. Therefore, the above decision, the delay in filing application is hereby condoned. Kindly similarly, in this paragraph, what is the period of limitation is not mentioned. 3 years, that is not mentioned. When the application was presented is not mentioned. What reason is given for delay is not mentioned. Melod, for which the ESI Corporation has filed objection stating that whatever he has stated was prior to 1998 and not subsequent to that, covering the period of limitation. Therefore, Melod, the application before the court below. Kindly see, Melod, the date of application, copy of which. Well, continuation of delay application is dated 27/9/2013. That means it was presented nearly after 5 years. But this is covered by various decisions of our High Court and other High Courts. I will cite which. Provisions are also discussed. My lord, the two judgments of our Honorable High Court, my lord, kindly see. This is ILR 2001 Karnataka 5674. Copy ಕೊಟ್ಟಿದ್ದೀನಿ. My lord, the first page. This appeal and cross objections arise out of the order passed by the ESI court dated 5/9/88, dismissing the application filed under section 75 of the ESI Act as barred by limitation. My lord, in this case, it was barred by limitation. Para 2, the ESI Corporation called upon measure so and so to pay the contribution for the period 82-83 by demand letter dated 11/7/84 to pay rupees 5,722.13 paisa. Since contribution amount was not paid, an order under section 45A was passed dated 28/9/84. The management, having kept quiet for a period of 6 years, filed an application under section 75 of the ESI Act on 17/8/1990, questioning the order passed by the ESI court. The ESI court considered the provisions of section 77, which I have read just now, held that the application is barred by limitation and accordingly dismissed. Kindly come to para 4. On the other hand, Lieutenant Counsel Shri M. Papanna, relying on the provisions of section 77(1)(a) of the ESI Act, contended to initiate the proceedings before the ESI court. The period of limitation prescribed is 3 years. In this case, the proceedings under section 75 of the ESI Act were initiated nearly after 6 years. Therefore, ESI court has rightly dismissed the application and the impugned order does not suffer from any infirmities. Accordingly, prayed for dismissal of the appeal. The point for consideration arises is whether the impugned order of the ESI court dismissing the application filed under section 75 of the ESI Act does suffer from any infirmities as such. Kindly come to next page, Mela. That is starts with section 8. Section 77(1)(a) of the ESA Act thus reads, the commencement of the proceedings. The proceedings before the Employees Insurance Court shall be commenced by application. Every such application shall be made within period of 3 years from the date on which the cause of action arose. A reading of Section 77(1)(a) of the ESA Act that any proceedings initiated before ESA Court either under Section 71 of the ESA Act or any other provision after a period of limitation of 3 years from the date of cause of action accrued is liable to be dismissed. In the present case, it is not in dispute that the cause of action has arisen on 29/8/84, on which day an order under Section 45(a) of the Act came to be passed. Whereas the appellant, having not diligent in the matter, approached the ESA Court with an application under Section 75 of the ESA Act on 17/8/1990, which is on the face of record is barred by limitation. Then section para 11, when the ESA Court has recorded the finding that the application itself is barred by limitation, the court further examining the matter on merits was unnecessary. Then another judgment of our High Court, my lord, ILR 2009 Karnataka 1194, madam. Para 8 ink page, print page 1199 of the decision. Para 8. In the light of the above submission, the points that arise for consideration in this appeal are whether the application filed by the respondent before the ESA Court was barred by period of limitation provided under Section 77(1)(a) of the ESA Act. Then come to print page number 1203, madam. In the middle, there are certain lines in italics thereafter. The ESA Act is a special act. May I read, Mala?
Yes.
The ESA Act is a special act. Therefore, the period of limitation provided under Section 77(1)(a) of the ESA Act will have to be treated as period of limitation provided under the Limitation Act, and Section 3 of the Limitation Act is applicable. In other words, if an application under Section 75(1)(g) of the ESA Act is filed beyond the period of 3 years from the date on which the cause of action arose, such application will have to be rejected as barred by limitation. Look, there are other judgments of other high courts. I will read.
Num judgment irodrinda matte bere judgment.
There is a special reference to other provisions, namely where the limitation is provided is set, but whether that can be condoned or not is also treated by court of High Court of Kerala and High Court of Orissa in very detail. A few paragraphs I will read, man. And relying on Kerala High Court judgment reported in Laws 2016-400. Tripenta Hotels case, my lord. Kindly come to first para of the judgment, my lord, after the judge's name. The basic point mooted as substantial question of law. Among other questions raised is whether Limitation Act, particularly Section 5, is applicable to a proceedings filed before the Employees Insurance Court, and whether the EI Court has power to condone the delay beyond the specified extent under the relevant provision, that is Section 77(1)(a) of the Employees State Insurance Act, even if the explanation is offered is satisfactory. Then arguments are, I will read two paragraphs, my lord. Thereafter court concurred with the argument of the ESA Council. Kindly come to para 9, my lord. The crux of submission made by the learned counsel for the appellant is that the EI Court is a court in all respects by virtue of the scheme of statute and is having all trappings of the civil court with regard to the duties to be performed. A reference is made to Section 74 to 83 of the ESA Act, aiding that the work by virtue of section 75(3), jurisdiction of the civil court stands barred. By virtue of section 78(4), the order passed by the EI court is as of a decree of a civil court, and as such, section 5 of the Limitation Act is applicable to the EA court as applicable to any other court. Then come to para 10. So and so learned counsel appearing for the respondent corporation submits that the idea of understanding of the appellant with regard to the scope of section 5 of the Limitation Act and its applicability to the proceedings before the EA court is thoroughly wrong and misconceived. It is asserted that the Limitation Act is not applicable to the proceedings before the EA court, as the ESI court is a special statute and being self-contained court. It confers right upon the parties to the extent as specified in the statute, which cannot be stretched beyond the written limits. There is a specific purpose as well in stipulating time for approaching the EA court, beyond which it is not possible to be condoned unless it is specifically provided. Section 29(2) of the Limitation Act is stated as not applicable to the case in hand, as it is an express exclusion of the Limitation Act insofar as the proceedings before the EA court are concerned by necessary implication. In view of the different course and procedure and extent of rights separately mentioned of the proceedings before the EA court and for an appeal before the High Court in terms of section 77 and 82 respectively of the Act, it is contended that the respondent corporation that the EA court, though named as court in the statute, is actually not a civil court to be governed by the provisions of the Limitation Act. Reliance is sought to be placed on the verdicts of the apex court and this court in this regard. Thereafter, various judgments of apex court and other courts are quoted. Then kindly come to para 18. May I read, Mala? Para 18. Yes. By virtue of law declared by the Supreme Court in Consolidated Engineering so and so reported in so and so, this court cannot but hold that the provisions of the Limitation Act as such are not applicable to the proceedings before the EA court. Then the question only whether section 29(2) of the Limitation Act, even if held as applicable, would save the proceedings. The provision reads as follows: section 29 of the Limitation Act, which I have read just now. Then kindly come to para 19, last line. Para 19, last line. Insofar as the special statute clearly specifies the time limit or maximum extent of delay which can be condoned by the concerned authority court, it cannot be simply given a go-by, contrary to the intention of the lawmakers and the scheme of the statute. Then my lord, para 21, in the middle, my lord, section 77 is read, wherein, my lord, the ESI Act prescribes 3 years limitation in para 21. Then come to para 22, last but one. Para 22, man. Coming to the right of appeal under section 82, the lawmakers consciously added subsection 4 to section 82, making it clear that section 5 and section 12 of the Limitation Act would be applicable to such appeal. In other words, the lawmakers consciously avoided usage of such expression like subsection 4 when the proceedings are to be pursued before the EA court. This conspicuous difference in the usage of terminology in the provisions, that is between section 77 and section 82, is a clear indicator as to the exclusion of provisions of Limitation Act to the proceedings before EA court by way of necessary implication. Well, it has come to the conclusion that this is a special enactment, therefore, limitation prescribed herein will have to be followed. Orissa High Court, in a judgment of 2009, let's say para 5, of Orissa High Court judgment. May I read, Mala? On the rival contentions of the learned counsel for the parties, the question that falls for consideration by this court is whether EAE court is justified to reject the application of the appellant on the ground of limitation. Thereafter, my lord, in para 6, section 77 is read just now. My lord, after para section 77, a plain reading of the above section makes it amply clear that the proceedings before an EAE court shall be commenced by an application filed within a period of 3 years from the date on which cause of action arose. My lord, then come to para 7. This is the conclusion. Para 7. Apart from the above, another important aspect of the case is as to whether any power is vested in EAE court to condone the delay in presenting the application under section 77 of the ESA Act. A plain reading of section 77 of the ESA Act does not show that such power is vested in EAE court. It may be relevant to mention here that while subsection 4 of section 82 contains the provision for condonation of delay in presenting the appeal before the High Court, no such power is vested in the EAE court to condone the delay in presenting the application before under section 77 of the ESA Act before it. Now the question arises whether in the absence of such a power the EAE court can condone the delay in presenting the application under section 77 of the ESA Act after the expiry of 3 years from the date on which the cause of action arose. In this context, it would be appropriate to refer to the judgment of Honorable Supreme Court in so and so. While considering the provisions of so and so, Apex Court has held the provision of subsection 1 of section 35 makes the position crystal clear that the appellate authority has no power to allow the appeal to be presented beyond the period of 30 days. My lord, comparison is drawn, but the conclusion is this is a special enactment. And therefore, limitation cannot be condoned. But Calcutta High Court in 2003 judgment first paragraph. The petitioner herein filed an application under section 5 of the Limitation Act in the Employees Insurance Court, West Bengal, for condonation of delay in filing the case before the said court. The learned judge of the said Employees Insurance Court rejected the said application filed on behalf of the petitioners on the ground that the application under section 5 of the Limitation Act is not applicable to any proceedings before the ESI court. The petitioners have challenged the aforesaid decision of the learned judge of the Employees Insurance Court in the present writ petition. Then, let's kindly come to para 13. The petitioners herein thereafter filed an application under section 75 of the said act before the Employees Insurance Court, West Bengal, being numbered as so and so, raising aforesaid disputes. The said application under section 75 of the ESI Act was, however, not filed within 3 years from the date on which cause of action arose, as provided in section 1A of the section 77 of the said act. In the circumstance, the petitioner made an application under section 5 of the Limitation Act in the said case being so and so, praying inter-alia for condonation of delay in filing the said application under section 75. The said application, para 14, the said application for condonation of delay came up for hearing before the learned judge of the Employees Insurance Court on December 6, 1999. After hearing the parties, the learned judge of the said Employees Insurance Court was pleased to reject the said application filed on behalf of the petitioners under section 5 of the Limitation Act and holding inter alia. The application filed under section 5 of the Limitation Act was not applicable to any proceedings before the Employees Insurance Court. Thereafter, various judgments were quoted. Then come to para 13, madam. Para 31. I am sorry. Para 31. May I read, madam? The learned counsel of the respondents oppose the aforesaid contentions made on behalf of the petitioners. The main objections raised on behalf of the respondents are summarized as under. Then come to subpara 3. The learned counsel for the respondents further submitted that section 77(1)(a) of the said act prescribes a limitation of 3 years, the period prescribed by the special statute. The section does not contain any provision for conditional delay as in other special statutes. Then come to para 43. Para 43. Please. From the aforesaid rival contentions of the respective parties, it is now appears that the main question which falls for determination before this court in this proceeding is whether provisions of section 5 of the Limitation Act is applicable to any proceedings before the Employees Insurance Court. The provisions relating to commencement of proceedings before the Employees Insurance Court has been mentioned in section 77 of the Act. In terms of section 77(1)(a) of the ESA Act, every application shall be made before Employees Insurance Court within a period of 3 years from the date on which cause of action arose. There is no dispute that the cause of action arose in the present case on January 27, 1992, etc. Then para 45. Appreciating the delay in filing the said dispute case before the Employees Insurance Court, the petitioners herein also filed an application under section 5 of the Limitation Act in the continuation of delay in continuation of delay in filing the said case before the Employees Insurance Court. Then come to para 46. Para 46. Now it is to be decided whether Employees Insurance Court has any authority to entertain the application under section 5 of the Limitation Act, etc. Para 47. It has been repeatedly held by the Supreme Court in various decisions that the provisions of Limitation Act 1963 apply only to proceedings in courts and not appeals or applications before bodies other than court, such as quasi-judicial tribunal or executive authorities. In the case of so and so, Honorable Supreme Court has specifically held that the provisions of Limitation Act apply only to proceedings in courts and not to appeals and applications before bodies other than such courts, such as quasi-judicial tribunal, etc. Come to para 50. 50. The Employees Insurance Court is admittedly a creature of the Act, and while condoning the proceedings, the said Employees Insurance Court is bound to follow the procedures as prescribed by the rules framed by the
Each and every finding is with regard to the limitation is not applicable.
Please. Then para 54 and 55 on. Should I read? It is clearly discussed. Para 54. One other interesting point in the present case is that the provisions of section 5 of the Limitation Act has been made specifically applicable.
Yes, counsel. When the proviso is very clear in under section 77(1)(a), it doesn't apply in
then section para 55, 56 and 57. It clearly holds that special statute. Special statute
cannot apply to any proceeding before the ESI court.
Only one short note of cases, lost judgment.
One point judgment waste of time.
Well, this is anyway. I have given kindly see my lord small paragraph. I will not read it.
Namai court the judgment directly on point in the
in our High Court judgment, a small lacuna I feel is my lord, whether continuation of delay application can be filed under any of the provisions.
Discussion illa
adondilla idu elladralli ಇದೆ. ಮತ್ತೆ ESI Act ಅಲ್ಲಿ ಬೇರೆ ಪ್ರಾವಿಷನ್ಸ್ ಅಲ್ಲಿ ಕಂಟಿನ್ಯೂಷನ್ ಆಫ್ ಡಿಲೇ ಪ್ರಾವಿಷನ್ ಇದೆ. ಈ ಪ್ರಾವಿಷನ್ ಕೆಳಗಡೆ 77 ನಲ್ಲಿ there is no provision for continuation of delay. Therefore, my lord, my request is to reject on this preliminary issue the entire application.
Not looking into the merits.
Please.
That's all. Yes. Hmm. 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 Hmm.
Provided that the employees court may entertain an application after a period of 3 months if they satisfied.
Hmm.
Sufficient reason for not presenting the application.
Hmm.
Which tells that even after 3 months, there is no prescribed.
Hmm.
That is section 78 of the SI Act.
Hmm.
78 is the powers of the employees insurance code.
Hmm.
Wherein rule 4 is saying, section 4 tells an order of the ESA code shall be enforceable as if it were a decree passed and sued by a civil court.
Yes.
We have not invoked section 77 at all.
Hmm.
When we have felt a delay application. Now, my humble submission is that the order of the ESA code, in all the cases that my learned friend had cited, the ESA code had rightly rejected the application for continuation of failure. In this manner, the ESA code has gone into the merits. It has given reasons as to why the respondent was not able to approach the court in time.
Hmm.
Now, if your lordships may see the reasoning also.
Hmm. Reasoning already has read. Hmm. Hmm.
That I have partially lost my vision.
Hmm.
Not properly, I was not able to be taken care by my wife or my children.
Hmm.
Now, because of this, I was not able to approach on time.
Hmm.
And in the citation which my learned friend had read in the reasoning also,
Hmm.
with respect to social justice, a period of 12 years of delay was condoned.
Hmm.
And the coordinate of the High Court has also allowed an application.
Hmm.
In 2002, 1 LLN 293.
Hmm.
In the case of ES Employees Insurance Corporation and Nutan Ayurvedic Karnataka Private Limited.
Hmm.
Which will not read para 5.
Hmm.
No doubt, section 77 prescribes the period of limitation up to 3 years, but in the section cited, it is enunciated that section 5 of the Limitation Act is applicable even to the Employee State Insurance Act, and also further under the savings clause of section 29 subclause 4 of the Limitation Act. In view of the decision by the Bombay High Court, I am inclined to hold that section 5 of the Limitation Act is made applicable, and the Employee State Insurance Code has confirmed the delay. Hence, it can be held that the application is maintainable. My lord, in all these cases, the ESI Court has gone into the merits of the question whether the limitation is allowed or not.
Hmm.
In all the cases that my learned friend had cited, the ESI Court has rejected the application filed by the respondent.
Hmm.
Even as per the merits of the case, my lord, it is a question of, if I'm not wrong, the 16,000 rupees which I have been not a period of 10 months.
Hmm. 2007 to 2008. Hmm.
The limitation can be condoned as my. Limitation is condoned, then I am able to argue.
Third. Heard the appellant counsel and also the counsel appearing for the respondent. This appeal is filed challenging the order passed by ESI court, condoning the delay and entertaining the application filed under section 75 1E and G of the Employees State Insurance Act 1948. And also challenging the dismissal of review petition number 19 of 2015. The factual matrix of case of respondent before the trial court while invoking the section 75 1E and G of Employees State Insurance Act 1948, wherein has contended that applicant is an insured person under section 29 of the Employees Insurance Act 1948, as amended from time to time. It is also his case that under the ESI scheme from June 93 has paid contribution up to October 2016, 2006 within vacant 13 years. He has been allotted insurance number IP number 16040051 It is also his case that applicant suffered a brain stroke during 2006 and avoided treatment from the ESI the dispensary up to 31st of May 2007. The applicant was still unwell and was not in a position to carry on his duties. Hence, he approached the local office of the ESI Corporation at Yeshwanthpur for further leave. However, he was refused further leave, in spite of producing the ESP certificate. The applicant represented to the manager, local office, ESIC, Peenya, Bangalore, with letter dated 18.21.6/2007 and requested the concerned authority to clarify as to why he was not granted further leave, and also to refer the matter for re-examination of his fitness and to take an early action in this regard. He was informed by the respondent to wait for a call letter from ESI Corporation. It is also his case that he did not receive any call letter and hence the applicant lodged a complaint with the medical superintendent, Medical Hospital, Rajaji Nagar, Bangalore, to further extend the monetary benefits. The applicant received a letter dated 31/8/2008 from the medical superintendent, Model Hospital, Rajaji Nagar, to again approach the dispensary doctor for further action. The applicant had already waited for 14 months for the call letter and had not received any medical benefits, and when nothing came out of it, the applicant being frustrated by the treatment meted out to him, complained to the state medical commissioner along with a copy of the medical superintendent, Model Hospital, Rajaji Nagar. It is also his case that it was only after repeated follow-up that directions were given by the deputy director, by way of endorsement on the letter dated 13/8/2008. The deputy superintendent issued directions to the manager, local office to refer the case to the medical board, if necessary. However, the matter was never referred to the medical board, and the monetary benefits from 19/10/2007 to 2008 was also not paid. The applicant thereafter pursued his case with the Commissioner of State, Regional Director, Medical Director, Benefit by forwarding a copy of the letter at Annexure A. The Deputy Director made his letter dated 10/9/2008. Director directed the manager, local office, Peenya, to refer the matter to the medical board. Thereafter, the applicant was asked to appear before the medical board on 24/6/2009. The medical board on examination extended the sickness benefit for a period of 6 months, that is up to 24/12/2009. However, the period in question, that is from 19/10/2007 to 21/8/2008, was not paid and remains unpaid to this petition this day. It is also his case that he has been denied benefit due to him from 19/10/2000 to 21/8/2008, although he had given several representations to that effect. And hence, he had approached the ESI court seeking for benefit. The ESI court issued the notice and the respondent appeared and filed statement of objections. The main contention raised before the ESI court is that the very application is not maintainable since the same is barred by limitation. The details of the period during which the applicant availed the sickness benefit also stated, and also sickness benefit. The respondent also denies all the allegations contained in the petition. And the applicant has utterly failed to submit any ESP certificate for the period stated above, and in the absence of the non-production of the medical certificate, the applicant is not entitled any claim, any benefit, much less the benefit of payment of the money during the period which the applicant has claimed the benefit. The respondent also denied all other allegations with regard to the government of not taking up any decision. And there is no proof of the applicant having availed the medical treatment. As such, he is entitled to claim any monetary benefit. The ESA court, having considered the pleadings of the parties, formulated the point for consideration, that is, whether the application is barred by limitation and whether the applicant proves that he is entitled for sickness benefit. And the ESA court comes to the conclusion that same is not barred by limitation and partly allowed and directed to pay the sickness benefit for the concerned period 19/10/2007 to 21/8/2008. The same is also challenged before by filing a review petition and the same also rejected. Now the very main contention before this court by the petitioner is that the ESI court failed to take note of the very proviso that if any claim made claim beyond 3 years, the same cannot be entertained, and the limitation prescribed under section 77(1)(a) of the ESI Act 1948. The reasons adduced by the respondent for condonation of delay, speaks of the events up to 2008 only, and no cogent reasons or tenable reasons is forthcoming in the affidavit for delay after the year 2008 to 2013. Therefore, the ESI court committed an error in passing such an order. The counsel, during the course of his argument, did not argue the matter on merits and mainly concentrated on the limitation issue is concerned, and mainly contend that when the petition is filed under section 75(e) and G, and also when the application is filed beyond period of limitation, and the limitation is only 3 years, no condonation can be done. In support of his argument, he relied upon the judgment of this court, reported in ILR 2001 Karnataka 5674, wherein discussion was made with regard to section 75 and 77. Application under section 75 of the Act shall have to be filed within 3 years from the date of cause of action. The council also brought to notice of this court the very proviso of section 77 1A, wherein period of 3 years is mentioned regarding commencement of proceedings. And council also brought to notice of this court section 29 of Limitation Act. And also council would vehemently contend that when the specific provision is made in the special enactment, question of invoking section 5 also doesn't arise. The council also referred brought to notice of this court the application filed before the trial court under Rule 20B of the ESI rules, read with section 78 of the ESI Act, and also brought to notice of this court section 75 of the ESI Act, and also contend that section 5 cannot be invoked. 5 of limitation cannot be invoked. The council also relied upon the paragraph number 4 and 9 of the judgment of this court referred supra. Council also relied upon ILR 2009 Karnataka 1194, wherein also discussion was made with regard to when the application is filed under section 75 1G, and also discussion made under section 77 1A, and brought to notice of this court paragraph number 8, wherein point for consideration is raised in the said case, and also brought to notice of this court paragraph number 11, wherein discussion was made with regard to the ESI Act is a special act. Therefore, the period of limitation provided under section 77 1A of the ESI Act will have to be treated as the period of limitation provided under the Limitation Act, and section 3 of the Limitation Act is applicable. In other words, if an application under section 75 1G of the ESI Act is filed beyond the period of 3 years from the date on which the cause of action arose, such application will have to be rejected as barred by limitation. The council also brought to notice of this court the judgment of Kerala High Court, class within bracket Kerala 2016.4.100, and brought to notice of this court the factual aspects stated in paragraph number 1, and so also paragraph number 9 10, 18, 19, and also paragraph number 21, wherein discussion was made with regard to section 29(2) of the Limitation Act. And also discussion was made with regard to section 77 and 82. And brought to notice of this court, paragraph number 23. And content that section 5 of limitation cannot be pressed into when the specific provision is made in the act itself. The council also relied upon the judgment of Orissa High Court, laws within bracket Orissa 2009.10.20. Brought to notice of this court, paragraph number 5, wherein whether court is justified to reject the application of the appellant on the ground of limitation. And also brought to notice of this court, discussion made in paragraph number 6 with regard to proviso of section 77. And also paragraph number 7, wherein also discussion was made with regard to the applicability of the Limitation Act. And proviso to subsection 1 of section 35 makes no position crystal clear that appellate authority has no power to allow the appeal to be presented beyond the period of 30 days. And also there is complete exclusion of section 5 of the Limitation Act. Council also brought to notice of this court, judgment of Kolkata High Court reported in last within bracket Kolkata 2003.4.50, and brought to notice of paragraph number 1, wherein also discussion was made with regard to the application under section 5 of Limitation Act. And also discussion was made in paragraph number 13, 14 regarding applicability of section 5 of Limitation Act. And brought to notice of this court, paragraph number 31. Paragraph number 43, 44, 45, 46, 47, 50, wherein discussion is made that employees court has discussed earlier cannot be regarded as a court in the strict sense, and therefore provisions of Limitation Act 1963 cannot apply in respect of the proceedings before the said employees insurance court. Wherein also the judgment of the apex court in the case of Nityanand versus Life Insurance Corporation of India reported in AR 1970 SC 209 was also discussed with regard to the Limitation Act, is that it only deals with the applications to courts, and that the labor court is not a court within the limitation of 1963. And also brought to notice of paragraph number 54, wherein also discussion was made. Section 77 1A of the ASI Act specifically provides that every application shall be made before the Employees Insurance Court within a period of 3 years from the date on which the cause of action arose. The council referring this judgment vehemently contend that the respondent cannot invoke section 5 of the Limitation Act when this very special statute prescribes the period of 3 years, and admittedly the claim is in respect of 2007 to 2008 and claim is filed in 2013 beyond 5 years of limitation, and hence the ESI court ought not to have entertained the petition and committed an error in coming to the conclusion that no limitation. For contra, the counsel appearing to the respondent in this argument would vehemently contend that the trial court, taking into note of the material on record, particularly when he has not partial vision, and also considering the matter on merits, condone the delay, and reason assigned in the application also taken note of while condoning the delay. The counsel also, in support of his argument, he relies upon the judgment of this court 2002 within bracket 1 LLN 293 and brought to notice of this court, wherein also discussion was made with regard to Limitation Act 1963 section 5 and 29(2) of period of limitation to file application challenging the order of the Employees State Insurance Corporation. and brought to notice of this court paragraph number 5, wherein this court held that no doubt section 77 prescribes the period of limitation up to 3 years. But in the decision cited, it is enunciated that section 5 of the Limitation Act is applicable even to the Employees State Insurance Act, and also further under the saving clause of section 29(2) of the Limitation Act. In view of the decisions by the Bombay High Court declined to hold that section 5 of Limitation Act made applicable, and the Employees State Insurance Court has condoned the delay, hence it can be held that application is maintainable. The counsel referring this judgment would contend that when this court also comes to the conclusion that limitation can be considered, the very contention of the appellant counsel cannot be accepted. Having heard the appellant counsel and also the counsel appearing for the respondent, the point that would arise for the consideration of this court, whether the tribunal ESI court committed an error in condoning the delay, invoking section 5 of Limitation Act, read with Rule 20B and section 78 of the ESI Act. Having heard the petitioner counsel and also the counsel appearing for the respondent, and this court has to take note of the material on record, the application is filed before the ESI court under section 75 1E and G of the Employees State Insurance Act 1948. The proviso section 75 1E and G purports with regard to matters to be decided by Employees Insurance Act. If any question or dispute arises as to the right of any person to any benefit and as to the amount and duration thereof. And clause G says any other matter which is in dispute between a principal employer and the corporation and an immediate employer, or between a person and the corporation, or between an employee and a principal or immediate employer in respect of any contribution or benefit or other dues payable or relevant recoverable under this act, can make such application. It is also important to note that court also to take note of the very proviso of section 77. This is with regard to the commencement of proceedings before an employee insurance court shall be commenced by application, and in the case on hand an application is filed is also not in dispute. And also the section 77 1A is very clear that every such application shall be made within a period of 3 years from the date on which the cause of action arose. The counsel also not disputes the fact with regard to an application is filed before the ESI court for the sickness benefit. But only main contention of the counsel appearing for the appellant is that it ought to have been filed within 3 years from the date on which the cause of action arose. It is also important to note that claim is also made in respect of sickness benefit for the period from 1910-2007 to 21/8/2008. And having perused the application filed before the ESI court also, the same was filed in 2013.
27/9/2013.
27/9/2013. But actually our date adide avat agilla. Affidavit agirade in the month of October. You see the application.
Both date are 27/9/2013.
Notarize ಆಗಿರೋದು ಬೇರೆ ದಿವಸದಲ್ರಿ 22nd October 2013 ನೋಡಿ. Though application was prepared on 27/9/23, filed on notary ಆಗಿರೋದು ನೋಡಿ ಯಾವಾಗ ಅಂತದ್ದು 22nd October 2013 ಅಂತಿದೆ ನೋಡಿ. Anyhow, that is not the matter. Please, 2013. But the contention of the respondent counsel that court, ESI court not committed an error in entertaining the application, and Section 5 is also can be pressed into the service. Having perused the judgment of this court, particularly while dealing with the application filed under section 75 and 77, categorically held in the judgment ILR 2001 Karnataka 5674, shall have to be filed within 3 years from the date of cause of action. Cause of action arises for the period from 2000 to 2008, in 2008 only. And this court also in the judgment referred ILR 2001 Karnataka dealt with regard to the limitation is concerned and dismissed the same. Referring the judgment, section 77 1A of the ESI Act dismissed the application, which in it does not suffer from any infirmities as to the reasoning given. It is also important to note that in 2009 also, this court held in the judgment ILR 2009 Karnataka 1194, wherein also discussion was made with regard to section 77 1A. Period of limitation prescribed under application filed beyond the period of 3 years from the date on which the cause of action arises. And detailed discussion was made. And having considered the factual aspects also in paragraph number 11, elaborately discussed the proviso under section 77 1A of the ESI Act. And also even discussed subsection 2 of section 29 of the Limitation Act, where any special or local law prescribes for any suit, appeal or application, a period of limitation different from the period prescribed by the schedule, the provisions of section 3 shall apply as if such period were the period prescribed by the schedule and for the purpose of determining any period of limitation prescribed for any suit, appeal or application by any special or local law. It is also observed that the ESI Act is a special act. Therefore, the period of limitation provided on section 77 1A of the ESI Act will have to be treated as the period of limitation provided under the Limitation Act. And section 3 of the Limitation Act is applicable. In other words, if an applicable application under section 75 1G of the ESI Act is filed beyond the period of 3 years from the date on which the cause of action arose, such application will have to be rejected as barred by limitation. The principle laid down in the judgment is also aptly applicable to the case on hand. This is the judgment of 2009. And counsel refers the judgment of this court reported in 2002 within bracket 1, wherein discussion was made in paragraph number 5. It is applicable. And also court has to take note of the recent judgment of this court, since both the judgments are by the single judge. And apart from that, other judgment which have been relied upon by the counsel for the appellant, that is Kerala judgment, Orissa High Court judgment, Kolkata judgment, all are 2009, 2016 and 2003, as well as elaborate discussion is made with regard to the applicability of section 5 of Limitation Act. The concurrent finding of this court as well as other high courts, though same are is persuasive in nature, taken note of elaborate discussion, particularly in the judgment of Kolkata High Court, as well as in the judgment of Kerala High Court in 2016, and also in the judgment of Orissa High Court. Issue has been considered with regard to the applicability of the Limitation Act. And all the courts comes to the conclusion that section 5 of the Limitation Act cannot apply to any proceedings before the Employees Insurance Court. And when such principles are held in the judgment, particularly taking into note of the ESI Act as a special enactment, and when the limitation is prescribed under section 77 of class 1A, period of limitation, and admittedly the application is filed beyond period of 5 years, and also claim is in respect of 2007 to 2008 and petition is filed in 2008, and when such being the material available on record, the ESI court committed an error in entertaining an application for condonation of delay. No doubt, the counsel appearing for the respondent brought to notice of this court with regard to the respondent lost his partial vision, and also he was suffering from the having paralysis. And also reasons are assigned, but when the statute prescribes the period that an application has to be filed within a period of 3 years, particularly in the proviso of section 77 1A of the ESI Act, ought to have been filed the same within the statutory period. And hence, there is a force in the contention of the counsel appearing for the appellant that the ESI court committed an error in entertaining the application beyond the period of limitation. And hence, I do not find any force in the contention of the respondent counsel that the judgment of this court referred supra 2002 is applicable to the facts of the case on hand. And hence, the order passed by the ESI court requires to be set aside on the ground of limitation without considering the matter on merits. In view of the discussions made up, I pass following order. Appeal is allowed, impugned order is set aside. Set aside, that's all.
39. MS Vishwanath. Rakshita.
Just to serial number
39.
39. Hmm. Hmm. ಏನು ಒಕ್ಕಲತ್ತ ಹಾಕಿದ್ದೀರಾ? ಅವರೆಲ್ಲರೂ ಪಾರ್ಟಿಸ್ ಇದಾರೆ ಇದ್ರು. ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್ ಯಾವ್ದಕ್ ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್? ಯಾವ ಲ್ಯಾಂಡಿಗೆ ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್ ಅವರು? ಬೇರೆ ಇದೇ ಸೇಮ್ ಲ್ಯಾಂಡ್ ಈಗ ಯಾವ್ದು ಮೊನ್ನೆ ಏರ್ ಮಾಡಿದ್ವಲ್ಲ ಅದಲ್ಲ ಏನೋ ಸಜೆಷನ್ಸ್ ಏನೋ ಏನಾಯ್ತು? ಸೆಟ್ಲ್ಮೆಂಟ್ ಏನು ಅಪಾರ್ಟ್ಮೆಂಟ್ 1, 2
After hearing, after the examining the survey report. And in fact, my learned friend proposal has been ultimated to examine my land. So may I request my lord to the properly have a develop a joint develop. This is a property question is a joint development. So not make any appreciate what I agree to my lord is. Only by way of assisting the clarification. May I expect my lord the will, only this I wanted to point out 1 minute, I mean. But page 4 maybe kindly will. May I speak the Tata will.
ಎಲ್ಲಿದೆ ವಿಲ್ ಎಲ್ಲಿದೆ ಹೇಳಿ? ಪೇಜ್ ನಂಬರ್
in the along with the argument contractor proceeding.
ಯಾರು ಹಾಕಿರೋದು ಹೇಳಿ ವಿಲ್? ಯಾವತ್ತು ಹಾಕಿರೋದು? ಮೆಮೋ ಮೆಮೋ ಇದೆಯಾ?
One more copy I will give.
ಹಾ ಕೊಡಿ ಹೇಳಿ.
The part of the record also. So let me may request the Lord for the page 3. Page 3 will be kindly given. Just below bottom. Page 3 of the will. ಈ ಮೇಲ್ಕಣಿಸಿದ ಮನೆಗೆ ಸೇರಿದ ಇದೆಲ್ಲ ಹಾಗೆ ಈ ಮೇಲ್ಕಣಿಸಿದ 3 ಐಟಮ್ ಆಗ್ತಿದ್ದು ನನ್ನ ಸ್ವಂತ ಪ್ರಯಾಣಿತ ಆಸ್ತಿಗಳಾಗಿದ್ದು ನನ್ನ ಸಂಪೂರ್ಣ ಮಾಲೀಕತ್ವ ಒಡೆತನಕ್ಕೆ ಸೇರಿ ನನ್ನ ಸ್ವಾಧೀನ ಅನುಭವದಲ್ಲಿರುತ್ತವೆ ಹಾಗೂ ನನ್ನ ಇಷ್ಟಾನುಸಾರ ಇವುಗಳ ವಿಲೇವಾರಿ ಮಾಡಿಕೊಳ್ಳಲು ಅನುಕೂಲನಾಗಿರುತ್ತೇವೆ. ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಇಸ್ ರಿಲೆವೆಂಟ್. ವಾಟ್ ಐ ಟ್ರೈ ಟು ಪಾಯಿಂಟ್ ಔಟ್ ಹಿಯರ್. ಹಾಗೂ ಸರ್ವೆ ನಂಬರ್ 24 ಖಾತಾ ನಂಬರ್ 71 ಉಳ್ಳ ಖರಾಬು ಜಮೀನು 15 ಗುಂಟು ಜಮೀನಿಗೆ ಚೆಕ್ಕು ಪೂರ್ವಕ್ಕೆ ಬಿಡಿಯವರ ಸೊತ್ತು, ಪಶ್ಚಿಮಕ್ಕೆ ಸರ್ಕಾರಿ ಅಲ್ಲ, ದಕ್ಷಿಣಕ್ಕೆ ಲಕ್ಷ್ಮಣನಿಗೆ ಸೇರಿದ ಜಮೀನು, ಉತ್ತರಕ್ಕೆ ಉಮರ್ ಬೇಗ್ ಲೇಔಟ್. ದಿಸ್ ಈಸ್ ಐ ಟ್ರೈ ಟು ಪಾಯಿಂಟ್ ಔಟ್. Then I will take my lord to the survey the sketch that has been produced, that has been the part of the survey report submitted. So last May, this background, 15 quintas is the undisputed Karab land is in existence, rather than this also. That was the only, may request the law for evidence. Kindly, I try to point out from the survey sketch filed before this court. So last May, kindly appreciate this background of the schedule shown here. ಸುಮಾರು 15 ಗಂಟೆ ಜಮೀನು ಚಕ್ಕು ಬಂದು ಎಲ್ಲ ದಕ್ಷಿಣಕ್ಕೆ ಲಕ್ಷ್ಮಣನಿಗೆ ಇಲ್ಲಿ ತಾವು ಮೊನ್ನೆ ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡಿದ್ರಿ ತಾವು ಕೈಲಿ ಪರ್ಪಲ್ ಕಲರ್ ಅಲ್ಲಿ ಇದೆಯಲ್ಲ
ಲೆಜೆಂಡ್ ಅಲ್ಲಿ 8 ಅಂತ ಇದೆ. ಕೆಳಗಡೆಗೆ 8 ಪರ್ಪಲ್ ಕಲರ್.
ಈ ಬಣ್ಣದಿಂದ ತೋರಿಸಿದ್ದು ಸರ್ವೆ ಸ್ಕೆಚ್ ಈ ಬಣ್ಣದಿಂದ ತೋರಿಸಿರುವುದು ಸರ್ವೆ ನಂಬರ್
22 ಗುಂಟೆ ಫುಲ್ ಅಂದ್ರೆ ಖಾಲಿ ಇರುತ್ತೆ ಅಂತ.
ಖಾಲಿ ವೇಕೆಂಟ್.
Point out this and the availability of the land for the artist or land. This is what I try to pursue and also try to from the schedule shown in the will. The 15 quintas is considered in the lord.
ಈ ಡಾಟರ್ಸ್ ಕೊಟ್ಟಿರೋ ಪ್ರಾಪರ್ಟಿ ಎಲ್ಲಿದೆ ವಿಲ್ ಪ್ರಕಾರ?
ಪ್ರಕಾರ ಇದನ್ನೇ ನಾನು ತೋರಿಸ್ತಾ
ಈಗ ಓದಿದ್ರಲ್ಲ ಅದೇನಾ? ಸರ್ವೆ ನಂಬರ್ 24 ಖಾತಾ ನಂಬರ್ 71 ಉಳ್ಳ ಖರಾಬು ಜಮೀನು ಸುಮಾರು 15 ಗುಂಟೆ ಜಮೀನಿಗೆ ಚೆಕ್ ಬಂದಿ. ಹಾ
ಹೆಣ್ಮಕ್ಳಿಗೆ ಕೊಟ್ಟದ್ದು ಹಾಗೆ ನನ್ನ ಎರಡನೇ ಮಗಳಾದ ಶ್ರೀಮತಿ ಜಯಮ್ಮ ಪೇಜ್ 12 ತಾವು ನೋಡ್ಬೋದು.
ಪೇಜ್ 12.
Yes, madam.
ಇದು ಚಾರಿ ಆಗಿದೆ. ಹಾಗೆ ನನ್ನ ಎರಡನೇ ಮಗಳಾದ ಪ್ರೆಸೆಂಟ್ ಡೆಟೆಕ್ಟಿವ್ ಪಾಯಿಂಟ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್ ಸೇರತಕ್ಕ ಸ್ವತ್ತಿನ ವಿವರ ಪಶ್ಚಿಮಕ್ಕೆ ಪೂರ್ವ ಪಶ್ಚಿಮ 40 ಅಡಿಗಳು, ಉತ್ತರ ದಕ್ಷಿಣ
100 ಅಡಿ,
ಖಾಲಿ ಜಾಗಕ್ಕೆ ಚೆಕ್ ಬಂದಿದೆ. ಇಲ್ಲಿ ತಾವು ನೋಡ್ಬೋದು ದಕ್ಷಿಣಕ್ಕೆ ಲಕ್ಷ್ಮಣಪ್ಪನ ಲೇಔಟ್, ಮೋಟಮ್ಮ ಪೂರ್ವಕ್ಕೆ ಮೋಟಮ್ಮನ ಮಕ್ಕಳ ಸೊತ್ತು, ಪಶ್ಚಿಮಕ್ಕೆ ಗವರ್ಮೆಂಟ್ ಅಲ್ಲ, ಉತ್ತರಕ್ಕೆ ವಿಶೇಷ ಸೊತ್ತು, ದಕ್ಷಿಣಕ್ಕೆ ಲಕ್ಷ್ಮಣಪ್ಪ ಲೇಔಟ್. ಈ ಪರ್ಪಲ್ ಕಲರ್ ಇದೆಲ್ಲ ತಾವು ಒಂದ್ಸತಿ ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡಿದ್ರಲ್ಲ ಅದನ್ನ ವಾಟ್ ಎಕ್ಸಾಕ್ಟ್ಲಿ
ಈಗ ಇಲ್ಲಿ ಲಕ್ಷ್ಮಣಪ್ಪನ ಸೊತ್ತು ಯಾವ್ದು
ಮಧ್ಯದಲ್ಲಿರೋದು ಅಂತ ಹೇಳ್ತಾರೆ.
ಮಧ್ಯದಲ್ಲಿ ತೋರಿಸಿದಾರಲ್ಲ ಅದ
ಬ್ಲೂ ಕಲರ್.
ಟೋಟಲ್
ದಕ್ಷಿಣ ನಾರ್ತ್.
ಅದ್ ಮೇಲ್ಗಡೆ ನಾರ್ತ್ ಅಂತ ತೋರಿಸಿ ಕೆಳಗಡೆಗೆ
ಹಾಗಾಗಿ ಕ್ಲೈಮ್ ಅಂಡ್ ಪರ್ಸ್ಯೂ not continuing the way.
ಉತ್ತರಕ್ಕೆ ಎಂ ವೆಂಕಟೇಶನ ಸೊತ್ತು.
ದಕ್ಷಿಣಕ್ಕೆ ಲಕ್ಷ್ಮಣಪ್ಪನ ಲೇಔಟ್.
ಅದೇ ವೆಂಕಟೇಶ್ ಅಂದ್ರೆ ಇವರೇ ಒನ್ ಆಫ್ ದಿ ಬ್ರದರ್. ಒನ್ ಆಫ್ ದಿ ಬ್ರದರ್ ವೆಂಕಟೇಶಪ್ಪ ಅಂದ್ರೆ ಇವರನ್ನ ಕಳಿಸಿ ದಿಸ್ ಪೋರ್ಷನ್ ನಲ್ಲಿ ಈ ದೇವಸ್ಥಾನದ ಪಕ್ಕದಲ್ಲಿ ಆ ಅಲೇಜ್ಡ್ ವಿಲ್ ಅಲ್ಲಿ ನಾಟ್ ಓನ್ಲಿ ಡಾಟರ್ಸ್ಗೆ ಅಂತಲ್ಲ 5 ಸನ್ಸ್ ಅಂಡ್ ಡಾಟರ್ಸ್ಗೆ ಅಡಿಷನಲ್ ಖರಾಬ್ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ಎಕ್ಸ್ಟ್ರಾ ಕೊಟ್ಟಿದೀವಿ ಅಂತ ಅಲ್ಲಿ ವಿಲ್ ಅಲ್ಲಿ ಹೇಳಲಾಗಿದೆ. ಆದರೆ ಇವರ ಮೇಲೆ ಟೋಟಲ್ 2 acres ಆಫ್ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ರಿಟೈನ್ ಲ್ಯಾಂಡ್ ಸದರನ್ ಸೈಡ್ ಮಾತ್ರ, ಇದು ಎಕ್ಸ್ಟ್ರಾ ಖರಾಬ್ ನಲ್ಲಿ ಕೊಟ್ಟಿದೀವಿ ಅಂತ ಇಲ್ಲಿ ಹೇಳಲಾಗಿರ್ತಕ್ಕಂಥದ್ದು. ಆ 1 acre ಆಫ್ ಲ್ಯಾಂಡ್ ಇದೇ ಜಾಗದಲ್ಲಿ ಇದೆ. ಆ 1 acre ರಿಟೈನ್ ಲ್ಯಾಂಡ್ ಇಲ್ಲಿ ಸ್ವಾಮಿ, ರಿಟೈನ್ ಲ್ಯಾಂಡ್ ಇದು ಲಕ್ಷ್ಮಣಪ್ಪನಿಗೆ ಮಾರಿರೋದು. ಇಲ್ಲಿ 1 acre ಇಲ್ಲಿ ಇದೆ ಒರಿಜಿನಲ್ ಲ್ಯಾಂಡ್ ಇಲ್ಲಿ ಉಳ್ಕೊಂಡಿದೆ. ಅದರಲ್ಲಿ ಈಗ 28 ಗುಂಟಾಸ್ ಮಾತ್ರ ಇದೆ ಅಂತ ಸರ್ವೆ ಸ್ಕೆಚ್ ರಿಪೋರ್ಟ್ ಹೇಳ್ತಾ ಇದೆ ಸ್ವಾಮಿ. ಈಗ ಸೊ ಇಲ್ಲಿ ನಮ್ಗೆ 1 acre ಆಫ್ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ಅವರು ಟೋಟಲ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅಂದ್ರೆ ಅವೈಲಬಲ್ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ಸ್ವಾಮಿ. ಈಗ ನನ್ಗೆ ಇವರಿಗೂ ಖರಾಬ್ ವರ್ಜುವರ್ನಲ್ಲಿ ವಿಲ್ಲಲ್ಲೂ ಸಹ ಹೇಳ್ತಾ ಇರೋದೇನಂದ್ರೆ ಖರಾಬ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತೇಳಿ ಸ್ವಾಮಿ. ನನ್ನ ವಿಚಾರ ಇಷ್ಟೇ, ಅಲ್ಲಿ ಗಂಡ್ಮಕ್ಳಿಗೂ ಕೊಟ್ಟಿದ್ರಿ ಅಂತ ಹೇಳ್ತೀರಿ. ಓವರ್ ಆಲ್ ಇದು ಏನಿದೆ ಈ ವಿಲ್ ಅನ್ನೋದು ಏನಿದೆ ಇದು ನನ್ಗೆ ಏನ್ ನಾನ್ ಎಕ್ಸಿಸ್ಟೆಡ್ ಪ್ರಾಪರ್ಟಿ ಕೊಡುವಂತ ಪ್ರಯತ್ನವನ್ನ ಗಂಡ್ಮಕ್ಳು ಆ ವಿಲ್ಲಲ್ಲೇ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಸ್ವಾಮಿ. ನಾನ್ ಎಕ್ಸಿಸ್ಟೆಡ್ ಪ್ರಾಪರ್ಟಿ ಅವ್ರಿಗೂ ಅಲ್ಲೂ ಮೈಲಾರ್ಡ್ ಅಲ್ಲೂ ಸಹ ಅವ್ರಿಗೂ ಎಲ್ಲರಿಗೂ ಶೇರ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಖರಾಬ್ ಲ್ಯಾಂಡ್ ಅಲ್ಲೂ ಸಹ ಖರಾಬ್ ನಲ್ಲಿ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಮೆನ್ಷನ್ ಮಾಡ್ಬಿಡ್ತಾ ಇದಾರೆ. ಇವರಮ್ಮ ಖಂಡಿಸಿ ಹೌ ಕೆನ್ ಐ ಗೆಟ್ ದಟ್ ಖರಾಬ್ ಲ್ಯಾಂಡ್ ಮೈಲಾರ್ಡ್, ಹೌ ಕೆನ್ ಐ ಗೆಟ್ ದಟ್ ಖರಾಬ್ ಲ್ಯಾಂಡ್? If I go on with the will, even ನನಗೆ ಗೊತ್ತೇ ಇಲ್ಲ will ಆಗಿರುವಂತದ್ದು.
ಆಯ್ತು, why you people have not produced the document of title deed to the extent of 2 acres is concerned, both plaintiff and
How-
defendants. Why you have not produced the original documents? ಈಗ ನಿಮ್ಮ ಕ್ಲೈಮ್ ಏನು ಅಂದ್ರೆ ಒರಿಜಿನಲ್ ಓನರ್ ಗೆ 2 ಎಕರೆ ಜಾಗ ಇದೆ ಅಂತ.
ಹೌದು.
2 ಎಕರೆ ಜಾಗ ಟೈಟ್ಲ್ ಕೊಡಿ ಫಸ್ಟ್.
I have a copy. I may be permitted to.
ಎಲ್ಲಿ ಹಾಕೇ ಇಲ್ವಲ್ಲ?
ಇಲ್ಲ, ನಾನು ಇವತ್ತು ವಕಾಲತ್
ಇವ್ರಿಗೂ ಕೊಟ್ಟಿಲ್ಲ, ಯಾರಿಗೂ ಸರ್ವೇಯರ್ ಹೋದಾಗ್ಲೂ ಸರ್ವೇಯರ್ಗೂ
ಇಲ್ಲ, ನಾನು ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅವರು. ನನಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅವರು.
ನೋಡಿ, ನಿಮಗೆ ಯಾಕೆ ನೋಟಿಸ್ ಕೊಡ್ತಾರೆ? ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ರು?
JDR ಯಾರಾಗಿದೆ? JD ಡೆವಲಪ್ಮೆಂಟ್ ಇದ್ದಾರೆ
2
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಎಕರೆ ಲ್ಯಾಂಡ್ ಎಲ್ಲಿದೆ ತೋರ್ಸಕ್ಕೆ?
I have a copy ಮೇಲೆ. That is the reason I said I may be permitted to file application.
Then kind submission, my lord. Page number 11 of the will.
ಆಯ್ತ್ರಿ, ನಿಮ್ ಬೌಂಡ್ರಿ ಏನಿದೆ ರೀ ವಿಲ್ ಪ್ರಕಾರ? ನಿಮಗೆ
ನನ್ನ
you are
boundary-
claiming the property based on the will only. Based
No,
on the
no,
will
no, my
only.
lord. No. I am not at all claiming based on the will. They are claiming the will. I am disputing the will, my lord.
ಈ ವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ನನ್ಗೆ ಗೊತ್ತೇ ಇಲ್ಲ, ನನ್ಗೆ ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಹಾಕಿದ್ಮೇಲೆ ತಂದ್ಕೊಟ್ಟಿದ್ದು. ಪ್ರೊಬೇಟ್ ತಗೊಂಡಿಲ್ಲ, ನನ್ಗೆ ಖಾತಾ ಮಾಡ್ಕೊಂಡಿಲ್ಲ ಅವ್ರು ಮೊದ್ಲು ಅರ್ಲಿಯರ್ 98 ವಿಲ್ ಅನ್ನ ಈ ಖಾತಾ ಆಫ್ಟರ್ ದಿ ಡೆತ್ ಆಫ್ ದಿ ಫಾದರ್ ಇವ್ರೆಲ್ಲೂ ಗಮನಕ್ಕೆ ತಂದಿಲ್ಲ. ನಾವು ಜಾಯಿಂಟ್ ಅದರಲ್ಲಿ ನಮ್ಗೆ ಬಿಲ್ ಅಲ್ಲಿ ನಮಗ್ ಶೇರ್ ಕೊಟ್ಟಿರೋದೇ ಆದ್ರೆ ಯಾವ ವಿಚಾರವೂ ನಮ್ಗೆ ಗಮನಕ್ಕೆ ತಂದಿಲ್ಲ. ಅವ್ರು ಒಬ್ಬರಿಗೆ ಅವ್ರು ಖಾತಾ ಮಾಡಿದ್ದಾರೆ. ಎಸ್ ಮೇಲ್, ನನಗೆ ಗೊತ್ತೇ ಇರ್ಲಿಲ್ಲ ಅದು. ನನ್ನ ಪಾರ್ಟಿಷನ್
ಈ ಒರಿಜಿನಲ್ ಓನರ್ 2 ಎಕರೆ ಜಾಗ ಇತ್ತು ಅನ್ನೋದು ತೋರಿಸಿ ಎಲ್ಲಿದೆ ಮತ್ತೆ?
ಇವ್ರ ಖಂಡಿಸಿ ಅದು ಅವ್ರ ಡಾಕ್ಯುಮೆಂಟ್ ಅವ್ರ ಹತ್ರನೇ ಇದೆ ಸ್ವಾಮಿ ಅದು. ಅಂಡ್ ನನಗೆ ನಾನು ಅದಕ್ಕೊಂದು ಅಪ್ಲೈ ಮಾಡಿದ್ದೆ ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ ಅಪ್ಲೈ ಮಾಡಿದ್ರೆ ಆ ಡಾಕ್ಯುಮೆಂಟ್ಗೆ CCB ಹೋಗಿದೆ. ನನಗೆ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಸಿಗ್ಬೇಕು, ಯಾಕಂದ್ರೆ ಒರಿಜಿನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅವ್ರ ಗಂಡ್ ಮಕ್ಳ ಹತ್ರ.
What is your pleading in the plaint based on the will or?
ಇಲ್ಲ ಸ್ವಾಮಿ, ನನಗೆ RTC ಏನಿದೆ ಲ್ಯಾಂಡ್ 2 ಎಕರೆ ಇದೆ ಅಂತ
ಅಷ್ಟೇ ಕೇಳಿರೋದು ನೀವು?
ಅಷ್ಟೇ ಸ್ವಾಮಿ.
ನಾಟ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್.
ಇಲ್ಲ ನನ್
ಆಯ್ತು, ಅವ್ರಿಗೆ ವಿಲ್ ಮಾಡಿದಾರೆ ಅಂತ ಅಂದ್ಮೇಲೆ ನೀವು ಈ ವಿಲ್ಲಿಗೆ ತಕರಾರು ಹಾಕಿದೀರಾ?
ಸ್ವಾಮಿ ಇಲ್ಲ, ನಾನು ಒಂದು IA ಹಾಕೊಂಡಿದ್ದೆ ಸ್ವಾಮಿ ವಿಲ್ಗೆ ತಕರಾರು. ಅಲ್ಲಿ ಒಂದ್ ಸ್ವಲ್ಪ ಆ ವಿಲ್ ಅಲ್ಲಿ ತಪ್ಪಾಗಿದೆ, ಪ್ರೇಯರ್ ಕೇಳಿರೋದು ಅಂತ ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಂಡು ಫ್ರೆಶ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಳ್ತೀನಿ ಅಂತ ವಿತ್ಡ್ರಾ ಮಾಡಿದೀನಿ ಸ್ವಾಮಿ. ಅಂದ್ರೆ ವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಕ್ಕೆ ಫ್ರೆಶ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಳ್ತೀನಿ ನಾನು ಅಂತ ಹೇಳಿ ವಿತ್ಡ್ರಾ ಮಾಡಿದೀನಿ. ಅಷ್ಟರೊಳಗಡೆ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಮ್ಯಾಟ್ರ್ ಬಂದಿರೋದ್ರಿಂದ ಅಲ್ಲಿ ಹೋಲ್ಡ್ ಆಗಿದೆ ಸ್ವಾಮಿ ಅಷ್ಟೇ. ಅಲ್ಲ, ಅವ್ರು ಪ್ರೊಬೇಟು ತಗೊಂಡಿಲ್ಲ, ಬಟ್ ನನ್ ಗಮನಕ್ಕೂ ತಂದಿಲ್ಲ ಸ್ವಾಮಿ.
ಪ್ರೊಬೇಟ್ ಅವಶ್ಯಕತೆ ಇಲ್ಲ.
ಅಲ್ಲ, ಸ್ಟ್ರೈಟ್ ಅವೇ ದೇ ಆರ್ ಗೋನ್ ವಿತ್ ದಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಇನ್ ದಿ ಸೂಟ್ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ರೀಸೆಂಟ್ಲಿ ಗೆಟ್ ಖಾತಾ.
ವಿಲ್ 98
ಈಗ ಸಡನ್ ಆಗಿ ಅವರು ಇದ್ ಮಾಡ್ತಾರೆ, ಇದುವರೆಗೆ ಗಮನಕ್ಕೆ ತಂದಿಲ್ಲ.
ಆಯ್ತ್ರಿ, anyhow father has left the property, daughters are also entitled for a share in the property. ಹೇಳಿ, ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಸ್ಟಾಪ್ ಮಾಡ್ಬೇಕಾ ಅಥವಾ ಏನ್ ಮಾಡ್ಬೇಕು ನೀವ್ ಹೇಳಿ. ಇಲ್ಲ ಬೇರೆ ಕೇಸಲ್ಲಿ ಹೇಗೆ ಒಂದು ಸೆಟ್ಲ್ಮೆಂಟ್ ಆಗಿದೆ ಅದೇ ತರ ಮಾಡೋದಾದ್ರೆ ವೆಲ್ ಅಂಡ್ ಗುಡ್. ಲಾಸ್ಟ್ ಟೈಮ್ ಯು ಹ್ಯಾವ್ ಟೇಕನ್ ದಿ ಪ್ರಪೋಸಲ್, ಏನೋ ಕೊಡ್ತೀವಿ ಅವ್ರಿಗೆ, ಏನೋ ಲ್ಯಾಂಡ್ ಕೊಡ್ತೀವಿ, ಏನೋ ಮಾತನಾಡ್ತೀವಿ ಅಂತ ಅಂದ್ರಿ. ಈಗ ಬಂದು ಬೇರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ರಿ. ಫ್ರೀ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ, ಅದ್ರ ಮೇಲೆ ಒಂದ್ ಯಾರಿಗೂ ಒಂದು ಕೊಟ್ಟಿದೀವಲ್ಲ ಒಂದ್ ಫ್ಲಾಟ್ ಅನ್ನ. ಈ ಇದ್ರಲ್ಲಿ ಏನಾದ್ರು ಕೊಟ್ರೆ ನೋಡೋಣ. ಈ ಇದ್ರಲ್ಲಿ ಏನಾದ್ರು ನೀವು ರಿಸರ್ವ್ ಮಾಡಿ ಓನರ್ಸ್ ನೀವು ಯಾರ ಜೊತೆ ಜಾಯಿಂಟ್ ಡೆವಲಪ್ಮೆಂಟ್ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಿ. ಯಾರು ಓನರ್ಗೆ ಯಾರು ಅಪೇರ್ ಆಗೋದು? ನಿಮಗ್ ಜಾಯಿಂಟ್ ಡೆವಲಪ್ಮೆಂಟ್ ಅಗ್ರಿಮೆಂಟ್ ಬರ್ಕೊಟ್ಟವ್ರು ಯಾರು? ಅವರಿಬ್ರು ಹೇಳಿ.
We may have to seek instructions.
ಲಾಸ್ಟ್ ಒಕೇಶನ್ ಏನೋ ಮಾಡ್ತೀವಿ ಇಬ್ರು ಸೇರಿ ಅಂತ ಏನೋ ಅಂದ್ರಿ.
I was thought over, but I'll sit with them because they are large in number. Sit maybe learned.
Till then you stop the construction. Admittedly property belongs to the Kadirappa and they are daughters also. Their legal right cannot be curtailed.
I invested for nearly borrowing a loan from the different banks. Nearly 12 crores.
ಹಾಗಂತ ಹೇಳಿ ನೀವು ಇನ್ವೆಸ್ಟ್ಮೆಂಟ್ ಮಾಡಿದಿರಿ ಅಂತ ರೈಟ್ಫುಲ್ ಓನರ್ಸ್ ರೈಟ್ ನ ಕಟೈಲ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಕೌನ್ಸಿಲ್.
But the question of will being known to him is in the joint development agreement which he has produced. And there is a recital that there is a will. Whereas Muni Kadrappa.
ಜಾಯಿಂಟ್ ಡೆವಲಪ್ಮೆಂಟ್ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ವಿಲ್ ಇದೆ.
Yeah.
ಆಯ್ತು,
There
ಇರ್ಲಿ
is a reference.
ಇರ್ಲಿ. They are not the parties to the said joint development
He has
agreement.
got the knowledge of the document. He could have challenged the will by filing in the suit itself. He could not have filed a suit for partition after knowing that there is a joint development agreement. And a will is notified in the joint development agreement itself.
ಜಾಯಿಂಟ್ ಡೆವಲಪ್ಮೆಂಟ್ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ಇರ್ಬೋದು, ನೀವು ಅದು ಇಂಟರ್ಸೇ ಬಿಟ್ವೀನ್ ಯು ಅಂಡ್ ದಿ ಜಾಯಿಂಟ್ ಡೆವಲಪ್ಮೆಂಟ್.
No, no, the document of will is recited.
May be recited, that is the document inter-se between you and the joint developer.
Not the will
Maybe
of,
it is
will
stated
of
in the joint
Kadirappa
development
is
agreement.
made available in the joint development agreement.
ಆಯ್ತ್ರಿ, ಅದ್ರಲ್ಲಿ ಇದೆ, ಅದು ಇಂಟರ್ಸೆ ಬಿಟ್ವೀನ್ ಯು ಅಂಡ್ ದಿ ಡೆವಲಪರ್. That is not the, he is not the party to the joint developer agreement.
My lords may notice that he has the knowledge. When he has the knowledge of the joint development.
ನಾಲೆಡ್ಜ್ ಯಾವಾಗ್ರಿ? ಕೇಸ್ ಹಾಕಿದ್ಮೇಲೆ ಅವ್ರಿಗೆ ಗೊತ್ತಾಗಿದೆ.
yes, ma'am.
2021.
ಮುಂಚೆ ಕೇಸ್ ಹಾಕಿದ್ಮೇಲೆ.
Case ಹಾಕಿದ್ 2022 ಅಲ್ಲಿ.
ಆಯ್ತು.
He takes the certified copy of the joint development agreement.
ಹೌದು.
He must have read the joint development agreement.
ಜಾಯಿಂಟ್ ಡೆವಲಪ್ಮೆಂಟ್
When
ಅಗ್ರಿಮೆಂಟ್
he read it, he has the document
he
also.
is not a party to the joint development agreement. How can you bind him? If he is not a party to the joint development agreement, how can you bind him?
We get the title.
Maybe there is a recital in the joint development agreement. But they are having a right over the property.
But the right arises only on the will.
Will ಅಲ್ಲ, ಅಪ್ಪ ಸತ್ತಿದ್ದಾರೆ. According to you, there is a will ಅಂತ.
Yes.
Now he comes to know about the will. The question of will, validity of the will also to be proved before the court.
Yes, bill.
That has to be proved.
But there is not
Under
one
section
recital,
63 and
but
68 of.
there are a couple of recitals mentioned. He has read the document. It's a register.
ಆಯ್ತ್ರಿ, ರೆಡ್ ಆಯ್ತು, ಬಟ್ ನೀವು how can you enter into an agreement excluding the sisters? It is not an exclusive property of you. ಹೇಳಿ ಬೇಗ.
Submission.
And also this court appointed a commissioner also.
Yes,
Commissioner.
my lord. Commission report has been submitted in
And
this
you
case.
also cannot say that you go and take the property in the Karab land.
No,
And
it is-
we will enjoy the property for the other property and take the property in Karab land.
No, it
that
is
cannot
not
be
the
a-
Karab land, my lord.
ಮತ್ತೆ?
It is not the Karab land.
It's not a canal.
Karab land and ನೀವೇ ಈಗ will ರೆಫರ್ ಮಾಡ್ತೀರಿ.
Yes, my lord, there is a extent,
development
my lord, there is certain extent of Karab land.
Argues that no, this pink color land is Karab land, the property comes there in as per the will anta. You cannot go hot and cold.
My lord, total extent remaining 22 guntas comes in the violet color, my lord, which has been shown. by
ಹೌದ್ರಿ,
my-
ಅದನ್ನೇ ಖರಾಬ್ ಲ್ಯಾಂಡ್ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು ಈಗ.
My lord, it is not totally
There is-
20, it is a
Ah.
portion of that, it is a Karab.
ಆಯ್ತು, ಆ ಲ್ಯಾಂಡ್ ಬೇರೆಯವರು ಕ್ಲೈಮ್ ಮಾಡ್ತಾ ಇದಾರೆ, ಹಾಗಂತ ಹೇಳ್ಬಿಟ್ಟು ನೀವು ಡಿಸ್ಪ್ಯೂಟ್ ಇರೋ ಜಾಗಕ್ಕೆ
My lord, as per the will,
ತಳ್ಳಿಬಿಟ್ಟು ನೀವ್ ಎಂಜಾಯ್ ಮಾಡಕ್.
no, it is not that, my lord. It is not that, my lord.
Let the court decide it, that's all.
Please, my lord, I may permit to file my objections, my lord. Today only I filed my power.
ಏನ್
That is a-
objection sir?
Just till Monday, my lord.
ಆರ್ಡರ್ ಇದೆ ಅಷ್ಟೇನೆ, that's all.
My lord, it
Yes.
is,
ಅಲ್ಲಿವರೆಗೂ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ನಿಲ್ಸಿ, ಆಮೇಲೆ ಕ್ಲೈಮ್ ಮಾಡೋದ್ ಬೇಡ.
it may be taken up Monday, my lord, by the time.
ಈಕ್ವಿಟಿ ಅಂತ ಆಮೇಲೆ ಕ್ಲೈಮ್ ಮಾಡೋದ್ ಬೇಡ.
No, it is not that, my lord, it is.
This is the status of the building now. ಹೌದಾ?
ಖಾಲಿ ಇತ್ತು
ಫೋಟೋಸ್
ಸ್ವಾಮಿ.
ಹಾಕಿದೆ ಈಗ.
ಒಂದು ತಿಂಗಳಿಂದ
ನ್ಯೂಸ್ ಫುಟ್ ಹಾಕ್ದ ಖಾಲಿ ಇತ್ತು ಈಗ.
ಇಲ್ಲ ಇಲ್ಲ ಸ್ವಾಮಿ, ಹೈಕೋರ್ಟ್ ಮುಂದೆ ಮೊನ್ನೆ ಬಂದಾಗ್ಲೂ ಸಹ ಬರೀ ಫಸ್ಟ್ ಫ್ಲೋರ್ ಇತ್ತು, ಈಗ 4 ಫ್ಲೋರ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಹೌದಾ? ಆಯ್ತು, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
It is,
ಹಾ. ಹಾ, ಹಾ, ಇರ್ಲಿ. ಹಾ.
What I said, my lord, they let them know they examine the review of the and also.
ಅಲ್ಲ, let them examine it, you stop the work till then. That's all.
Borrowed in fact, but
ಆಯ್ತು, that is interest between you and the owners. Maybe you have borrowed the money and joint development. Joint development is also for your benefit also. You are not developing the property without any
sketch or
profit. Prima facie admittedly they are the daughters of original owner. ಹೌದಾ? They are having a right over the property, whether in terms of the will or in terms of the right of the property, that has to be decided before the trial court.
my lord, my respectful submission, as per the will, the land earmarked for the daughters has been clearly shown, my lord. As per the sketch which has been produced by the,
will ನಮ್ಗೆ ಗೊತ್ತೇ ಇಲ್ಲ will ಅಂತ ಹೇಳ್ತಾರೆ.
when they have not challenged the will itself, my lord, they, when,
ಚಾಲೆಂಜ್ ಮಾಡಕ್ ಈಗ ಗೊತ್ತಾಗಿರೋದು ಅವ್ರು ಸೂಟ್
not now, my lord, they know that suit for partition. They have not challenged the will, knowingly well that there is a will, they have not challenged the
for
purpose.
partition.
And moreover, my lord, the suit is only for the vexatious purpose has been filed at this stage. My lord, now the construction is going on. Now at this stage, they came up with awakened claiming the after lapse of 20 years that there is a land piece of land in our.
ಖಾತಾ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದು ಯಾವಾಗ ಹೇಳಿ?
Well, it has been passed, soon after that it has been passed.
Before entering into the JDA. ಹೌದಾ? Will of the year
Yes, ma'am.
1998.
Yes, ma'am. It is a registered will.
Will came to the light only in 2021 or 22. ಹೌದಾ?
For the purpose of sanctioning of the plan and all that.
ಬಿಲ್ ಆದ್ಮೇಲೆ 2022 ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
Well, they were in position, when the matter was, they wanted to entrust the matter for the JD.
ಈಗ ಅವ್ರಿಗೆ ನೀವು ಈಗ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಕ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ಮೇಲೆ ಬಂದಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಿರಲ್ಲ, ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದೆ.
Yes, ma'am. My lord,
ಬಿಲ್ ಆದ್ರೆ 22 ವರೆಗೂ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
my respectful submission, the boundaries shown in the
council
page number 12 of the.
prima facie they are the.
I may have given one opportunity, my lord, to make submission, my lord.
They are having a right over the property.
My lord, page number 12 of the will, may kindly we see the property which has been allotted to the daughters. Only one point, my lord, that itself crystallized the dispute. Page number 12 of the will. My lord, in the middle, my lord, ನನ್ನ ಮೊದಲನೆಯ ಮಗಳಾದ ದಿವಂಗತ ಮೋಟಮ್ಮನ ಮಕ್ಕಳಾದ 1ನೇ ಕುಮಾರ್ 2ನೇ ಅಶ್ವಥ್ ಇಬ್ಬರಿಗೂ ಸೇರತಕ್ಕ ಆಸ್ತಿಯ ವಿವರಗಳು. ಪೇಜ್ ನಂಬರ್ 12, my lord.
ಹೌದು, ಅದನ್ನ ಅವರು ತೋರಿಸಿದ್ದು.
Yes, my lord. ಪೂರ್ವ ಪಶ್ಚಿಮ 80 ಅಡಿಗಳು, ಉತ್ತರ ದಕ್ಷಿಣ ಕಾಲೇಜ್. ಪೂರ್ವಕ್ಕೆ, my lord, now the only one point. ಪೂರ್ವಕ್ಕೆ what is there? ಮುನೇಶ್ವರ ಸ್ವಾಮಿ ದೇವಸ್ಥಾನದ ಜಾಗ. Might kindly see the sketch, my lord, which has been produced with the survey report. The survey report, the temple is also here identified it. Whereas the construction is going on, joint developer agreement is going on, may kindly look into where it is going on. It is away, my lord.
ಇವ್ರು ಬಂದಿಲ್ವಾ ರೆಕಾರ್ಡಿಗೆ? ಈ ಯಾರೋ ಮೊದಲನೇ ಮಗಳಾದ ದಿವಂಗತ ಮೋಟಮ್ಮನ
ಬಂದಿದ್ದಾರೆ.
ಅಡ್ವೊಕೇಟ್ ಬಂದಿಲ್ಲ, ಪಾರ್ಟಿ ಬಂದಿದ್ದಾರೆ. ಅಡ್ವೊಕೇಟ್ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿಲ್ಲ.
ಇನ್ನು ನೋಟಿಸ್ ಜಾರಿ ಆಗಿಲ್ಲ.
ನೋಟಿಸ್ ಜಾರಿ ಆಗಿದೆ, ಲಾಯರ್ ಇಟ್ಕೊಂಡಿಲ್ವ ಅವರು?
ಇಲ್ಲ, ನಮಗೂ ಸಹ ನೋಟಿಸ್ ಜಾರಿ ಆಗಿಲ್ಲ.
ನೋಟಿಸ್ ಜಾರಿ ಆಗಿಲ್ಲ,
ನಮಗೂ ನೋಟಿಸ್ ಬಂದಿಲ್ಲ.
ಪ್ಲಸ್ ಅವ್ರ ಅಪಿಯರೆನ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ.
My voluntary, I am appear before this court. And my lord, as per this sketch, my lord, survey report ಏನ್ ಮಾಡಿದ್ದಾರೆ, ಟೆಂಪಲ್ ಇಟ್ ಕ್ಯಾನ್ ಬಿ ಐಡೆಂಟಿಫೈಡ್ ಬೈ ಪರ್ಪಲ್ ಕಲರ್ ಅಲ್ಲಿ ಕಾಣ್ತಾ ಇದೆ. ಈ ಬೌಂಡ್ರಿ ಸಹ ಕಾಣ್ತಾ ಇದೆ, ಮುನೇಶ್ವರ ಸ್ವಾಮಿ ದೇವಸ್ಥಾನ ಈಸ್ಟ್ ಬೈ ಅಂತ ಹಾಕಿದ್ದಾರೆ ಅವರು. My lord, the property then here marked is for the plaintiff is here, not here, my lord.
This will cannot be looked into.
My lord, they have to establish the prima facie case before granting.
Is that they are the daughters of.
No, that is in not dispute. You are not disputing the relationship. You are not disputing the relationship, my lord. The identification of the property is in dispute. You are not saying, my lord. You are not saying that our property ಕೊಡಬಾರದು ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ.
There is a partition. How can you proceed with the construction, entering into a joint development agreement, council?
My lord, I am not.
Also, this will comes to light only in 21-22 for making of kata.
No.
Though you are relying upon this will of the year 1998, 18/3/1998.
It is a registered will, my lord. Once it is a registered, it is a public document.
Public document ಆಗ್ಬಿಟ್ರೆ ಬರ್ಬೇಕಲ್ಲ ಬೆಳಕಿಗೆ.
My lord, they have to come, my lord. It is not that I have to. When they have, my lord, when they wanted to seek.
ಆಯ್ತು, you file detailed objection statement. In the meanwhile,
Monday I will file it, my lord. I will file it Monday itself.
On Monday. Till then, my lord, we will.
ಮೊನ್ನೆ ನಾವು ಸ್ಟಾಪ್ ಮಾಡಿ.
ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಅದು.
ಮೊನ್ನೆನೆ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಸ್ಟಾಪ್ ಮಾಡಿದ್ರೆ ಅವ್ರಿಲ್ಲ, ನಾವು ಮಾತನಾಡ್ತೀವಿ, ನೆಗೋಷಿಯೇಟ್ ಮಾಡ್ತೀವಿ. We'll come with negotiation ಅಂತ ಹೇಳಿದ್ರಿ. ಇವತ್ತು ಬಂದು
The landowners are before the court. So let me taking forward, it may be taken, let them look into it.
ಆಯ್ತು, ನಾಳೆ ಹಾಕೋಣ.
2:30 ನಾಳೆ.
Let them
please
make a stay.
This background of the argument of the both the sides and the what you are lacking.
ಕೂತ್ಕೊಂಡ್ ಮಾತನಾಡ್ರಿ. ಅವರು ನಿಮ್ಮಂಗೆನೆ ರಕ್ತ ಹಂಚಿಕೊಂಡು ಹುಟ್ಟಿರೋರು ಅವನಿಗೆ. ಹೆಣ್ಮಕ್ಳಿಗೆ ಒಂಚೂರು ಕೊಟ್ರೆ ಏನಾಗ್ತದೆ? ಮತ್ತೆ
I'll insist upon.
ಅಲ್ವಾ? ಅವರು ನಿಮ್ ಮಕ್ಳೇನೇನ್ ಬೇರೆಯವ್ರಿಗೆ ಕೊಡ್ತೀರಿ? ಇಲ್ಲಲ್ಲ, ಕೊಡಿ. ಅವ್ರಿಗೂ ಹಕ್ಕಿದೆ, ಕಾನೂನು ಪ್ರಕಾರ ನೀವು ಕೊಡಿ ಅಷ್ಟೇ. ಸಿಟ್ ಟುಗೆದರ್. ಸ್ವಲ್ಪ ಹೆಚ್ಚು ಕಡಿಮೆ ನೀವಾದ್ರೂ ಅಷ್ಟೇನ್ರಿ? ನಂಗೆ ಇಷ್ಟ ಬೇಕು, ನಂಗೊಂದು
ನಾವು ಆತರ ಕೇಳಿಲ್ಲ.
ಸಿಟ್ ಟುಗೆದರ್ ಅಂಡ್ ಟೇಕ್ ಡಿಸಿಷನ್. ಅವ್ರನ್ನ ಓಡಿಸ್ಬಿಟ್ಟು ಅಲ್ಲಿಂದ ನಾವು ಕಟ್ಕೊಂಡು ನಾವು ಎಂಜಾಯ್ ಮಾಡ್ತೀವಿ ಅನ್ನಕ್ಕಾಗಲ್ಲ. ತೊಗೊಳ್ಳಿ. Heard the matter in part again. And both council submits that matter may be listed tomorrow and hence list this matter tomorrow.
2:30, madam.
Time fix ಮಾಡೋದಿಲ್ಲ ನಾನು. No 2:30.
40 R.B. Sadashivappa, Rakesh B. Bhatt.
ಇಲ್ವಾ? Heard in part. ನೋಟ್ಸ್ ಇದೆಯಾ ಮೇಡಮ್? ಇಲ್ವಾ? ಎಸ್.
Route for declaration, easementary right, my lord.
Easementary right.
Please, my lord. Pension is granted again, challenging that, my lord, appeal is filed by the court.
Yes, let him argue.
My lord, I submitted one.
Parted ಆಗಿದೆ. Interference with plaintiff using the suit E schedule road to enjoy their suit B to D schedule properties. Also restrain the defendant, his agents or anybody acting through them from interfering with plaintiff's peaceful possession and enjoyment of the C schedule property pending disposal of the suit. Yes,
Last date of hearing, my lord, I had given the plain copy, my lord. Wherein, my lord, the partition deed, my lord, was,
ಅದೇನ ಇತ್ತು ಸ್ವಲ್ಪ
Please,
ಕೇಳಿದ್ವಿ. ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಅಲ್ಲಿ ಏನೋ ಫೋಟೋಸ್ ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರಿ, ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ಇತ್ತು ನೋಡಿದ್ವಿ. ಎರಡಿದೆಯಾ? ಆಯ್ತು. ಎಸ್ ಕೌನ್ಸಿಲ್ ಹೇಳಿ.
Yes, madam. My lord, may kindly take up the second one, 56-55 of 20. It is not in dispute, my lord, I am the owner of the land bearing survey number 59/24. ಅದು ಒಂದು. According to them, there is a road running through my land, which is being disputed. All the documents show, except the partition deed which my learned friend referred to, it is only private road when all the properties were together and there was a joint family. Subsequently, my lord says that the partition deed is of the year 2003. 16/10/2003. In which the particular land fell to the 59/1 fell to the share of Srimati Venkata Varalakshmi. Now this land in toto, that is 4 acres and odd, together was sold in favor of one Srimati D.G. Girija under registered sale deed dated 28/5/2011. In the said sale deed, there is no reference to the road. Srimati Girija in turn sells it to two persons. That is to the plaintiff and to the defendant.
Total extent of 4 acres.
4 acres.
Sold on what date?
Sold, my lord, on 28/5/2011.
11. But Girija purchased on what date?
No, Girija purchased on that date, 28/5/2011.
The Girija, 28/5/2011, sold in favor of plaintiff and defendant on what date?
Both are on the same date, 20th/4/2018.
18.
Yes. So here, 1 acre 33 guntas was sold in favor of Mr. Satish, who is the present appellant before my lord.
1 acre?
1 acre 33 guntas, including 9 guntas of Kharab. In the remaining 2 acres 15 guntas was sold in favor of the defendant, respondent, Mr. Puttaraju. In these two sale deeds also, there is no reference to the road. Then what happens? The appellant before my lord agreed to sell this land in favor of the defendant only. That is under agreement to sell dated 14/8/2021. And in that agreement also, there is no reference to the road which they claim easementary right now.
And now the respondent has filed a suit for specific performance based on that agreement. In that suit also, while giving this schedule, he has not referred to the road. So all through from 2011, I may say with great respect till today. So several transactions have taken place, but nowhere there is reference to the road. Is my respectful submission. I may invite my lord's attention to the, and secondly, the land was converted. While passing the conversion order, OD work, this, that, and all that, my lord, road is not shown all through.
In which year land was converted?
Converted, my lord. That is in 2023, 6/6/2023. Therefore, in all these documents, when there is no existence of any road, whether a road said to be in my land can said to be a public road on which he can have an access. Secondly, I have pointed out last time from referring to the sketch that for his lands, there are roads all through 3 sides. So he need not depend upon presuming for the sake of argument that there was a road. He need not have access to this road to reach his land. May I invite my lord's attention to the sketch.
Sketch. ಯಾವ್ದು ಹಾಕಿರೋದು ಯಾವಾಗ ಹಾಕಿದಿರಿ?
ಸರಿ ತಾವು ಕೋರ್ಟಲ್ಲಿ
ಹಾಕಿದ್ರಿ ಯಾವಾಗ ಹಾಕಿರೋದು?
ಅಲ್ಲ ರೀ, ಇಲ್ಲೇ ಕೋರ್ಟಲ್ಲಿ ಕೊಟ್ಟರೆ.
ಜಾಯಿನ್ ಮಾಡ್ಬಿಟ್ಟಿರ್ತಾರೆ ಮೇಡಮ್. ಇದೆಯಾ ನೋಡಿ ಸ್ಕೆಚ್. ಫೋಟೋಗ್ರಾಫ್ ಇದೆ.
ಅಲ್ಲ, ಈ ರೀತಿ ಒಂದು ಸ್ಕೆಚ್ ಕೊಟ್ಟಿದ್ದೇವ್ರಿ. ಈ ಸರ್ವೆ ನಂಬರ್ಸ್
ಸಪರೇಟ್ ಆಗಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಹೌದು, ಸಪರೇಟ್ ಆಗಿ.
ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ತೋರಿಸ್ದಾಗಿತ್ತು, ನೋಡಿದೀನಿ. ನೋಡಿ ಅದ್ರಲ್ಲಿ ಇದೆಯಾ?
Further, my lord, the respondent now is not the owner of that land at all, which he claims that he is on the other side of this particular road. He has sold already 8 sale deeds are there. ನಮಗ್ ಬೇಕಾಗುತ್ತೆ.
ಒಂದು ಎಕ್ಸ್ಟ್ರಾ ಇದ್ರೆ ಕೊಡಿ.
While selling these plots, also, he has not referred to the road which is the subject matter of the case.
The 59/24 is plaintiff,
ಹೌದು, plaintiff 59/4. ಅಲ್ಲ, 59/24.
24 is defendant.
ಇಲ್ಲೇನ ಬರ್ದಾಗ plaintiff defendant
59/1 was
ಈ ಪ್ಲಾಟ್ ಯಾರು?
belongs to the defendant.
Is the defendant?
Please, my lord. Next to that, my lord, adjacent to that belongs to the plaintiff.
ಯಾವುದು 29/1?
59/1, my lord. Both had purchased 59/1. It was coded and his name, his survey number was renumbered as 59/24. My survey number is still shown as 59/20, 59/1.
59/1.
59/1, which is adjacent to his.
ಇದೆಯಾ? ಕೊಡಿ ಕೊಡಿ. ಈ ಪುಟ್ಟರಾಜು ಟಿ ಯಾರದು?
Plaintiff.
ಅದು ನೀವೇನಾ? ಪುಟ್ಟರಾಜು ಟಿ 59/2.
59/2.
ನಿಮ್ದೇನೆ?
Please, my lord, but the sketch, my lord, I dispute the sketch.
ಈ ಸ್ಕೆಚ್ ನೀವು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತಾ ಇದೀರಾ?
I dispute that sketch. With respect to the actual position which is there. And based on all the documents that they themselves are, I seek to produce certain photographs and sketch, my lord. As to the actual existence, what it is there.
ಈಗ ಆಲ್ಮೋಸ್ಟ್ ಸುತ್ತ ಎಲ್ಲ ನೀವೇ ಇದ್ದೀರಾ ಪುಟ್ಟರಾಜು?
No.
It has been sold.
ಸೊ ಸೇಲ್ ಮಾಡಿದಿರಿ?
Sale like. If in the memo, if it is seen.
He has sold about 6 plots, my lord, already.
ಅಲ್ಲ, ಮಧ್ಯದಲ್ಲಿ ಅವತ್ತೇನ ಈ ರೋಡ್ ಫೋಟೋ ತೋರಿಸಿದ್ರಿ?
Photograph. Second, kindly see the second photograph. Is there. My lord, what they are saying,
Hmm.
my lord, there are two road, my lord, which is
Hmm.
there.
Hmm.
The left side, my lord, it is 59/24
Hmm.
belonging to the defendant. Next to that is 59/1.
Hmm.
There is a road which goes straight there.
Hmm.
Next to that is 59/2.
Hmm.
This 59/2, my lord, is sold in favor of various other persons.
Hmm.
Though I own 59/6, that is the front portion of the property.
Hmm.
There is also road in existence here also.
Hmm.
Two roads go.
Hmm.
Now what they say, my lord, this road, what is there between 59/1, earlier 59/1 and 59/2,
Hmm.
which even now, my lord, if court commissioner is appointed, my lord, concrete road is there which goes and joins there.
Hmm.
Now they say that road is not in existence.
Hmm. Hmm.
This is the road, my lord, if it is seen, that
road.
road is there even now, which goes along his property and my property.
Now they are causing obstructions to
Please.
usage of this road.
Usage of
Antana?
this road.
That is
Because-
your case.
Please, my lord. And at last I have produced the sketch,
Hmm.
which is there.
Hmm.
The main public road, what they are mentioning, my lord,
Hmm.
is it this side, my lord. Next to that, two roads are there.
Hmm.
Now, their contention is that
Hmm.
since you have a road on the
Public road.
public, next to public road, my lord, this is the property which we
Hmm.
own. 59/2 is owned by defendant herein.
Hmm.
59/24.
Hmm.
Next to that, my lord, 59/1,
Hmm.
my lord, belongs to plaintiff.
Hmm.
Both of us have purchased this property through common vendor.
Common vendor.
59/2
Hmm.
belong to another sharer of the property and under the partition deed, my lord, of 2003, under which, my lord, all this property belong to the same family.
Hmm.
This 59/2 was purchased by us.
Hmm.
This, my lord, farmland, we wanted to sell it as a farmland,
Hmm.
and in respect of various persons, it has been sold.
Hmm.
At the time of selling this property, there is another road which is formed for our benefit,
Hmm.
and that totally two roads joins to all the property.
Hmm.
Now, this is the actual position of what actually it is there.
Hmm.
But with respect to the road which is formed between 59/1 and 59/2,
Hmm.
it was an easement by express grant which was made amongst the sharers, my lord, that is in the partition deed itself.
Hmm.
What is referred another 59/2, another road, what they are mentioning now, which is also in existence.
Hmm.
It is a newly formed road which for the benefit of all other persons, because it has been sold in favor of various other persons, this as a farmland.
Hmm.
Now, my lord, what I am claiming is that there is a road in existence,
Hmm.
which is an express grant. This road is there. There is a concrete road which is in existence, because he is in the, at first, my lord, at the entrance of the property,
Hmm.
there is a gate which is formed.
Ah.
He is causing obstruction for that,
Using of the said road.
using of the said road, and hence I filed this suit for declaration.
Hmm.
Now, and senior counsel mentioned, my lord, that there is no reference of road except for the partition deed.
Yes.
I will show all the deeds, my lord, everywhere this road was there,
Hmm.
in all the deeds.
Hmm.
Except for one deed, my lord, in respect of my vendor, I admit that in my vendor sale deed, it had not come. But
Hmm.
at the time of my vendor selling this property in favor of me and the defendant, at that point of time also existence of road is there.
Hmm.
And then other documents which is produced along with the memo,
Hmm.
with respect to the sale deeds which I have executed in favor of various other persons, with respect to survey number 59/2,
Hmm.
to show that there is a road in existence after 59/2 also, my lord.
Hmm.
Even that, my lord, in that there is a, this road is also shown.
ಆಯ್ತು, ಈ ರೋಡ್ ನೀವು ಡಿಸ್ಪ್ಯೂಟ್ ಇರೋದು ಈ ರೋಡಿಗೆ, ಮಧ್ಯದ ರೋಡ್,
ಮಧ್ಯದ ರೋಡಿಗೆ,
ಇದ್ರಲ್ಲಿ ಮಧ್ಯದ ರೋಡ್ ಇದೆ.
ಮಧ್ಯದ ರೋಡಿಗೆ
ಯಾವ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ಬರುತ್ತಾ ರೋಡ್?
59/1 ಮತ್ತೆ 59/2 ಮಧ್ಯ.
ಎರಡು ಸೇರಿ ಮಧ್ಯ ಆಯ್ತು. ಬಟ್ ಇದು ಆಮೇಲೆ ಮಾಡ್ಕೊಂಡಿರೋ ರೋಡ್,
ಆಮೇಲೆ
ಯಾವ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ಬರುತ್ತದು?
ಆಮೇಲೆ ಮಾಡ್ಕೊಂಡಿರೋ ರೋಡ್ ಅಲ್ಲ ಸರ್. ಇಫ್ ದರ್ ಫೋಟೋಗ್ರಾಫ್ಸ್ ಇಸ್
ದೇರ್ ಆರ್ ಟೂ ರೋಡ್ಸ್ ಅಲ್ಲೇನ್ರಿ? ಆ ಕಡೆ ಒಂದಿದೆ, ಈ ಕಡೆ ಒಂದಿದೆ. ನೀವು ಹಾಕಿರೋದೇ
that joins, my lord. That next to that what is there, it is not a road. ಅದು ರೋಡ್ ಅಲ್ಲ, ಅದು ಮುಂದೆ ಹೋಗಿ ಅಲ್ಲೇ ಸ್ಟಾಪ್ ಆಗುತ್ತೆ. That is not a road.
ಮತ್ತೆ ಇನ್ಯಾವ ರೋಡ್?
In next
ಈ ರೋಡಾ?
ಈ ರೋಡ್. What they say, this comes in 59/2.
59/2.
59/2. It is towards the end of that 59/2. The dispute is between us is the middle road which is in there.
ಅದೇ ಮಿಡಲ್ ರೋಡ್ ಈಗ ಮಧ್ಯದಲ್ಲಿ ಇದೆ.
That comes under 59/1.
59/1.
59/1.
versus
Hmm.
59/24.
My lord, our land is 59/24.
ಅದೇ
59/24 ಅದು ರೀ-ನಂಬರ್ ಆಗಿರೋದು.
renumbered as
Earlier it was 59/1 only.
ಅಲ್ಲ, ರೀನಂಬರ್ ಆಗಿರೋದನ್ನೇ ನಾನು ಹೇಳ್ತಾ ಇರೋದು 29/24 ಆಫ್ಟರ್ ಕೋಡ್.
ಅದೇ ಆಫ್ಟರ್ ಕೋಡ್ 59/24 ಆಗಿದೆ.
ಆಯ್ತು, ಅವ್ರದ್ದು 29/1 ರಿಟೈನ್ಡ್.
ಅದು ರಿಟೈನ್ ಅವ್ರದೇ ಇನ್ನೂ ಇದೆ 59/1 ಇದೆ.
ಈಗ ಅವ್ರೇನ್ ಕೇಳ್ತಾ ಇದಾರೆ 59/2 ಏನಿದೆ ಕೆಳಗಡೆ,
ಹಾ.
ಇದ್ರಿಗೆ ಉತ್ತರ ದಿಕ್ಕಿನಲ್ಲಿ ರೋಡ್ ಇದೆ, ಅಂದ್ರೆ ನಮ್ಮ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ರೋಡ್ ಇದೆ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. ಹಾಗೆ ರೋಡ್ ಇರ್ಬೇಕಾದ್ರೆ ರೆವಿನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್ ಇಷ್ಟೊಂದು ನಾವು ಹಾಜರುಪಡಿಸಿದ್ದೇವೆ. ಯಾವ್ದನ್ನ ಒಂದರಲ್ಲಿ ರೋಡ್ ತೋರಿಸ್ಲಿ ಅವರು. There is no road. As I submitted to my lord, except in the partition deed of the year 2003. Subsequently, there are sale deeds including mine and his. There is no reference to the road. Further, he has sold
But in the 2003 document ಅಲ್ಲಿ ಈ ರೋಡ್ ಬಗ್ಗೆ ಪ್ರಸ್ತಾಪ ಇದೆಯೇ ಇಲ್ಲ?
ಅದೇ ಪ್ರಸ್ತಾಪ ಏನಂತ ಇದೆ, ಎಲ್ಲರೂ ಯೂಸಿಗೆ ಬೇಕು ಅಂತ. ಅಂದ್ರೆ ನಾವು ಎಲ್ಲಾನು we are all the members of the family.
Because they all belongs to the same family.
Yes. Now having sold, my lord, whether it can be still said, no, it shall be used for the persons other than who have purchased from me or from others. Now he has admittedly sold other 8 plots already. I have produced sale deeds also. In that sold sale deeds also, there is no reference to this road on the northern side.
Our sale deed ಅಲ್ಲಿ mention ಮಾಡಿಲ್ಲ.
They have produced this document. When you take the document produced by them, list of documents, they say that allegedly that I have executed those sale deeds. Memo, my lord, dated 16/12/2024. Everywhere that reference is there, my lord. Page number 18, my lord, is apologies, my lord. The next.
ನೋಡಿ, ಕನ್ವರ್ಷನ್ ಆರ್ಡರ್ ಜೊತೆ ಒಂದು ಪ್ಲಾನ್ ಕೊಡ್ತಾರೆ ಅವರೇ ಆಫೀಸರ್ಸ್. ಅದರಲ್ಲೂ ಸಹ ಆ ರೋಡ್ ಇಲ್ಲ. ದೆರ್ ಇಸ್ ಓನ್ಲಿ ಮೈ ಲಾರ್ಡ್ ಮೇ ಕೈಂಡ್ಲಿ ಪಾಸ್ ಲುಕ್ ಇನ್ ಟು ದಟ್. Just because, my lord, we did not execute the sale deed in his favor and a suit for specific performance is
Land is
filed.
not yet converted. It is still an agriculture land. I don't know, my lord.
Order,
I've not
no,
seen-
it is a converted land.
ಈಗೇನ ಕನ್ವರ್ಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಕನ್ವರ್ಷನ್ ಆಗಿರೋದಿಲ್ಲ, ಅದನ್ನೇ ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
Order is there. Order ಇದೆ ರೀ ಹಿಂದ್ಗಡೆ.
ಅಲ್ಲ, ನಾವು I have filed this suit.
ಕೊಡಿ ಮೇಡಮ್.
ಕೊಡಿ ಸರ್ ನೋಡಿ. ತಗೊಳ್ಳಿ.
ಬೇಕಂದ್ರೆ
ಕೊಡಿ, ತಗೊಳ್ಳಿ ಸರ್.
No, next to that road is shown.
ಇಲ್ಲಿದೆ road.
Even in this sketch also road is shown.
ಅಲ್ಲಿ
I don't know
Still, sir.
regarding which property, my lord, it is 59/18 is what they're saying. Even kindly see, my lord, even in this document, road is shown. 59/24.
ಸೌತ್ ಬೈ ರೋಡ್ ಅಂತ ಇಲ್ಲ, ಸೌತ್ ಬೈ 7 numbers ಇದೆ.
Kindly see, my lord. 59/24.
South survey numbers only are there. No site, I mean. road.
Please. 59/24 and 59/1 adjacent to it, if that sketch is seen, a road is shown.
ಸರ್, ಚೆಕ್ ಮಂದಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಪಶ್ಚಿಮಕ್ಕೆ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ? ಐ ಮೀನ್ ದಕ್ಷಿಣಕ್ಕೆ 59/12, 13, 14, 15, 16, 17, 18 ಜಮೀನು. No road is shown on the southern side.
ಆ sketch ನೋಡಿ ಸ್ವಾಮಿ, ಮೇಲ್ಗಡೆ ಇರೋ sketch. What sketch is filed? 59/2 in a southern side and 59/1. ಅಲ್ಲೂ ಒಂದು ರೋಡ್ ತೋರಿಸಿದ್ದಾರೆ.
And in the sale deeds also, my lord, as I submitted, he has admittedly sold about 8 plots.
ನೀವ್ ಹೇಳ್ತಿರೋದು ಇಲ್ಲಿ ತೋರಿಸಿದಲ್ಲ ಅದು ರೋಡ್ ಅಂತನಾ?
That is
ಈ ರೀತಿ ತೋರಿಸಿರೋದು.
please, that is the road, my lord, on the southern side of 59/24 and 59/1. If my sketch is seen that I have produced, ನಾನು ಇದ್ ಮಾಡಿದ್ದು and photographs, and if that is compared, my lord, or even if someone is appointed now also, if it someone goes there and check, my lord, there is a concrete road which.
All right,
both property.
my learned friend says regarding commissioner, he wants to see that. I have no objection straight away.
ಅಲ್ಲಿ ಫೋಟೋಗ್ರಾಫಿ ಇದೆಯಲ್ಲ, ಮತ್ತೆ ಹಾಕ್ಬೇಕು.
ಅಲ್ಲ, ಫೋಟೋಗ್ರಾಫ್ ನಿಂದ ನನಗಾಗ್ಲಿ ತಮಗಾಗ್ಲಿ ಏನು ಗೊತ್ತಾಗಲ್ಲ. ಈ ಸ್ಕೆಚ್ಗಳು ಅವ್ರು ಏನ್ ಡ್ರಾ ಮಾಡಿರ್ತಾರೆ, I mean revenue officers, where my lord can find out. By photograph, how I can say that there is a road, and secondly, a road whether it could be said as a public road where he can use it. If I form my own road in my land to have access for the cultivation or this and that, he cannot claim access to my road, which is in my land. That is all the point for consideration. What I respectfully submit is the road which is shown in my land, it is for me. That road is found only in the 2003 partition deed, which fell to the share of Srimati Varalakshmi. She sells it in 2 bits, I mean, the entirety. In entirety, he sells it to Srimati Girija. There is no road shown. My lord could look into that sale deed. If it is a fact that it is a public road, one can have access, free access either to them or to me. The road should have been continued in the subsequent documents. 2011 document, which Srimati Girija sells it both to me and to him. Let him show that there is any road.
But no dispute with regard to the existence of road. Why court commission?
No,
has to be
existence
appointed?
of a road, whether it
According to you, that is in your survey number.
no,
and survey number 59/1.
only for my use within my land.
ನಿಮ್ದು ಏರಿಯಾ ಎಷ್ಟು ನೀವು ಕೊಂಡ್ಕೊಂಡಿರೋದು?
Now 2 acres,
1 acre 33
33 guntas, including of 9 guntas of Karab.
ಖರಾಬ್.
ಹೌದು.
ಈ ರೋಡ್ ಎಲ್ಲಿದೆ? ಖರಾಬ್ ಅಲ್ಲಿ ಇದೆಯಾ ಅಥವಾ ಬೇರೆ ಇದ್ರಲ್ಲಿ ಇದೆಯಾ?
ಅದನ್ನ ಪಟ್ಟ
33 guntas including Karab 9
Yes.
guntas.
Karabali ಇಲ್ಲ.
that, my lord, on the southern side of my land, in my own land.
ಅಲ್ಲ ರೀ, if it is the property is road is in existence in his property,
Please.
that is for his use. How can you claim the said road?
No, I am not claiming, it is not that he purchased the property. He formed road for his purpose. And then I am claiming that to go to my property, I want this road. So kindly see the sketch.
ಅಲ್ಲ
So,
road,
no, not for the sketch.
road formed in the land of the respondent.
No.
How can we
Survey-
claim the right,
survey num-
easement right also?
Survey number 59/1, survey number 59/2, and survey number 58, all were adjacent and was belonging to one
Belongs to the
family.
same family.
One family, yes.
When the partition was happening between survey number 59 and 59/1
All the
and
survey
59/2
numbers. 58, 59/1,
and
59/2.
59/2. My lord, at that point of time, 58 was behind, and my lord, to go to provide access to everyone, in between, 15 feet road was formed as per the partition deed. It is an easement by express grant.
ಅದೆಲ್ಲಿದೆ ಅಂತ ನಾ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
As partition deed, kindly take
Partition deed ಅಲ್ಲಿ
partition deed.
ಅವ್ರು ಹಾಕಿರೋದು
Refer that partition
copy
deed.
ನೋಡಿದ್ರೇನೆ ಗೊತ್ತಾಗುತ್ತೆ.
Kindly,
They have filed a suit against me with respect to my land, that is 59/24. They have not shown road on the southern side. Then how they could claim now that there is a road and a public road access to them,
I am,
easement right?
no, even in
Suit is
that I
filed by
have
them,
shown.
not by me.
Even,
So in the
even
suit-
that I have shown.
ರೂಟ್ ಅಲ್ಲಿ ತೋರಿಸಿದಿರಲ್ಲ.
ಸೂಟಲ್ಲೂ ತೋರಿಸಿದ್ದೀನಿ, ಸೂಟಲ್ಲೂ ರೋಡ್ ತೋರಿಸಿದ್ದೀನಿ,
ಅಗ್ರಿಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೇವೆ, ಅದರಲ್ಲೂ ಇಲ್ಲ.
ಅಗ್ರಿಮೆಂಟ್ ಒಳಗೂ ತೋರಿಸಿ.
ತಾವು ಹೇಳಿದ್ರೆ ಹೆಂಗೆ?
Everything, each and every document I will show, my lord. Kindly take document number 1, along with plain, my lord. Plain ನಾನೊಂದು ಕಾಪಿ ಹಾಕಿದ್ದೆ.
ಆಯ್ತು, ಪ್ರಿಂಟ್ ಕಾಪಿ ಇದೆ.
First, my lord, document number 1, page number 19 is the partition deed.
Partition.
ಕ್ಲೈಂಟ್ ಜೊತೆ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದೀರಾ?
ಹಾಕಿದ್ದೀನಿ. Partition deed ಒಳಗೆ I will show it first, my lord. Page number 30.
2003.
Please, my lord. Page number 39. It was amongst M. Shamanna and amongst their family members.
39.
37, my lord, is where that one portion goes to one Sriram. That is survey number.
ಶ್ರೀರಾಮ್ ರವರಿಗೆ
Please.
ಸೇರ್ತಕ್ಕ ಸೊತ್ತಿನ.
Please.
ಹಾ.
39, my lord, is what the relevant next. ಯಾವ್ದು survey number 59/2, measuring 7 acres 7 guntas.
39.
ಅದ್ರೊಳಗೆ 4 ಎಕರೆ.
7 ಎಕರೆ 7 ಗುಂಟೆನಲ್ಲಿ 4
ಉತ್ತರಕ್ಕೆ.
4 ಎಕರೆ. ಹಾ.
ಉತ್ತರಕ್ಕೆ.
ಉತ್ತರಕ್ಕೆ
15 ಅಡಿ ರಸ್ತೆ.
15 ಅಡಿ ರಸ್ತೆ ನಂತರ
ಡಿ ಶೆಡ್ಯೂಲ್ ದಾರರಾದ ಎಸ್ ಕಾಂತರಾಜು ಮತ್ತು
ಕಾಂತರಾಜು ಮತ್ತು ವರಲಕ್ಷ್ಮಿ ಅವರಿಗೆ ಸೇರಿದ
ಸ್ವತ್ತು.
ಹಾ.
There was a road on the northern side of survey number 59/2. Now kindly take page number 41. This is ಎಸ್ ಕಾಂತರಾಜ್ ಅಂಡ್ ವರಮಹಾಲಕ್ಷ್ಮಿ ಅವರಿಗೆ ಸೇರಿದ ಸ್ವತ್ತು, ಅವರಿಗೆ ಡಿ ಶೆಡ್ಯೂಲ್. ಅದಕ್ಕೆ ಪೇಜ್ ನಂಬರ್ 43. ದಕ್ಷಿಣಕ್ಕೆ.
ಒಂದೇ ನಿಮಿಷ. ವರಲಕ್ಷ್ಮಿ ಅವರಿಗೆ ಸೇರಿದ ಸ್ವತ್ತು. ಹಾ.
ಪೇಜ್ ನಂಬರ್ 43.
ದಕ್ಷಿಣಕ್ಕೆ
ಹ್ಮ್
ಅವ್ರಿಗೆ ಉತ್ತರಕ್ಕೆ 15 ಅಡಿ ರಸ್ತೆ
ಹ್ಮ್
59/2,
ಹ್ಮ್
59/1 ದಕ್ಷಿಣಕ್ಕೆ
ಹ್ಮ್
15 ಅಡಿ ರಸ್ತೆ. ನಂತರ ಸಿ ಶೆಡ್ಯೂಲ್ ದಾರರಾದ ಎಸ್ ಶ್ರೀರಾಮ್ ಅವರು. ಐ ಆಮ್ ನಾಟ್ ಸೇಯಿಂಗ್ ಇಟ್ ಇಸ್ ಎ ಪಬ್ಲಿಕ್ ರೋಡ್, ಇಟ್ ಇಸ್ ಅನ್ easement by express grant
them.
amongst family members which was there.
ಹಾ
Thereafter, this property
ಹ್ಮ್
was sold in favor of D. Girija.
ಹ್ಮ್
This D. Girija sold the property in favor of plaintiff and defendant herein. Kindly take document number 2, page 59. 74 is the relevant portion, my lord.
ಹ್ಮ್ 74.
Please, my lord.
ಹಾ
73 ಒಳಗೆ ಶೆಡ್ಯೂಲ್ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ.
73 ನ ಶೆಡ್ಯೂಲ್ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ.
1 acre 24 ಗುಂಟಾ 74.
ಸೇಲ್ ಇನ್ ಫೇವರ್ ಆಫ್
South by
ಗಿರಿಜಾ ಟು ಸತೀಶ್.
Girija to Satish.
ಸತೀಶ್ ಯಾರು?
That is the defendant herein.
ಡಿಫೆಂಡೆಂಟ್. ಹಾ
Page number 74.
ಹಾ
South by
ಹ್ಮ್
land bearing survey number 59/2 and private road.
ಹ್ಮ್
Private, yes, and private.
Now, their interpretation is that I have to see that 59/2 and thereafter this road is there
ಹ್ಮ್
and not this road.
ಹ್ಮ್
ಅಲ್ಲ ಅಲ್ಲಿ ಬರ್ದಿರೋದು ಆ ರೀತಿ ಇದೆ.
ಹ್ಮ್
ಅಲ್ಲ, ಅದಕ್ಕೆ
59/2 and private road.
private road ಅಂತ.
ಹಾ
So even then, my lord,
Kindly take
59/2
document
and
number
road
4.
on the southern side.
ಹ್ಮ್ ಸದರನ್ ಸೈಡ್.
On the southern
First
side.
is on the southern side of my property, not their property.
ಹ್ಮ್
If they had said
No.
road, my lord, on the
No,
northern
kindly
side
take-
of his property,
Kindly
it
document
is
number 4,
understandable.
page number 76. This is the remaining portion of the land which was sold by DJ Girija in favor of the plaintiff herein.
Hmm.
That is survey number 59/1.
ಹ್ಮ್
Page number 90 is the relevant extract, my lord.
ಹ್ಮ್ ಹ್ಮ್
91.
ಹ್ಮ್
South by land bearing 59/2 and private road, and west by, my lord, remaining portion of survey number 59/1.
ಹ್ಮ್
So that road was going across the property, that is on the eastern side, my lord, eastern portion of the land was sold in favor of the defendant herein,
Hmm.
and the western portion of the land was sold in favor of plaintiff.
ಹ್ಮ್
Now this road was in existence.
ಹ್ಮ್
I have produced photographs which shows, my lord, it is not 1 day or 2 days, now they have done. The trees are planted, my lord, which are more than 30 years old trees which are there.
ಹ್ಮ್ ಹ್ಮ್
Then, Lord, even in the agreement, they said that I have not, this agreement is not there. Document number 13, page 155, my lord, I have produced the agreement, which is executed by defendant in favor of plaintiff herein.
ಹ್ಮ್
158, my lord, is the relevant portion.
ಹ್ಮ್
South by
ಹ್ಮ್
59/2 belongs to Shriram, yes, and access road.
ಹ್ಮ್
In suit also, my lord, the next is the suit for specific performance I have filed.
ಹ್ಮ್ ಹ್ಮ್
164 is the relevant portion, my lord. There also in South by it is written.
59/2 and belongs to the access road.
Please, my lord,
Hmm.
and access road.
Hmm.
And now, my lord, along last date of hearing, various documents were produced before this honorable court
Hmm.
to say that I have sold various bits of land in survey number 59/2, which I purchased from Shriram, yes.
Hmm.
And even in that sale deed, I have not shown this access road,
Hmm.
is what the one of the allegations.
Argument.
Argument. My lord, kindly take the documents that is produced by them on 19/12/2024. List of documents, my lord, they have produced.
On 1912.
Please, my lord.
ಹಾ
Private access road and thereafter land bearing survey number 59.
Hmm.
Sketch producers.
I was an agreement holder from Shriram, yes.
ಹ್ಮ್
But page number 1, Shriram, yes, so, and along with the plaintiff herein sold in favor of one third party.
ಹ್ಮ್
Page number 17 is the
ಹ್ಮ್
north by
ಹ್ಮ್
private road and thereafter land bearing survey number 59/1.
ಹ್ಮ್ ಹ್ಮ್
Down, my lord, what is sold in favor of that particular person.
ಹ್ಮ್
There is a south by also private road access is there,
ಹ್ಮ್
and north by also there is a private road access and thereafter 59/1.
ಹ್ಮ್
So when I sold bits of land in survey number 59/2, that was owned by Shriram, yes. At that point of time, they had two roads, one on the northern side and another newly formed road that for their benefit, this is formed. Now, just because there is another road formed towards the southern portion of 59/2, that does not mean that easement by grant will extinguish. I'm not claiming as an easement of necessity. Even if I claim by easement of necessity also, my lord, I will get right over the property. Because if sketch is seen, I am not the owner of the entire survey number 59/2. It is sold in favor of various other person. And on the eastern side of my 59/1 is the land owned by the defendant herein, that is renumbered as 59/24. So all along, my lord, in actual usage also, there is a concrete road which was formed. And also, as per the document also, my lord, there was an easement by express grant which was there for our benefit. Now, my lord, they are obstructing that road, saying that it is a private road only for the benefit of 59/24 and not to the adjacent land which is there in 59/21, 59/1, my land. And other sale deeds also, my lord, they have produced. If all these sale deeds, my lord, if it is same schedule, my lord. South by also private access road is there, north by also private access road is there. The only interpretation now they are saying is that, my lord, because end is used, we have to interpret that there has to be 59/2 and thereafter road has to be shown. Boundaries, my lord, will not be decided on the basis of what is there thereafter. It is adjacent property, what is there, that is the boundary that is there. And the mother deed for all these documents is partition deed of the year 2003, because it is for the first time under that deed that express grant was made and 15 feet access road was provided to either of the parties. I have purchased from part of the property from one sharer and another sharer also. That does not mean that the access road which was formed between the sharers, that will get extinguished. Hence, my lord, it is after considering these aspects, my lord, that court granted injunction in my favor.
Access towards north and southern border.
Even the sketch, my lord, for the first date of hearing, my lord, they had given certain other sketch. Where also the road was not going, but there was a gate and there was road which was going in between. Next date of hearing, my lord, the sketch changed and that road itself is not shown.
Why there are two appeals?
My lord, what had happened? I have filed two injunction application. Survey number 59/2, which is the front portion of the property adjacent to him, my lord. Now, if for better understanding, my lord, if the photograph is seen, photograph, my lord, which I have produced. This property is owned by me. There is CCTV camera and everything which is there, a shed is there and everything. Can you take photograph number 2, my lord? This is my portion which I have retained. This property he was interfering and distracting the property. It is under those circumstances I have filed an injunction application with respect to that. That is also allowed.
In the very same suit.
In the very same.
Two IAS.
Two IAS. The trial court refers to all these documents in
Common order or separate order?
common order.
A number 1 and 2.
Please.
Yes, that's all.
Please.
Reply, Perry.
ರಿಪ್ಲೈ ಅಲ್ರಿ ನಮ್ದೇ ಆರ್ಗ್ಯುಮೆಂಟ್, ಯಾಕಂದ್ರೆ ಎಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅವರೇ ಮಾಡಿದ್ದಾರೆ.
ಆಯ್ತು ಹೇಳಿ, ನಿಮ್ದು ಕೇಳಿದೀನಿ, ನಾನು ಮಾಡಿದೀನಿ, ನೋಟ್ಸ್ ಮಾಡಿದೀನಿ ನಿಮ್ದೆಲ್ಲ.
But I respect the
I have shown that sort of.
The sketch is the main thing. According to this, on the northern side of my land is 58. No dispute. Dispute is with respect to my land on the southern side only. According to them, on the southern side of my land, there is a road which we disputed. Though road is there, it is for my private usage, not for anybody else. When whole land was a joint family property, when they partitioned it,
they might have said for access to other portions of the land, they could make use of this. But subsequent deeds do not indicate, though my lord repeatedly said road is shown. I will point out to you, my lord, from sale deed of Srimati Girija in favor of both of us. That will clinch the issue according to me. My lord may kindly take the sale deed of Srimati Girija in favor of the appellant, who is the defendant in the file. In that, my lord,
No road is shown anta.
no road is shown. On the other hand, on the southern side, it is shown survey number 59/2. 59/2 survey number, then private road. So this private road which they refer to 59/2, not for 59/24. Southern side. In the plan that is rough sketch produced by me also, we have shown on the southern side of 59/2, there is a road. That road leads to all these sub numbers, as could be seen from the sketch. Therefore, under the circumstances from the sale deed itself, it is evident 12 clear parcel. Kindly see on the northern side under the sale deed, it is shown as land bearing survey number 58. North land bearing survey number 58, south by land bearing survey number 59/2 and private road. Now, my lord may take to my sale deed also. Both are of the same date, 20th/4/2008. On the same day, she executes two sale deeds in favor of plaintiff and the defendant. In this also, my lord could see on the southern side, my lord finds same survey number 59/2 and private road. If there were to be a road in my land, 59/4, they could have said, inclusive of this road, or on the southern side, a road is there. It is not mentioned. So these are the basic documents on which my lord, myself and the defendant claim our title. If it does not disclose the road in between 59/24 and 59/2, where is the question of claiming any easement right on my land? By looking at the two sale deeds, that is 20th/4/2008, one in favor of plaintiff, one in favor of the defendant. Both are on the same date. Reference to the road in my land is not shown. Then I take my lord's attention to he himself, that is Mr. When they executed by executed by the plaintiff, Mr. Putraj, in favor of one Sri Ajit Lakshmanan. That is dated by note 15/12/2021. In that also, the one which he himself has sold. My lord finds in the clause 9 of the deed, it is stated, it is agreed between the parties that the 5 and 0.12 guntas of Schedule B property is inclusive of access towards the northern and southern boundary side measuring about 0.12 guntas of land, which is inclusive of that, they sell it. If it is in my land, according to them, and they have got an excess easementary or otherwise, it could not have been said inclusive of that my road, which is running into my land, could be a part of the sale deed. Kindly see, my lord, their schedule that is given also of this line. On the northern side, private road, land bearing survey number 59/1. South agricultural land belonging to Lakshmana. Yes. Then with respect to Schedule B also, my lord kinds on the north, private access and thereafter land bearing survey number 59/1. And south private access and thereafter land of survey number 59/5. Of course, number of survey numbers are there. They have given the schedules like this. In this number of sale deeds, all of them, about 5 or 8 sale deeds he has executed, about 5 guntas each perhaps, approximately. In no sale deed, it is mentioned that on the northern side of this land which he has sold, there is a road. In
Existence
59
of road.
Yes, 59/24. He does not say it. It clearly shows that there is no road in my land at all, and what road they are showing it by photograph is my own, in my land for my use. He cannot claim any access to my land, either easementary or otherwise, because he has got other access to his lands. If no access to his land, one can say, well, he is claiming some right because he has to move into his land and all that. In the absence of it, he cannot claim any right on the adjoining land as easementary right. His case is easementary right. Now, easementary right could be claimed by whom? By persons who are adjacent to my land, or those who had to move into my land only. Now, admittedly, when he has sold major portion of these 59/2, and there is a sketch, OD, and all that by the revenue authorities, I have produced that. Secondly, land which got converted also do not indicate existence of this road on the southern side of my land. That's it. And therefore, my lord, my respectful submission to my lord is, the suit as such, the prayer easementary right, is not maintainable, particularly when he has no land on the on the southern side of my land. There is no road at all which belongs to them, or who can have access to them. When they have got road on the western side, therefore 59/2, public road is there on the western side. And on the southern side of this, their own land, 59/2, my lord, another road, private road is there, which runs through all the portions of the land divisions, like 59/5, 59/2, 59/1, 59/8, 58/7, all these lands belong to them only. Where is the question of having easementary right on the land said to be, road said to be in my land? And secondly, I pointed out to my lord that in the specific performance that is suit filed by him in OS number 1001 of 2023, with respect to the land 59/24, that is my land, my lord do not find on the southern side any road. I take my lord's attention to the plaint that is filed by him. One can dispute anything, but not the plaint and the written statement filed in the court, which are court proceedings. Kindly see, my lord, the plaint that is produced by me. My lord finds it at page 75. This is filed by Mr. Putraj, who is the respondent. Against me, that is the appellant, Mr. Satish. Now the prayer is, where? 6498 is present. Acha, idu alla.
6498. One more suit. Other suit for specific performance. 159, 1001. That is for specific performance.
Oh, specific performance, so
Hmm.
that is between myself and the respondent here. Kindly see the schedule, my lord, which my lord finds it on page 164 in this book. On the southern side, survey number 59 part 2. This is my land in the sense of according to the sketch, mine is 59 part 24. On the southern side, 59 part 2. That is what we say. There is no road in between 59 bar 24 and 59 bar 2. Therefore, they write it here in the schedule. On the southern side, 59 bar 2 land belongs to Sri Ram, yes, and access road. Yes, on the next road, I mean, southern side, my lord finds the road. Not the one which they are claiming. So this is their own suit for specific performance, which is based on the agreement to sell between the parties only, not others. Therefore, they cannot dispute this is the schedule that is given in the agreement when they themselves give that schedule in the plaint for speaking specific performance. Under these circumstances, whether the suit for them for easementary right, having regard to the fact the about 5 or 6 sale deeds he has already executed, remains a very small extent of land perhaps for him. Under these circumstances, the impugned order I respectfully submit requires interference. If more clarity my lord feels required, as he suggests, I have no objection.
E road and public road ಅಥವಾ ಏನಿದೆ?
That is thereafter, because everything was there. With the concept of-
ಅಲ್ಲ ನನ್ನ ಪ್ರಶ್ನೆ ಇಲ್ಲೊಂದು ರೋಡ್ ಇದೆಯಲ್ಲ?
Next road.
ಹಾ.
ಅದು private road thereafter.
That is also a private road.
Private road without any document. But to say that the entire interpretation, my lord, because out of our daily. So the.
ಅಲ್ಲ this road also like similar road or different road?
Similar.
Similar. But whether this entire block belongs to you or no? No.
Sold in the.
ಅಲ್ಲ sold ಆಯ್ತು, but ಈಗ now you are claiming easementary right in respect of this property is concerned.
59 portion of the property.
ಈ ಕಡೆನಾ?
24 ಹಿಂದ್ಗಡೆ.
24 ನ ಬ್ಯಾಕ್ ಸೈಡ್.
Back side.
ಹಾ.
Because.
ಬಟ್ ಇದು 24 ಅಲ್ವಾ?
Property, western side ಗೆ. I have a property.
ಹೌದು.
To go to that property.
Western side.
Western side property, that is, it comes back side in the photograph. There's argument is, now to interpret this argument. There is other, it is not that the road was there in existence between survey number 59 bar 1 and 59 bar 2. Towards southern portion of 59 bar 2, there is a road. Hence, that road is shown in the sale deed and not is what the argument. Kindly take partition deed, which is the 2003 document.
ಅದು ಹೇಳಿದ್ರಲ್ಲ ತೋರಿಸಿದ್ರು.
No, not for the reason of road belongs to 59 bar 1 and 59 bar 2. Whether there was a road after 59 bar 2. But
after 15
belongs to them.
59 bar 2.
Original family.
No dispute.
If that survey number 59 bar 2 schedule is seen towards the southern portion of that property, there is no road in existence. It is in fact because we purchased the property or not purchased, but we became agreement holder. We had to
sell the property.
Various persons, we formed another road for our benefit. But just because I have formed that road in that portion, that does not give me any right, because for the another argument is I don't own any other property on the southern portion. I own this property. One portion at the beginning, that is 59 bar 6, and another portion on the western side of this property, that is back side of 59 bar 24, for which I have no other access. I mean to say, my lord, I'm not claiming as an easement by access, easement by necessity, but by express grant, this road gives me right to go to that property. And the deed itself, the other deed itself says that the all road which was there in between is 59 bar 1 and 59 bar 2 and not after 59 bar.
Yes, heard reserved.
Please, please.
Your lordships kindly may make one mention, my lord. That a serial.
But in serial number 25.
ಇದ್ರಲ್ಲಿ ಬೇರೆಯವ್ರಿಗೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ? RBS ಬೇರೆಯವ್ರಿಗೆ ಯಾರೋ ಇದ್ದಾರ ಅವರು? ಇದು ಇಂಟರ್ಸೆಪ್ಟ್ ಬಿಟ್ವೀನ್ ಯು ಅಂಡ್ ಇಂಟರ್ಸೆಪ್ಟ್ ಬಿಟ್ವೀನ್ ಯು ಅಂಡ್ ದಿ ಡಿಪೆಂಡೆಂಟ್ ಅಷ್ಟೇ ಅಲ್ಲ? ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡ್ಬೇಕಾಗುತ್ತಾಗ ಮೆಮೊ ಕೊಡಿ. ಬೇರೆಯವ್ರು ಯಾರಿದ್ದಾರೆ? ಯು ಆರ್ ಅಪಿಯರಿಂಗ್ ಫಾರ್ ಓನ್ಲಿ R1 ನಾ? ರಾಜು
I understood file wakalat for R2 also.
R2 also ನಾ? ನೋಡಿ.
Caveat was filed.
ಅದು ಎರಡರಲ್ಲೂ ಸೇಮ್ ಪಾರ್ಟಿ. ನೀವೇ ಅಂಡರ್ಟೇಕ್ ಮಾಡ್ತೀರಾ?
Please, madam.
ಅಲ್ಲೇ ತಗೊಳ್ಳಿ. ಕೌನ್ಸಿಲ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂಡರ್ಟೇಕ್ಸ್ ಟು ಅಪಿಯರ್ ಆನ್ ಬಿಹಾಫ್ ಆಫ್ R2 ಆಲ್ಸೋ ಅಂತ ಹಾಕೋಬಿಡಿ ಅಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ. ಹರ್ಡ್ ಅಂಡ್ ರಿಸರ್ವ್ಡ್ ದಿಸ್ ಮಾರ್ಟ್ ಬೇಡ, ಹರ್ಡ್ ಅಂಡ್ ರಿಸರ್ವ್ಡ್ ಅಷ್ಟೇ. ಆಯ್ತು, ನೆಕ್ಸ್ಟ್.
In both the appeals.
ಇನ್ನೂ ಒಂದಿದೆಯಾ ಪಾರ್ಟ್ 2?
ಅಲ್ಲ ರೀ, ಅದು connected.
ಆಯ್ತು, ಅದೆರಡು ಆಯ್ತು.
Order
ಸೇಮ್
with
ಸೇಮ್
respect
ಸೇಮ್
to
ಆಯ್ತು.
two appeals are.
41 ಯಾರು? KV ನರಸಿಂಹನ್ ಅಂಡ್ ವಿವೇಕಾನಂದ. ಮತ್ತೇನ ಮಾಡ್ತಿರಲ್ಲ? ಸರಿ.
Milord, serial number 25, Milord, it was a 138.
ಆಲ್ರೆಡಿ ಆಗೋಯ್ತಲ್ಲ.
ಆಗೋಯ್ತು, entry ಮಾಡ್ರು vacate ಆಯ್ತು ಅಂತ ನನ್ನ colleague ಹೇಳಿದ್ರು. Milord, the reason is, Milord, I have moved the memo for extension of time. ನಾನೇ ಮೂವ್ ಮಾಡಿದ್ದೆ extension of time ಅಂತ ಹೇಳಿ, ಅಮೌಂಟ್ ಡಿಪಾಸಿಟ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿ ಎಂಟ್ರಿ ಮಾಡ್ರು vacate ಆಯ್ತು. DD was, Milord, they have taken DD after 4 weeks. Therefore, I moved a memo. That DD is also ready, Milord. I will deposit. Milord, if entry
ಇಲ್ಲಿ ಯಾವ್ದು ಇಲ್ಲ.
ಮೆಮೊ ಫಾರ್ ಪೋಸ್ಟಿಂಗ್ ಅಲ್ಲೇ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್ ಅಂತ ಕೇಳ್ಬಿಟ್ಟಿದ್ದೆ ನಾನು, ಅದಕ್ಕೋಸ್ಕರ.
ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್
ಫಾರ್ ಡಿಪಾಸಿಟಿಂಗ್ ಆಫ್ ಅಮೌಂಟ್.
ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮಿಗೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋಬೇಕು. ಈಗ ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಆಯ್ತು.
Milord, I will make an application.
ನನ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ನೋಡಿ ಏನ್ ಮಾಡ್ತೀರಿ ನಿಮಗೆ ಬಿಟ್ಟಿದೆ. ಸೀರಿಯಲ್ ನಂಬರ್ ಏನಾಗ್ಬೇಕು ಹೇಳಿ. ಏಕೆ ಯಾರು ಬೆಳಿಗ್ಗೆ ಕೇಳಿದ್ರಲ್ಲ ಜಗದೀಶ್? ಜೋಸೆಫ್ ಅಂತೋನಿ ಅವರಿಗೆ ಲಿಮಿಟ್ ಇಂಟಿಮೇಟ್ ಮಾಡಿ ಹಿಂದೆ ಮಾಡಿದ್ರಾ? ಒಟ್ಟಿಗೆ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ. ಅವ್ರ ಮಧ್ಯಾಹ್ನ ಬಂದು ನಿಮ್ಮ ಅಬ್ಸೆನ್ಸ್ ಅಲ್ಲಿ ನನ್ನ ಅಬ್ಸೆನ್ಸ್ ಅಲ್ಲಿ ಡೇಟ್ ತಗೊಂಡೋಗಿದ್ದಾರೆ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು? ಈಗ ಮೆನ್ಷನ್ ಮಾಡಿ ಮತ್ತೆ ಈಗ ಯಾರು ಬಂದಿಲ್ವ ಇಲ್ಲಿ? ಮತ್ತೆ ಮೆನ್ಷನ್ ಮಾಡಿ ಅವ್ರು ಮಧ್ಯಾಹ್ನ ಇಂಟಿಮೇಟ್ ಮಾಡಿ ನೋಡಿ. Petitioner counsel seeks time and in the early morning also sought time and directed to intimate the counsel for respondent, and the counsel submits that respondent counsel is not picking up his phone, and at 1:35 also made the very same submission, and hence ಯಾವಾಗ ಬೇಕು ಯಾವಾಗ ಮಾಡ್ತೀರಿ? this matter on 2 weeks ಎಲ್ಲ ಕೊಡಲ್ಲ ಅವ್ರ ಆಬ್ಸೆನ್ಸ್ ಅಲ್ಲಿ. 17/1
Saturday.
20th working ಆಯ್ತು. 20th.
And request, please, my lord, serial number 66, it is a parted matter. And we'll argue in the matter, please, my lord, this honorable court has appointed.
66 parted matter.
Please, ADLR has been appointed for the local inspection and he submitted the report.
ಆಯ್ತು.
But I have not received the copies, please, my lord, because of the report has been sent and kept in the records. So I have to receive that copy and I have to file objections if any, please, my lord.
ಅದರ್ ಸೈಡ್ ಇದಾರಾ? DP
ಹೇಳ್ತೀನಿ ಸರ್,
ತಿಳಿಸಿದ್ದೀರಾ? ತಿಳಿಸ್ತೀರಾ?
ಇಲ್ಲ, ತಿಳಿಸ್ತೀನಿ.
ತಿಳಿಸ್ಬಿಟ್ಟು ಮಧ್ಯಾಹ್ನ 2:30 ಹೇಳಿ.
Milord, serial number 54, man.
ಸೀರಿಯಲ್ ನಂಬರ್ 44. ಹೇಳಿ ಏನಮ್ಮ? ಹೇಳಿ. ಎಲ್ಲಿಂದ ರೆಕಾರ್ಡ್ ಸೆಕ್ಯೂರ್ ಮಾಡೋದು ಈಗ? 20 ಮ್ಯಾಟರ್ ರೀ, ಮ್ಯಾಟರ್ ಆಫ್ 2020 ಡಿಸ್ಚಾರ್ಜ್ ಅಪ್ಲಿಕೇಶನ್ ಸ್ಟೇ ಇದೆಯಾ? ಮತ್ತೆ ನೋಡಿ ವೆರಿಫೈ ಮಾಡಿ ಅದನ್ನ. ಅದರ್ ಸೈಡ್ ಕೌನ್ಸಿಲ್ ಇದಾರಾ? ಚಂದ್ರಶೇಖರ್ ಏನಾಗಿದೆ ರೀ? ಅದರ್ ಸೈಡ್ ಇನ್ನು ಪೆಂಡಿಂಗ್ ಇದೆಯಾ? ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನು ಡಿಸ್ಚಾರ್ಜ್ ಅಪ್ಲಿಕೇಶನ್ 2 to 6 ಡಿಸ್ಚಾರ್ಜ್ ಆಗಿದ್ದಾರೆ. A1 ಗೆ ಡಿಸ್ಚಾರ್ಜ್ ಕೊಟ್ಟಿಲ್ಲ, ಅದ್ರ ಮೇಲೆ ಬಂದಿರೋದು ಹೌದಲ್ಲ? ನೀವೇ ಬಂದ್ರಿ, ಎಗನೈಸ್ ಡಿಸ್ಚಾರ್ಜ್ ಬಂದಿದ್ದೀರಾ? ಏನಾಗಿದೆ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ? ಆಯ್ತ್ರಿ, ಈಗ ಮ್ಯಾಟರ್ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ? ಡಿಸ್ಪೋಸ್ ಆಗಿದೆಯಾ? ಬಟ್ ಡಿಸ್ಪೋಸ್ ಆದ್ಮೇಲೆ ಈಗೇನ್ ಡಿಸ್ಚಾರ್ಜ್ ಅಪ್ಲಿಕೇಶನ್ ಇಟ್ಕೊಂಡು ಹೇಗೆ? ಈಗ ಆರ್ಡರ್ ಸೆಟ್ ಅಸೈಡ್ ಆದ್ರೆ ಮತ್ತೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬೇಕು. ಇದುವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ 2020 ಇಂದ ಮೇನ್ ಮ್ಯಾಟರ್ ಡಿಸ್ಪೋಸ್ ಆಗೋವರೆಗೂ 5 ವರ್ಷದ ಮೇಲೆ ಕೇಳ್ತಾ ಇದ್ರಲ್ಲ ಮತ್ತೆ ಡೇಟ್. Petitioner counsel seeks time and counsel for the respondent present. List this matter.
Copies also not served on us.
ಕಾಪೀಸ್ ಕೊಟ್ಟಿಲ್ವಾ? 20ನೇ ಇಸ್ವಿದ ಇನ್ನೂ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂದೇನ್ರಿ?
ನೋಟಿಸ್ ಹೋಗಿದ್ದೆಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್.
ನೋಟಿಸ್ ಬಂದಾಗ ಕಾಪಿ ಕೊಟ್ಟಿರ್ತಾರಲ್ಲ.
ಕಾಪಿ ಇಲ್ಲ.
ಕಾಪೀಸ್ ಕೊಟ್ಮೇಲೆ ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗೋದು. ಆಯ್ತು, ಏನೇ ಒಂದು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೊಡ್ರಿ ಮೇಡಮ್, ಡೇಟ್ ಕೊಡ್ರಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಯಾವ್ದಾರು ಡೇಟ್. 15/1 ಅವತ್ತು ನೋಡೋಣ.
Serial number 54, my lord. I am for the petitioner.
ಹೇಳಿ ಏನ?
Week's time may be granted, my lord.
ಏನಕ್ಕೆ ರೀಸನ್ ಏನ್ ಹೇಳಿ?
Is already complied the order of this honorable court.
ಆರ್ಡರ್ ಕಂಪ್ಲೈ ಆಗ್ಲಿ, ಬಟ್ ಏನಕ್ಕೆ ಡೇಟ್ ಕೇಳ್ತಾ ಇದ್ರಿ?
Some personal inconvenience.
ಸರ್ವಿಸ್ ಆಗಿಲ್ವಾ? ಸರ್ವಿಸ್ ಆಗಿದೆಯಲ್ಲ, ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ. ಹಾ,
So next week.
ಟೈಮ್ ವೈ ಒನ್ ಟೈಮ್ ರೀ.
Yes, some personal inconvenience.
Counsel seeks
after
time,
now.
counsel for respondent also present. List this matter on 21.
My lord, serial number 42, my lord.
ಹಾ, ಹೇಳಿ ಏನಲ್ಲ.
Appear for the petitioner.
ಹಾ.
My lord, the matter for the appeal was referred to Lokala. My lord, in the Lokala, my party has agreed to pay interim maintenance. But my lord, by oversight, that was taken as final one and order was passed. Thereafter, my lord, we filed an application to recall the order and to hear the matter on merits. In the meanwhile, my lord, the party has taken the NOC. For quite, my lord, all these days, the matter was not declared. Today it has been declared. I inform the party, my lord, we may engage some other advocate. I will take.
ನೀವೀಗ ಬ್ರೀಫ್ ವಾಪಸ್ ಕೊಟ್ಟಾಗ ಅಕ್ನಾನ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದೀರಾ ಇಲ್ಲ?
But it was we were pursuing that local matter. Then suddenly it has come now. But I will get that receipt and.
ಅದರ್ ಸೈಡ್ ಇದಾರ ಮೊಹಮ್ಮದ್ ಸದಾರ್.
Try to call him and inform.
ಮತ್ತೇನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ಆಯ್ತು, ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡ್ತೀನಿ ಅಷ್ಟೇ. Petitioner counsel seeks time and counsel submits that he made an attempt to intimate other side but could not contact him. And in view of the submission, list this matter on 15/1.
Serial number 16 on that.
Serial number
16. Katti aitu na 10,000. I am on no objection. I have come, Lord. I mean, not no objection. He has retired. Sorry.
ಪಾಸ್ ಅವರೆಲ್ಲ ಮಧ್ಯಾಹ್ನ ನೋಡೋಣ. ಈಗೇನು ಅರ್ಜೆಂಟ್ ಏನು ಪಾಸ್ ಕಟ್ಟಿದ್ರಲ್ಲ. ಹಾ,
ನಾನು ಕಳಿಸ್ಬಿಡ್ತೀನಿ, ಇಲ್ಲಾಂದ್ರೆ ಅವ್ರು ಮಾಡಲ್ಲ. 22 ಏನ್ ಬೇಕು ನಿಮ್ಗೆ? ಏನ್ ಬೇಕು? ಹೋಗೋಗಿದೆ ಸರ್, ಆ ಫೈಲ್ ಇರುತ್ತೆ ಸರ್ ಇಲ್ಲಿ. ಅದ್ ಹೆಂಗ್ ಸರ್ ಇರಕ್ ಸಾಧ್ಯ? ಹೋಗ್ಲಿ, ಆರ್ಡರ್ ಹಾಕಿ ಹೋಗಿರುತ್ತೆ, ಟೈಪ್ ಹಾಕಿ ಸೈನ್ ಹಾಕಿ ಫೋನ್ ತಗೊಳ್ಳಿ. ಹಿಂಗೇನೆ ಸಬ್ಮಿಷನ್ ಆಗ್ತದೆ. ಯಾವ್ದು ನಿಮ್ಗೆ ಯಾವ್ದು ಬೇಕು ಮೇಡಮ್ ನಿಮ್ಗೆ? ಮೇಡಮ್ ಯಾವ್ದು ಬೇಕು? ಹ್ಮ್. ಎಷ್ಟು ಆಗಿದೆ? ಒಂದು 4 ಆಗಿದೆ. ಹಾ ಹೌದು. 64ಗೇನು ಅಷ್ಟೇನೆ. 5 ಆಗಿದೆ. ಹ್ಮ್. ಹ? ಇಲ್ಲ ಇದೆ. ಹಾ ಇದೆ ಇದೆ. ಅವ್ರು 64 ಒಳಗಡೆ ಯಾವ್ಯಾವ್ದಾಗಿದೆ ಅಂತ ಕೇಳಿದ್ರು. ಅದೇ ಇದೆ. ಇದು ಕೊಡು ಇದೆ. ಏನ್ ಬೇಕು? ಅಲ್ಲ ಅವರು ಮೊನ್ನೆಯಿಂದ ಗಲಾಟೆ ಮಾಡ್ತಾ ಇದಾರೆ. ನಾನು ಅದು ಬೀಂಗ್ ಸ್ಪೋಕಂಟು ಅಂತ ಹಾಕ್ಸಿರೋದು ಆಗಲ್ಲ ಅಂದ್ಬಿಟ್ಟು ಮೆಮೊ ಹಾಕ್ಸಿದ್ದೀನಿ, ಅಲ್ಲೇ ಹಾಕ್ಸಿದೀನಿ. ಅದೇನಕ್ಕೆ ಮಾಡಿಲ್ಲ? ಅವ್ರು ಮತ್ತೆ ಬೆಳಿಗ್ಗೆ ಬಂದು ಸಬ್ಮಿಟ್ ಮಾಡ್ತೀವಿ ಅಂತ ಕುತ್ಕೊಂಡಿದ್ದಾರೆ. ಸುಮ್ನೆ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ರೆ ಪ್ರಾಬ್ಲಮ್ ಇಲ್ವಾ? ಯಾಕಮ್ಮ HPS ನಾನ್ ತಗೊಂಡಿಲ್ಲ. ಓ, ಅದ್ ಬಿಟ್ಟು. ಏನು? ಹಾ.
ಪೇಪರ್ ಸಾಯಂಕಾಲ ಬಂದಿದೆ. ಪರವಾಗಿಲ್ಲ. ಮತ್ತೆ ನಿನ್ನೆನೆ ಆಗಿರೋದು. ನಿನ್ನೆ ನಾಳೆ ಡೇಟ್ ಮೇಲೆ ಆಗಿದಪ್ಪ ಹೇಳಿದ್ದೀನಿ ನೋಡಿ.
ನಾಳೆ ಹಾಕ್ಸಿ ಅಷ್ಟೇ ಫೈಲ್ ಇವಾಗ. ನಾಳೆ ಮಿಸ್ ಮಾಡ್ಬೇಡಿ. ಮತ್ತೆ ಅವ್ರು ಬಂದು ಗಲಾಟೆ ಮಾಡ್ತಾರೆ. ಸುಮ್ಮನೆ ಸ್ಟಾಪ್. ಹೋಗಿ ಕೊಟ್ಟಿದ್ದೀನಿ. ಇದು ಇದೆ ನೋಡು. ಕಳಿಸಿ, ನಾಳೆ ಕಳಿಸಿ. 44 ಅಂತ ಕೊಡ್ಬೇಕು. ಅದಲ್ಲ
924 ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರ್?
ಇದು ಸೀಲ್ ನಂಬರ್ 52.
65 ಅದು.
65
65 of 24.
ಯಾವ್ದಪ್ಪ?
ನೀವು ಯಾವ್ದೋ ಕೊಡ್ತೀರಾ?
ಇಲ್ಲ, ಅದೇನ್ ಮಾಡಿದಾರೆ ಗೊತ್ತಾ? ಕನೆಕ್ಟೆಡ್ ಉಲ್ಟಾ ಹಾಕಿಟ್ಟಿದ್ದಾರೆ ಅವರು. ಹೇಳೋಣ ಅನ್ಕೊಂಡೆ. ಉಲ್ಟಾ ಮಾಡಿರ್ತೀನಿ, ನನಗೂ ಕನ್ಫ್ಯೂಸ್ ಆಯ್ತು. ಅದನ್ನ ಕೆಳಗೆ ಹಾಕೋಬೇಕು, ಹಿಂಗ್ ಮಾಡಿಟ್ಟಿದ್ದಾರೆ. 52
1274. ಓಕೆ, 42 ಕೊಡ್ಬೇಕು. 924. 42. ಇನ್ನೇ ದಿನ ಅಂತಾನೆ ಯಾರು ಡೇಟ್ ಕೊಡ್ಬೋಣ. 16.
ಕಾಣ್ತಿಲ್ಲ.
ಅದಕ್ಕೆ ಫೋನ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಮೇಡಮ್, ಹೇಳಿರಲ್ಲ ಬಿಡಿ ಮೇಡಮ್, ನಾನು ಮುಂದೆ
ಮಾತಾಡ್ಸೇ ಇಲ್ಲ. ನಿನ್ನೆ ಬೆಳಿಗ್ಗೆ ಗಪ್ಪ ಗಪ್ಪ ಅಂತ ಫುಲ್ ಹಾರ್ಟ್ ಪೊಸಿಷನ್ ಇದ್ದಾಗ ಬಂದಿದ್ದಾರೆ. ನಾನು ಹೆಂಗ್ ಮಾತಾಡ್ಸ್ತೀನಿ? ನಾನು ಮಾತಾಡ್ತೀನಿ. ವೆಂಕಟೇಶ ಹಿಡಿದ್ರು ಅನ್ಸುತ್ತದೆ. ಆರ್ತಿ ಹತ್ರ ಹೋಗಿ ಆರ್ತಿ ಹತ್ರ ಒಂದು ಹೌದಾ, ನನ್ನನ್ನು ಕರೆದಿದ್ರು. ನಾನು ಹೋಗ್ಲಿಲ್ಲ.
Serial number 66, please. Madam. I have informed to the other side is also here, please. Madam. Report has been come. 66 parted matter. I am for the applicant.
Counsel 6 time, one counsel for respondent also present. And applicant counsel 6 time, discuss matter.
And 10 days, please, madam, because I have to receive the certified copies.
21, 1.
Please.
Production of accused. ಬಂದು ಇದು ಅಡ್ವಾನ್ಸ್ ಮಾಡು. 13 ಒಂದಿದೆ. 13 ಆದ್ರೆ ಅವನು ಸ್ವಲ್ಪ ಅಬ್ಸ್ಕ್ಯಾಂಡ್ ಆಗಿದ್ದ, ಅದಕ್ಕೆ ಅರೆಸ್ಟ್ ಮಾಡಿ. ಹಾ, ಸಿಗಲ್ಲ ಅಂತೇಳಿ ಅರೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡು ಎಸ್ಟರ್ಡೇ ಆರ್ಡರ್ ಕಾಪಿ ಅದರಲ್ಲಿ.
Advocate on record as well on one person. You know, with the intimate man.
Please.
ಅವ್ರು ಇದಾರೆ ಅಡ್ವೊಕೇಟ್.
Advocate ಇದಾರ ಅವ್ರಿಗೆ? Advocate ಇರೋದರ ಫೈಲ್ ತರಿಸಿ.
ಪಾಸ್ಪೋರ್ಟ್ ಮಾಡಿದ್ರೆ 60 ಮಂಜುನಾಥ್ ಎಂಡಿ 16 ನಮ್ಮ ಫಾರ್ ರಿಟೈರ್ಮೆಂಟ್. ಅದೇ ಅವರು ಬೆಳಿಗ್ಗೆ ಅವ್ರೇನು ಹಾಕಿಲ್ಲ.
Retirement memo is accepted since counsel Alina being notified of petitioner. The balance amount of this 10,000 is also paid. Last time ಏನೋ order ಆಗಿತ್ತು.
ಹೌದು ಸರ್ ಆರ್ಡರ್ ಅಂತ
10,000 ದಂಡ ಹಾಕಿ 10,000
ಕಟ್ಟೋದಕ್ಕೆ ಇದಿದೆ 10,000 ಕಟ್ಟೋದಕ್ಕೆ
ಬಂದ್ರಲ್ಲ ಲಿಂಗ ಮೇಡಮ್ the amount of 10,000 remaining amount of 10,000 deposited and the file memo regarding depositing the same. Then this matter ಯಾವ year ಇತ್ತು 2015 ಯಾವಾಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಿ ಯಾವಾಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಿ ಆಯ್ತು 2 ವಾರ ಕೊಡ್ತೀನಿ ತಗೊಳ್ಳಿ this is not 2015 ಅದಕ್ಕೆ 2 ವಾರ ನಾನು ಕಾಪಿ ಕೊಡ್ಲೇ ಅಂದಲ್ಲ ನೀವು ಹೋಗಿ ತಗೊಂಡ್ರೆ ಮಾತ್ರ ಕಾಪಿ ಸಿಗೋದು ನೀವು ಬರ್ತೀರಿ ಅಂತ ಅಲ್ಲೇನು ರೆಡಿ ಮಾಡಿಡಲ್ಲ ನೀವು ಫಾಲೋ ಅಪ್ ಮಾಡಬೇಕು ಯಾವಾಗ ಹೇಳಿ ನಾನು 2 ವಾರ ಕೊಡ್ತೀನಿ ತಗೊಳ್ಳಿ 2 ವಾರ ಕೊಡ್ತೀನಿ 2015 10 ವರ್ಷ ಆಯ್ತು 23-1
70 ಬಲರಾಮ್ ಎಂ
My lord, petitioner, the petition is present before the court, my lord. The petition is present before the court. My lord, in fact, last time, bailable warrant has been issued. My lord, petition is before the court, my lord. No, my lord, in fact, an application has been filed. Yes, my lord. An application has been filed before the, in the office for recall of the order, my lord. I'm sorry, my lord. In fact,
ಬೆಳಗ್ಗೆ ಪಾಸ್ ಆನ್ ಮಾಡಿದ್ದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಳ್ಳಿ ಈಗ ಅಲ್ಲೋಗಿ ಆಫೀಸಲ್ಲಿ ಹಾಕ್ತಂದ್ರೆ
please.
ಯಾಕೆ ಬಂದಿಲ್ಲ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ
No, my lord, in fact, he's a lorry driver, my lord. My lord, no, he had no knowledge about it, my lord. In fact, the previous council was dead, my lord. Yes, my lord.
ಅಲ್ಲ ರೀ ಇವನಿಗೆ ಜಾರಿ ಆಗಿದೆ ಕೋರ್ಟ್ ನೋಟಿಸ್ ದಟ್ ಐ ವೆರಿಫೈಡ್ ಮಾರ್ನಿಂಗ್ ತೀರ್ಕೊಂಡ ಮೇಲೂ ಕೋರ್ಟ್ ನೋಟಿಸ್ ಹೋಗಿದೆ ಅರ್ಲಿಯರ್ ದ ರಿವಿಷನ್ ಕೋರ್ಟ್ notice came to be issued, court notice is served on the revision petitioner who remained absent.
My lord,
Accused has been convicted for the non-bailable warrant for the revision petitioner issued local notice to the surety as to why bond should not be confiscated. ಆಯ್ತು application ಬರಲಿ
please.
ಸರ್ವಿಸ್ ಆದ್ರೂ ಬರಲಿಲ್ಲ ಅಂದ್ರೆ
No, it is not an intention, my lord.
ಟೆನ್ಷನ್ ಇದೆಯೋ ಇದು ಅದು ಆಮೇಲೆ ನೋಡೋಣ
Please.
ಒಂದ್ಸರಿ ಕೋರ್ಟ್ ಇಂದ ನೋಟಿಸ್ ಬಂದಿದೆ ಅಂದ್ಮೇಲೆ ಕೋರ್ಟ್ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರಾಗ ಬರೋ ಕೆಲಸ ಮಾಡು
He should have come, my lord.
ರಿಕಾಲ್ ಮಾಡ್ತೀನಿ ಹೆವಿ ಕಾಸ್ಟ್ ಬರ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಬರ್ಲಿ ಪುಟಪ್ ಮಾಡಕ್ಕೆ ಹೇಳಿ ಮೇಡಮ್
34
Respondent, my lord, concerned finding, my lord.
Appearing for petitioners. There is no liability to pay the amount. In spite of that, by misusing the check, he has presented the check and both the courts have our amount withdrawal ಹಾಕೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಹೌದು ಸ್ವಾಮಿ. ಅಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೂಡ 2 ಎಕರೆ 30 ಗುಂಟೆನಲ್ಲಿ 30 ಕ್ವಿಂಟಲ್ ಅಡಿಕೆ ಬೆಳೆದಿದ್ದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಬೇರೆಯವರಿಂದ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ ಮತ್ತೆ. ಅಲ್ಲ ಪ್ಲೀಸ್ ಪ್ಲೀಸ್ ಅಲ್ಲ 2 ಇಲ್ಲ ನಾಳೆ ಆಗೋದಿಲ್ಲ, ನೆಕ್ಸ್ಟ್ ವೀಕಲ್ಲಿ ಹಾಕೊಳ್ಳಿ ಸ್ವಾಮಿ.
IAS filed for release of account and counsel for the revision petitioner seriously opposes the application.
Please.
Counsel for the respondent says that he is ready even for argument, argue the matter on merits. Hence this matter.
Lordship, I may request one thing, Your Lordship. Next week. 16 ಅಲ್ಲ ಹೌದಾ 15 ಇರಲಿ ಸ್ವಾಮಿ. ಆಮೇಲೆ ಇದರಲ್ಲಿ ಕೈಂಡ್ಲಿ ಇನ್ ದಿಸ್ CC number 388 of 2019. ಅಲ್ಲ
ಕೇಸ್ ಮಾತ್ರ ರೆಕಾರ್ಡ್
ಅಲ್ಲಲ್ಲ ಈ ಕೇಸ್ ಅಲ್ಲ ಸ್ವಾಮಿ, ಅಲ್ಲಲ್ಲ ಇದ್ರದ್ದಲ್ಲ ಸ್ವಾಮಿ ಅದು, ಪ್ಲೀಸ್.
20th.
ಸ್ವಾಮಿ 20th ಹತ್ತೊಂಬತ್ತು ಹಾಕೊಳ್ಳಿ, ಇದು 21.
19 ಭಾನುವಾರ.
19 ರಜೆ 21 ಹಾಕಿ. 21 ಆಗ್ಬೋದಾ? 21. ಇನ್ನು ಮೀನ್ ಬೈ ರಿಜಿಸ್ಟ್ರಿ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಗೆಟ್ ದಿ ರೆಕಾರ್ಡ್ಸ್ ಆಫ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್. ರೆಕಾರ್ಡ್ಸ್ ಬೇಕು ಅದಕ್ಕೆ ರಿವಿಷನ್ ಇರೋದು.
ಅಲ್ಲ ಸ್ವಾಮಿ ಇದನ್ನು ತರ್ಸಿರ ಒಳ್ಳೇದು, ಯಾಕಂದ್ರೆ ನಾನು ಒಂದು CC ನಂಬರ್ ಹೇಳ್ತೀನಿ.
ಟ್ರ್ಯಾಕಿಂಗ್ ದಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್
ಅಲ್ಲಲ್ಲ ಅದರಲ್ಲಿ ಅಲ್ಲಲ್ಲ ಮೈ ಕಂಟೆನ್ಷನ್ ಬಿಫೋರ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇಟ್ ಸೆಲ್ಫ್ ಇಸ್ ದಟ್ they are taken 2 checks from me and they have filed two separate check bounce cases. ಅದರಲ್ಲಿ ಇದೊಂದು ಇದೆ ಸ್ವಾಮಿ.
ಬೇರೆ ಕೇಸ್ ಇದ್ರೆ ಆ ಕೇಸ್
ಅಲ್ಲ ಎರಡು ಕಂಟಿನ್ಯೂಸ್ ನಂಬರ್ನೇ. ಪ್ಲೀಸ್
ಹೇಳಿ ಸರ್,
ಪ್ಲೀಸ್ ಪ್ಲೀಸ್
ನಿಮ್ಮ ವಾಯ್ಸ್ ರೇಂಜ್ ಮಾಡೋದು ಬೇಡ, ನನಗೆ ಕೂಡಲ್ಲ.
ಇಲ್ಲ.
ನನಗೆ ಕರೆಕ್ಟ್ ಆಗಿ
ಪ್ಲೀಸ್
ಕೇಸ್ ಅಲ್ಲಿ ಇಂಡಿಪೆಂಡೆಂಟ್ ಎವಿಡೆನ್ಸ್ ಆಗಿರ್ತದೆ. ಎರಡು ಚೆಕ್ಸ್ ಬೇರೆ ಬೇರೆ ಆಗಿದೆ.
ಹೌದು.
ಕ್ಲಬ್ ಏನಾಗಿದೆ?
ಇಲ್ಲ ಬೇರೆ ಬೇರೆ ಕೋರ್ಟೆ.
ಕೇಸ್ ಅಲ್ಲಿ ಆ ಮೆಟೀರಿಯಲ್ ಏನಿದೆ ನೋಡ್ಬಿಟ್ಟು ಆರ್ಡರ್ ಬರೀಬೇಕಷ್ಟೇ. ಅದ್ರ ಮೆಟೀರಿಯಲ್ ತಗೊಂಡು ಇಲ್ಲಿ ನಾನು ಆರ್ಡರ್ ಬರೆಯಕ್ ಆಗಲ್ಲ.
ಅಲ್ಲ ಅವರು
ಆಯ್ತಾ, ಒಟ್ಟಿಗೆ ಆರ್ಡರ್ ಡಿಸೈಡ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಬನ್ನಿ 21 ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ಅವತ್ತು ಮೆರಿಟ್ಸ್ ನಲ್ಲಿ ಹೇಳಿ ನೋಡೋಣ.
ಪ್ಲೀಸ್
ಮತ್ತೆ
41 KV ನರಸಿಂಹನ್, ವಿವೇಕಾನಂದ TP.
ಎಷ್ಟೊತ್ತಾಗುದ್ರಿ? ಅಡ್ಮಿಷನ್ ಮ್ಯಾಟರ್ಸ್ ಇದೆ, ರೆಫರೆನ್ಸ್ ಅಂತ ಇದೆ ಅದಕ್ಕೆ. ಎಷ್ಟೊತ್ತಾಗುತ್ತೆ ನಿಮ್ಗೆ?
half an hour time. Half an hour.
ನೆಕ್ಸ್ಟ್ ವೀಕಲ್ಲಿ ಯಾವ್ದಾದ್ರು ಡೇಟ್ ಕೊಡ್ತೀನಿ. ದಿಸ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಯಾವ್ದಾದ್ರು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೊಡಿ ಮೇಡಮ್. ಅಡ್ಮಿಷನ್ಸ್ ಎಲ್ಲ ಸ್ಟೇ ಇಲ್ಲ ಇರ್ತದೆ, ಅದಕ್ಕೆ ರೆಫರೆನ್ಸ್ ಇದೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ.
17-1.
17-1
ಆಗ್ಬೋದಲ್ಲ? ಪ್ಲೀಸ್.
43
42 ಆಯ್ತು.
ಹಾ, ಸರ್. ಅಭಿಷೇಕ್ ಕುಮಾರ್, MP ವಿಶ್ವನಾಥ್.
ಇಲ್ಲ ಇಬ್ರು ಇಲ್ಲ. ಯಾವ ಇಯರ್? 2020. Both counsels are absent. If counsel doesn't appear in the next state of hearing, matter will be dismissed for non-prosecution. Dismiss matter 138 is ತಂಗಿದೆ. Dismiss matter
21-1.
21-1.
44 urgent. 45 ಪರಮೇಶ್ವರ ಹೆಗ್ಡೆ.
Petitioner.
ಪರಮೇಶ್ವರನ್ ಹೆಗ್ಡೆ. ಹಾ. Respondent Sarudha. ಹೇಳ್ರಿ.
Petitioner in the case, madam. The check amount is at 25,000, madam.
25 ಮತ್ತೆ ಫಾರ್ಮ್ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು.
ಹೇಳಿ ಏನು ಗ್ರೌಂಡ್ ಏನು ಡಿಫೆನ್ಸ್ ವಾಟ್ ಇಸ್
Grounds itself is the complaint ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ 25,000 at the time of check ತಗೋಬೇಕಾದ್ರೆ ಇಂಟ್ರೆಸ್ಟ್ ಟೋಟಲ್ 2,50,000 10 ಚೆಕ್ಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ. 9 ಚೆಕ್ಸ್ ಆನರ್ ಆಗಿದೆ. ಹೌದು ಸ್ವಾಮಿ, ರಿಮೈನಿಂಗ್ 25,000 ಆಲ್ರೆಡಿ ಅಮೌಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಮೌಂಟ್ ಸೇಮ್ ಇಟ್ ಸೆಲ್ಫ್ ಇಸ್ ಅಕ್ಸೆಪ್ಟ್ ಆಗಿದ್ದಾರೆ. ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲೂ ಹೇಳಿದ್ದಾರೆ, ಈವನ್ ಲೀಗಲ್ ನೋಟಿಸ್ ಅಲ್ಲೂ ಅವರು ಇದು ಮಾಡಿದ್ದಾರೆ.
10 side checks.
ಎಸ್ ಮೈ ಲಾರ್ಡ್.
Each data partly paid interest. The interest of rupees 25,000 towards the interest account. Out of the 10 checks, the accused has honored the 9 checks, and the remaining 1 check issued by the accused bearing number so of discharge. Dishonored. The check ಅಲ್ಲಿ 9 honor ಆಗಿದೆ, 1 honor ಆಗಿಲ್ಲ.
ಅದೇ ಟೈಮಲ್ಲಿ ಇಂಟ್ರೆಸ್ಟ್ 25,000 ರಿಮೈನಿಂಗ್ ಒನ್ ಚೆಕ್ದು ಆಲ್ರೆಡಿ ತಗೊಂಡಿದೀವಿ ಅಂತ ಅವರೇ ಲೀಗಲ್ ನೋಟಿಸ್ ಅಲ್ಲೂ ಹೇಳಿದ್ದಾರೆ. ರಿಮೈನಿಂಗ್ 9 ಚೆಕ್ಸ್ ಆನರ್ ಆದ್ಮೇಲೆ ರಿಮೈನಿಂಗ್ 25,000 ಅಮೌಂಟ್ 25,000 ಕಲೆಕ್ಟ್ ಕ್ಯಾಶ್ ಅಲ್ಲಿ ರಿಸೀವ್ ಮಾಡಿದೀನಿ ಅಂತ ಹೇಳಿ ಅವರೇ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಲೀಗಲ್ ನೋಟಿಸ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ, ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಹೇಳಿದ್ರು.
ರೆಕಾರ್ಡ್ಸ್ ಇದೆ ಮೇಡಮ್? ಇಲ್ಲ ಬಂದಿಲ್ಲ ಇದು ಸ್ವಲ್ಪ ರೆಕಾರ್ಡ್ಸ್ 2020 ಇಂದ ಇನ್ನೂ ರೆಕಾರ್ಡ್ಸ್ ಇಲ್ಲ. ಸ್ವಲ್ಪ ರೆಕಾರ್ಡ್ಸ್ ಮಾತ್ರ 22nd.
ಅಚ್ಚಾ
ಎಲ್ಲಿಂದ ಬರ್ಬೇಕು ರೆಕಾರ್ಡ್ಸ್?
ಇಲ್ಲ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ಸ್
ಇಲ್ಲಿ
ಬೆಂಗಳೂರು ಸರ್.
21
ಮಚ್ಚ
26 ಜಯರಾಜ್.
46
respondents for petitioner counsel absent. If counsel doesn't appear in the next state of hearing, petitioner not on 21-1.
47
Charles.
Charles. ಶರದ್ ಗೌಡ GB.
ಹೌದು ಸ್ವಾಮಿ.
What is your defense?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇದು 147 ಹಾಕಿ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದೆ ಸರ್. ಹೌದು ಸ್ವಾಮಿ, 147 ಇದು ಮಾಡಿದ್ವಿ. ದೆನ್ ಕೋರ್ಟ್ ಈಸ್ ಆರ್ಡರ್ ದಟ್ It's quarter 22. 26 2ಗೆ ಹೇಳಿದ ಸ್ವಾಮಿ 4,70,000 ಪೇಮೆಂಟ್ ಆಗಿದೆ. 10,000
In Round and Council revision ಅಲ್ಲಿ revision scope is very limited.
ಸ್ವಾಮಿ
Round ಏನಂದ revision ಅಲ್ಲಿ admission ಹೇಳಿ ಹಿಂದೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಮ್ಯಾಟ್ರೇ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದೆ ಸ್ವಾಮಿ. 147 ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ
ಮತ್ತೆ ಕೋರ್ಟ್ ಮುಂದೆ admission ಗೆ.
ಆ ಸ್ಟೇಜಲ್ಲಿ ಮಾಡಿ
Since the compromise petition between the parties, the accused will be permitted to compound the offence of the state of Act. Has been convicted and confirmed with that this stage, the Sharad Code of 11th Council that unless there is a direction by this court, the subject court would not disperse the amount is in deposit. It is needless to emphasize that the amount in deposit is to be dispersed in favor of the complainant since the submission that there is a direction required. The application is allowed to the direction
ಫೈನ್ ಅಮೌಂಟ್ 10,000 rupees ಕಟ್ಟಬೇಕು ಟ್ರಯಲ್ ಕೋರ್ಟಲ್ಲಿ. ಅದು ಕಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ. ಬಾಂಡ್ ಕೂಡ ಕೇಳಿದ್ದಾರೆ, ಅದು ಕೊಟ್ಟಿದ್ದೀವಿ. 10 ಟ್ರಯಲ್ ಕೋರ್ಟ್ 10,000 rupees ಫೈನ್ ಕೊಟ್ಟು ಕಟ್ಟಬೇಕು. ಅದು 10,000 rupees ಕಟ್ಟಕ್ಕೆ ಆರ್ಡರ್ ಆಗಿದೆ, ಅದು ಕಟ್ಟಿದ್ದೀವಿ. ಬೇಲ್ ಬಾಂಡು ಬರೆದು ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ. ಅದನ್ನು ಕಂಪ್ಲೈ ಮಾಡಿ ಸ್ವಾಮಿ.
ಮಾಡಿದ್ರೆ ಇದು ಅಡ್ಮಿಷನ್ ಬಂದಿದೆ, ನೀವು ಅಡ್ಮಿಷನ್ ಏನಂತ ಗ್ರೌಂಡ್ಸ್ ಹೇಳ್ಬೇಕು. ಎಲ್ಲ ಆಗಿದೆ 147 ಅಪ್ಲಿಕೇಶನ್ ಯಾವಾಗ ಹಾಕಿದ್ರಿ?
ಅವಾಗಲೇ ಹಾಕಿದ್ದು ಸ್ವಾಮಿ. ಹೌದು ಸ್ವಾಮಿ.
ಆರ್ಡರ್ ಇದೆ.
ಹಾಂ
ಈ ನಮ್ ಕೋರ್ಟ್ ನೋಡ್ರಿ.
ಹೌದು ಹೌದು ಸ್ವಾಮಿ.
ಡೇಟ್
26 to
21. Video conference from Nellore State of Andhra Pradesh where present video conference is also quoted in this matter. Application A2 of 2020 under section 147 of NA Act has been submitted for in this side main part of the petitioner was sentenced to pay for 15 lakhs. The petitioner is a committed person. ಕೊಟ್ಟರೆ ಒಟ್ಟಿಗೆ 8,70,000 ಆರ್ಡರ್ ಆಗಿರೋದು 12,90,000.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು 1,30,30,000 ನಾವು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದು ಸೆಷನ್ ಕೋರ್ಟಲ್ಲಿ, ಅದನ್ನು ದೇ ವಿಡ್ರಾನ್ ಸ್ವಾಮಿ, ದೇ ಹವ್ ಟೇಕನ್ ದಟ್. 10 lakhs ಆಗುತ್ತೆ ಸರ್. $4.7 and 4 lakhs plus 1.330. 20% ಅಲ್ಲಿ ಕಟ್ಟಿರೋದು ಅದು.
ಬಾಂಡ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿ ಟೋಟಲ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ.
ಮಾಡಿದ್ದೀವಿ ಸ್ವಾಮಿ. 10,000 rupees ಕಟ್ಟಬೇಕು. ಕಟ್ಟಿ ಅದು ಕಂಪ್ಲೈ ಮಾಡಿದ್ದೀವಿ ಸರ್.
ಸೆಟಲ್ಮೆಂಟ್ ಪ್ರಕಾರ ಏನಾಗಿದೆ? ಜಾಯಿಂಟ್ ಸೆಟಲ್ಮೆಂಟ್ ಹಾಕಿದ್ದೀರಾ?
ಹೌದು ಸ್ವಾಮಿ, ಹೌದು ಸರ್, ಜಾಯಿಂಟ್ ಇಬ್ಬರು ಹಾಕಿ. ಫೈಲಲ್ಲಿ ಇದೆ.
ನೀವು ಕಾಂಪ್ರಮೈಸ್ ಪ್ರಕಾರ
10 lakhs ಸ್ವಾಮಿ.
ಇದು ಕೊಟ್ರೆ 15/1/21 ಕೊಡ್ಬೇಕು ಅಂತ ಇದೆಯಲ್ಲ, 4,70,000
ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ, ಅದರಲ್ಲಿ ಅಕ್ನಾಲೇಜ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಆರ್ಡರಲ್ಲಿ ಆಗಿದೆ ಸ್ವಾಮಿ. 26 ಆರ್ಡರಲ್ಲಿ 26/2 ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ, ತಗೊಂಡಿದ್ದಾರೆ. ಇನ್ ಟೋಟಲ್ ಸಮ್ ಆಫ್ 8,70,000. ಅದೇ ಸ್ವಾಮಿ. ಪೇಜ್ ನಂಬರ್ 3 ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಪ್ಯಾರಾ. ಪೇಜ್ 3 ಪೇಜ್ 3 ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಪ್ಯಾರಾ. ಇದು ಪೇಮೆಂಟ್ ಆಗಿದೆ
ಮಾಡೋದಕ್ಕೆ
ಮಾಡಿ.
ನೀವು ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ರಿ ಸೆಕ್ಷನ್ 147 ಅಲ್ಲಿ.
ಹೌದು ಸರ್.
ಇದು ಹಾಕಿರೋದು ನೀವು 22/12/2020
ಹೌದು ಸ್ವಾಮಿ, ಹೌದು ಸರ್.
ಡೇಟ್ ಫಿಕ್ಸ್ ಆಗಿದೆ. ಅಮೌಂಟ್ ಕಾಂಪ್ರಮೈಸ್ ಪ್ರಕಾರ 15/1/21 ದುಡ್ಡು ಕೊಡ್ಬೇಕು ಅಂತ.
ಹೌದು ಸ್ವಾಮಿ.
ಆ ದುಡ್ಡು ಕಟ್ಟಿದ್ದೀರಾ?
ಕಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ.
ಎಲ್ಲಿ ಕಟ್ಟಿದ್ದೀರಿ?
ಅಕ್ನಾಲೇಜ್ಮೆಂಟ್ ಅದ್ರಲ್ಲಿ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
4 lakhs plus 4 lakhs 3,87,000 8,70,000 ಕಟ್ಟಿ. Whereas in the page number 3 ಅಲ್ಲಿ ಈ ಪೇಜ್ ನಂಬರ್ 3 ಅಲ್ಲಿ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾನೇ in the view of settlement between the parties, 4,70,000.
Paid by the petitioner to the respondent. The same is acknowledged by the respondent. Also paid a sum of rupees 4 lakh to the respondent, which was also acknowledged by the respondent. In all, 8,70,000. To the respondent complaint, and therefore the amount is the terms have to compensate. ಕೆಳಗಿನ ಕೋರ್ಟಲ್ಲಿ 10,000 ಕಟ್ಟಿದ್ದಕ್ಕೆ ಏನಿದೆ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೀವಿ ಸರ್, ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ, ಆರ್ಡರ್ ಶೀಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
Submitted deposit terms have declared to the state having the possibility.
ಅಂಡ್ ಬಾಂಡ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಸರ್.
The counsels of the revision petitioner also filed memo. The petitioner has deposited the amount of 10,000. Report is also having perused the order dated 26/2021. In terms of the settlement between the parties, already made the payment. Hence, nothing survives for consideration of this petition. As a result, the petitioner is admitted for the offence punishment 138 of NI.
ಬಾಂಡ್
ಏನ್ ಬಾಂಡ್?
ಬಾಂಡ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ.
ಏನ್ ಬಾಂಡ್ ಅಲ್ಲ ನಾವು ಕ್ಯಾಶ್ ಕೇಸ್ ಕಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ. ಆಸ್ ಪ್ಲೀಸ್ಡ್ ಯು.
ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಆದಾಗ ಮತ್ತೆ ಬಾಂಡಿಗೆ ಆರ್ಡರ್ ಮಾಡ್ಬೇಕಿತ್ರಿ. ಏನ್ ಮಾಡಂಗಿಲ್ಲ, ಆರ್ಡರ್ ಅಂತ ಆ ರೀತಿ ಆರ್ಡರ್ ಇದೆ. ಪಿಟಿಷನ್ ಇಸ್ ಕ್ಲೋಸ್ಡ್.
48 ಅಂಶಿತ್ ಹೆಗ್ಡೆ 48
Respondent.
ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಈಗ ಪಿಟಿಷನ್ ಕೌನ್ಸಿಲ್ ಇಲ್ವಾ?
ಎಲ್ಲೂ ಬರೋದಿಲ್ಲ, ಅಲ್ಲೂ ಬರಲಿಲ್ಲ, ಇವನ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿಲ್ಲ.
ಮಾಡಿಲ್ವಾ? ಕರೆಕ್ಟ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಇದೆಯಾ?
ಅಲ್ಲ, ಸೆಷನ್ಸ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿಲ್ಲ.
ಇಲ್ಲಿ ರಿವಿಷನ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಯ್ತಲ್ಲ,
ಇಲ್ಲಿ ಆರ್ಡರ್
ಇಲ್ಲ ಮಾಡಿಲ್ಲ,
ಮಾಡಿಲ್ಲ, ಇದು ಮಾಡಿಲ್ಲ.
ಡಿಸ್ಕೌಂಟ್ ಬೈ ಆರ್ಡರ್ ಡೇಟೆಡ್ 14/2020. Deposit 30% of the fine amount, including the amount already deposited. Counsels of the petitioner submit that. Respondent submit that the said order has not been complied. And this court also subsequently passed an order on 16/1/2021. Directed to deposit the additional amount of 20% along with 30%. Totally, the petitioner will deposit 50% of the fine amount. Counsel for the respondent submits that no such payment is made and also not the bond of also not executed any bond before the report and none of when the matter is listed before the court. When such being the case, we have non-compliance of the order passed by this court on 14/2020 and also the 16/1/2021. The revision petition is dismissed.
My lords, I would like to come on record in this case, my lord. My lords, the earlier counsel has given NOC without intimating the petitioner, my lords. Hence, he was absent. Kindly, the warrant may be recalled before this. That's what, without intimation to the client. My lord, sir, ಇಲ್ಲಿ petitioner ಗೆ ಮತ್ತೆ the counsel who was on record had no communication, my lords. My lords, the earlier counsel who was representing High Court had given NOC to the counsel who was on lower court, my lords, not to the petitioner. ಇವಾಗ lower court, my lords, they had sought the NOC, my lords. Lower court. My lords, no, my lords, there was no communication between the petitioner and the counsel who was representing High Court, my lords. There was, because of miscommunication. Lower court advocate ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅವ್ರು ಇವಾಗ ತೀರ್ ಹೋಗಿದ್ದಾರೆ. My lords, recall ಮಾಡ್ಕೊಂಡು I'll come on record, my lords. My lords, warrant may be recalled.
Already he has stated that he has given no objection earlier, advocate.
My lords, I'm filing before this honorable court. Application filing before this honorable court.
Warrant recall ಪ್ರಶ್ನೆ ಬರೋದಿಲ್ಲ ಈಗ ಆಲ್ರೆಡಿ ವಾರೆಂಟ್ ಇಸ್ ಎಕ್ಸಿಕ್ಯೂಟೆಡ್. ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿದೆ ಸೂರಿಟಿಗೂ ಕೂಡ. ಸೂರಿಟಿ
One submission, my lord, the court house mic is on mute.
ಆಗ್ಲೇ ಡಿಸ್ಪೋಸ್ ಹಾಕಿದೆಯಲ್ರಿ ನಿಮ್ದು ಕಂಟಿನ್ಯೂ ಟು ಪೇ ದಿ ಅಮೌಂಟ್ ಆಫ್ rupees 2000 and 5000 ಅಂತ
ಕಟ್ತಾ ಇದೆ
ಮತ್ತೆ ಈಗೇನ್ ಸ್ಟೇ ಕೇಳ್ತೀರಿ ನೀವು?
ಅಲ್ಲ ಕನ್ಫ್ಯೂಷನ್.
ದೇವರೇ ಕಾಪಾಡ್ಬೇಕು ನಿಮ್ನೆಲ್ಲ.
ಅಲ್ಲ ಸರ್
ಆಲ್ರೆಡಿ ಆರ್ಡರ್ ಇದೆ ರೀ, ಕಂಟಿನ್ಯೂ ಟು ಪೇ ದಿ 2000 and 5000 ಅಂತ. ಅಕಾರ್ಡಿಂಗ್ಲಿ ದಿ ಆರ್ಡರ್ ಡೇಟೆಡ್ 9/3 passed by so totally it comes to rupees 7000. Maintenance shall be paid to them into total rupees 7000 per month regularly. The same shall be paid by the petitioner from the date of the order passed by the first appellate court in so and so. Pending disposal of this petition ಅಂತ ಆರ್ಡರ್ ಆಲ್ರೆಡಿ ಇದೆ, ಮತ್ತೇನ್ ಕೇಳ್ತೀರಿ? Call for records, list this matter on. ಅಲ್ಲ ನಾವೆಲ್ಲ ಓದ್ಕೊಂಡು ಆರ್ಡರ್ ಬರೆಯೋದ, ನೀವೇನ್ ಅಸಿಸ್ಟೆನ್ಸ್ ಕೊಡೋದು? ಕೊಡಿ, ಡೇಟ್ ಕೊಡಿ, ರೆಕಾರ್ಡ್ಸ್ ಬರ್ಲಿ. Registry is directed to get the records, list this matter on
23/1.
23/1.
50.
Serial number 50.
Karthik S. Nair.
Karthik S. Nair. B.N. Sunil Kumar.
For the petitioner, my lord.
ಹೇಳಿ.
The matter arises from section 138 proceedings. Concurrent findings have been raised against the accused, my lord. Both the trial court and the appellate court have held that have specifically noted that the complainant has paid to produce any proof of financial capacity, but merely on the ground of signature having been admitted. On that basis, the presumption has been raised, my lord. My lord, I would, the specific suggestion was made to the PW1. My lord, will find this finding of the regular first appellate court at para 20, my lord.
You have not led any defense evidence.
My lord, we have led defense evidence.
No, you have not led any.
That is an incorrect observation, my lord.
DW1.
We have led oral evidence.
No,
and we have also cross-examined the complainant and the
documents ಏನು ಹಾಕಿಲ್ಲ ಅಂತ.
Indeed, but the complainant in the cross-examination has categorically admitted that the legal liability was provided. The financial capacity was based on a site that was sold by him. And out of the proceedings of the site.
Madam. Call for records. This matter on. ಇಲ್ಲಿ ಶಿವಮೊಗ್ಗ ಇದ್ದಂಗಿದೆ. ಎಂಡಲ್ ಕೊಡಿ 31.
51. ಜಗದೀಶ ಡಿ.
There's an order to.
ಇದೆಲ್ಲ ಐಎಗಳೆಲ್ಲ ಡಿಸ್ಪೋಸಲ್ ಆದಾಗ ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ ಫಾರ್ ಆಗಿರಲಿಲ್ಲ. ಆಯ್ತು.
There is an order to deposit the cost of rupees
51.
IA for conducting deal was allowed on cost of rupees 1000. Directing the applicant to pay to the respondent. I have informed the local advocate to deposit, but till that they have not come. A week's time may be granted so that I will secure his presence and see that it is deposited.
ಕೊಡಿ, ಆರ್ಡರ್ ಏನಾಗಿದೆ ನೋಡಿ. ಡೆಪಾಸಿಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆರ್ಡರ್ ಆಗಿದೆಯಾ?
ಅಲ್ಲಿ ಕೊಡಿ ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆ. ಕಾಸ್ಟ್ ಕೊಡಿ ಅಂತ ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ.
ಕಾಸ್ಟ್ ಎಷ್ಟ್ರಿ?
1000 rupees.
ಅದ್ ಬರೀ ಕಂಡೋನೇಷನ್ ಆಫ್ ಡಿಲೇ.
ಹೌದು.
ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಗೆ ಏನಾರ ಆರ್ಡರ್ ಆಗಿದೆಯಾ?
ಅದಾಗಿದೆ. there is already an order.
ಆಗಿಲ್ಲ.
ಆಗಿದೆ. 3621 ಅಲ್ಲಿ ಆರ್ಡರ್ ಇದೆ.
ಯಾವಾಗ ಆಗಿದೆ? 50% ಕಟ್ಟಿದೀರಾ?
3621 ಅಲ್ಲಿ sentence is suspended subject to deposit of
ಆಯ್ತು. 3621 ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ.
ಹೌದು.
ಈ ಆರ್ಡರ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದೀರಾ?
ಅದರಲ್ಲಿ 24,000 rupees once ಕೊಟ್ಟಿದ್ದಾರೆ.
ಡೆಪಾಸಿಟ್ ಆಗಿದೆ my lords.
ಅಲ್ಲ 20
ಡೆಪಾಸಿಟ್ ಆಗಿದೆ ಕೋರ್ಟ್.
ಮಾಡಿದ್ದಾರೆ. ಈಗ ಓನ್ಲಿ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಡಿಸೈಡ್ ಮಾಡಬೇಕು ಅಷ್ಟೇ.
ಹೌದು.
ರೆಕಾರ್ಡ್ಸ್ ಇದೆಯಾ ನೋಡಿ ಮೇಡಮ್? ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್, ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 31.
ಕಾಸ್ಟ್ 1000 rupees ಕೊಡ್ಲಿಕ್ಕೆ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಕೊಡಿಸ್ತೀನಿ.
ಕಾಸ್ಟ್ ಯಾರು ಕಟ್ಬೇಕು? ನೀವ ಅವರ?
ಅಪೆಲೆಂಟ್ ಅಷ್ಟು
ನೀವೇ ಕಟ್ಬೇಕು. ರಿವಿಷನ್ ಪಿಟಿಷನರ್.
ಅಲ್ಲ, ಇದು IA was allowed
ಸರಿ, ಯಾರಿಗೆ ಕೊಡ್ಬೇಕು ಅಂತ ಇದೆ ಅದು?
ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ ಅಂತ ಇದೆ.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂತ ಇದೆ.
ಅವರು ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿರಲಿಲ್ಲ, ಹಂಗಾಗಿ
ರೆಸ್ಪಾಂಡೆಂಟ್ ಎಲ್ಲಿ ಬರ್ತಾರೆ? ಕೌನ್ಸಿಲ್ ಇದಾರೆ ಅಷ್ಟೇ ಇಲ್ಲಿ. ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂತ
ಇವತ್ತು ಇವರು ಲಾಸ್ಟ್ ಟೈಮ್ ಅವ್ರು ಇರಲಿಲ್ಲ, ಇವತ್ತು ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ.
ಕಂಡೌಂಡ್ ಅಂತ ಇದೆ, ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕು ಅಷ್ಟೇ. ಕೊಟ್ಬಿಟ್ಟು ರೆಸಿಪ್ಟ್ ತಗೊಳ್ಳಿ ಅಷ್ಟೇ.
ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಸೆಕ್ಯೂರ್
30th ರೆಕಾರ್ಡ್ ಬರ್ಲಿ.
ಆಯ್ತು.
52 urgent 53.
Sandesh TB. Suspension of sentence.
Please, madam.
6,50,000.
Please, madam.
ಎಷ್ಟು ಕಟ್ಟಿದಿರಿ ಈಗ?
What's the 30% we have?
50% ಕಟ್ಟಿ along with including the amount already been deposited.
Please,
2 lakhs ಗೆ bond ಬರ್ಕೊಡಿ.
please,
With one surety before the trial court within 4 weeks.
Please.
Deposit within 4 weeks. Call for records.
Notice.
Issue notice against respondent. Next, 54.
Four ಅರ್ಜುನ್ ಆಗಿದೆ ಸರ್.
ಅರ್ಜನ್ ಆಯ್ತಾ?
55.
55. Korumbaya TA, suspension of sentence.
Yes, ma'am.
6 ಲಕ್ಷ ಇದೆ. Same order. 50% deposit ಮಾಡಿ inclusive of already deposited within 4 weeks. And execute a bond for rupees 2 lakh with one surety before the trial court within 4 weeks. Call for records and issue notice against the respondent.
56.
56.
Please, my lords, for the petitioner. My lords, ಇದು DV Act ಇಂದ this arises out of DV Act. ಕುಮಾರ್ ಅವ್ರು ಕೇಳಿದೀನಿ, if the matter could be referred for mediation, my lords. ಅಲ್ಲಿ ಮಂಡ್ಯದಲ್ಲಿ ಮಾಡಿಸಿ ಅಂತ ಅವರು ಹೇಳಿದ್ರು ಬೆಳಗ್ಗೆ.
ಅಲ್ಲೇ ಹೋಗ್ತೀರಾ ಮೀಡಿಯೇಷನ್ಗೆ?
ಆಗ್ಬೋದು ಸ್ವಾಮಿ.
ಅವರು ಕನ್ಸೆಂಟ್ ಕೊಟ್ಟಿದಾರೆ ಅಲ್ಲಿ ಹೋಗ್ಲಿಕ್ಕೆ ಕುಮಾರ ಕೆಜಿ ಅವರು?
ಅವರು ಬೆಳಗ್ಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೆ, ಮಂಡ್ಯ ಆದ್ರೆ he had consented.
ಆಗ್ಬೋದು ಅಂತ ಹೇಳಿದಾರಾ?
ಆಗ್ಬೋದು ಅಂತ ಹೇಳಿದ್ದಾರೆ.
The matter is referred to the Mandya Mediation Center. And both parties are directed to appear before the mediation center at Mandya on 30th of January 2025 at 3 PM.
Grateful.
And submit the report on 5th of February.
Grateful.
57, Sandesh Kumar M.
Petition is matter, madam.
ಎಲ್ಲ ಎರಡೆರಡು ವರ್ಷ ಏನೋ ಪನಿಷ್ಮೆಂಟ್
Yes,
ಇದ್ದಂಗೆ
my lord.
ರೆಕಾರ್ಡ್ ಬಂದಿದೆಯಾ? ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ, sir.
ಆಗಿಲ್ಲ.
I have spent more than 21 months in the prison, madam, now.
ಆಲ್ರೆಡಿ ಜೈಲಲ್ಲಿ
Also.
21 months.
Under trial, 9 months. After the conviction, madam, from the trial court, madam, 1 year, madam.
ರೆಕಾರ್ಡ್ಸ್ ಬರ್ಲಿ, ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೋಣ.
Kindly.
ಈಗಲೂ ಕಸ್ಟಡಿಲಿ ಇದಾನ?
ಹೌದು ಸ್ವಾಮಿ.
ಏನ್ರಿ ಎಷ್ಟು ದಿವಸ ಆಯ್ತಾನೆ? ಗೆಟ್ ದಿ ರಿಪೋರ್ಟ್
ಪ್ಲೀಸ್.
ಈಗ ಆಲ್ರೆಡಿ UTP ಎಷ್ಟು ದಿವಸ ಇದ್ದ ಮತ್ತೆ ಆಫ್ಟರ್ ಕನ್ವಿಕ್ಷನ್ ಎಷ್ಟು ದಿವಸ ಇದ್ದ ನೋಡಿ ಸೆಟಪ್ ಮಾಡೋಣ. ಅದೇನು ಇನ್ನ ಆಲ್ರೆಡಿ 21 months ಅಂತೆ. ಇರೋದೇ 2 years ಎರಡು ಅಫೆನ್ಸ್ಗೆ.
ಮ್ಯಾಕ್ಸಿಮಮ್
354 2 years, 354D ಗೆ 2 years. ಕನ್ಕರೆಂಟ್ ಮಾಡಿದ್ರೆ ಆಯ್ತು, ಸೆಟಪ್ ಮಾಡಿದ್ರೆ ಆಯ್ತು. ಯು ಗೆಟ್ ದಿ ಡೀಟೇಲ್ಸ್
ಪ್ಲೀಸ್.
ಮಂಡೇ 15th ಬೇಕಾ? ಆಯ್ತು. The counsel appearing by the petitioner would submit that the petitioner already undergone punishment for a period of 21 months, including as UTP and also the after the conviction. And hence the additional ನೀವೇನು HCGP na? HCGP is directed to get the information regarding the submission of the petitioner and list this matter on 15/1. Yes, ತರಿಸ್ಕೊಳ್ಳಿ.
PA Shobit and Shetty.
Shobit and Shetty. Suspension of sentence,
Yes, ma'am.
same order.
15% already deposited.
50% inclusive of deposit made earlier.
59.
Bond ಇದನ್ನ 23 ಲಕ್ಷ ಇದೆಯಾ?
ಹೌದು, 23 ಲಕ್ಷ ಸರ್.
Execute a bond for rupees 5 lakh with 2 sureties before the trial court within 4 weeks.
And
Call for records, issue notice. 1 month ಆದ್ಮೇಲೆ ಕೊಡಿ ಮೇಡಮ್ ಇವೆಲ್ಲ ಡೇಟ್. ಯಾವ್ಯಾವ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದು ಅವೆಲ್ಲ 1 month ಆದ್ಮೇಲೆ, ಯಾಕೆಂದ್ರೆ ಅವ್ರು 1 month ಟೈಮ್ ಕೊಟ್ಟಿರ್ತೀವಿ ಡೆಪಾಸಿಟ್. 10-2. ಅದು ಹಿಂದಿಂದ ಯಾವ್ದು ಆಯ್ತಲ್ಲ ಮೇಡಮ್, ಅದು ಅಷ್ಟೇನೆ 10-2.
6,15,000.
6,15,000. 59 serial number 59. ಅದರಲ್ಲಿ 50% ಡೆಪಾಸಿಟ್ ಮಾಡ್ಲಿ, ಜೊತೆಗೆ ಇದು 2 lakh bond with 1 surety before the trial court within 4 weeks. Call for records, issue notice.
Including deposit.
Including ಅದೆಲ್ಲ ಸೇಮ್.
Jairaj.
1 ಲಕ್ಷ ಇದೆ ಫೈನ್.
ಎಷ್ಟು ಕಟ್ಟಿದಿರಿ?
20% ಕಟ್ಟಿ.
ಆಯ್ತು, 50% ಕಟ್ಟಿ inclusive of already deposited 50,000 rupees with 1 surety.
Reporting settlement.
Before the trial court.
appearing for the LS of the respondent, my lord.
Yes, madam, release of amount paid by counsel for respondents.
Please, my lord, the petitioner has made an offer for settlement. Our clients are not in agreement with that amount, my lord. We have communicated the same to the petitioner counsel. They are yet to get back on that. Meanwhile, we have also filed an application for release of amount, my lord. That may kindly be allowed, and if petitioners are
May I
coming
make one
up with-
submission. But on the last day, coordinate bench, my lords, proposed, my lords, parties to settlement. My lords, settlement talks are going on. No particular amount, my lords, has been, my lords, arrived at by both the parties. No, my lords, I have deposited, my lords, 36 lakhs. Now, my lords, if there is, my lords, a particular amount that, my lords, we settle, then, my lords, it can be, my lords, considered. Now, my lords, it is too premature, my lords, for her to, my lords, seek withdrawal of the money. Therefore, my lords, my request is, they have also, my lords,
ಸೆಟ್ಲ್ಮೆಂಟ್ ಮಾಡ್ತೀರಾ ಏನು?
settlement ಗೆ ಅಂತಾನೆ ಮಾತಾಡ್ತಾ ಇದೀವಿ.
ಮಾತಾಡಿ, ಕರ್ಸಿ, ಪಾರ್ಟಿ ಕರ್ಸಿ, ಯಾವ ಕರ್ಸ್ತೀರಿ? You get your party.
My lord, the LRs of the
19 revision petition.
ಅದು ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲೇ ಮಾತೆಲ್ಲ ಆಡಿದೀವಿ. ಇನ್ನು ಅಮೌಂಟ್
ಎಲ್ಲ ಆಡ್ಲಿರಿ, ನೀವು
Correct,
ಮಾತಾಡ್ತಾನೆ ಇರಿ,
understand.
ಪರವಾಗಿಲ್ಲ, ಸೆಟ್ಲ್ ಆಗುತ್ತಾ ಯಾವಾಗ ಹೇಳಿ,
ಆಗುತ್ತೆ.
ಆ ಟೈಮ್
ಫೈನಲ್ ಅಮೌಂಟ್ ಫಿಕ್ಸ್ ಆಗಿದೆ.
ಯಾವಾಗ ಬೇಕು?
1 week, my lords.
1 week.
1 week.
ಇಲ್ಲ ಅಂದ್ರೆ
My lord-
ರಿಲೀಸ್ ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ.
ಅಲ್ಲ,
settle
ಇಲ್ಲ,
ಆಗ್ಲಿಲ್ಲ.
I'll file my objection, my lord, because, my lords, they are, my lords, not even, my lords, if at all there is a settlement, they ought not to have, my lords, filed this application for withdrawal.
Petitioner counsel
My lord-
seeks time.
My lord, may I make one submission?
ಹೇಳಿ
The
madam.
LRs of the respondent, that is Ryan Amravati, she is undergoing serious medical ailment, my lord. The reason we have filed this application is she needs funds, my lord. She is on and off on hospital. We are
Madam,
in-
he seeks 1 week time to get to the party.
Please, my lord.
To settle
We
the
have
matter once for all. I will,
Please, my lord.
otherwise I will consider the application and let him also file objections to IA.
Please, my lord.
Petitioner counsel seeks 1 week to settle the matter and also seeks 1 week time to file objections to IA 1/25. And hence this matter next Thursday kodi madam. Thursday na to Friday kodi.
Please.
17/1.
My lord. Please, my lord.
17/1.
Please.
Please.
62. ಎಲ್ ರಾಜಣ್ಣ?
ಎಷ್ಟೊತ್ತಾಗುತ್ತೆ ನಿಮ್ದು? 15 minutes. Okay. ಎಲ್ಲ ಪಾರ್ಟ್ ಆಡಿದೆ. ಕ್ರಿಮಿನಲ್ ರಿವಿಷನ್ ಪಿಟಿಷನ್ಸ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ನಾವು ವೇಟ್ ಮಾಡೋದು ಬೇಡ. ಡೇಟ್ ಕೊಡ್ತೀನಿ. 67 onwards, no need to wait.
69, may I request on 21st?
69.
21st.
21st ಅದರ್ ಸೈಡ್ ಇದಾರಾ?
ಅಲ್ಲ, state, I have to deposit.
Date ತಗೊಳ್ಳಿ. ಯಾವಾಗ? 21st?
21st.
69. Appellant revision petitioner counsel seeks time. This matter on
21st.
21/1.
I have deposit balance amount also.
Present.
ಅದರಲ್ಲಿ ಏನಾಗಿತ್ತು, 50,000 ಬಾಂಡ್ ಅಮೌಂಟ್ ವಾರಂಟ್ ಆಗಿತ್ತು ನನ್ನ ಆಬ್ಸೆನ್ಸ್ ಇದ್ದ. She was arrested. 50,000 ಬಾಂಡ್ ಹಾಕಿದ್ದು, 35,000 ಕಟ್ಟಿದ್ದೇನೆ. ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ಅಲ್ಲಿ ಮೆಮೋ ಹಾಕಿದ್ದೆ. ಬ್ಯಾಲೆನ್ಸ್ 15,000 ವಿದಿನ್ ದಟ್ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಪೇ ದ ಅಮೌಂಟ್.
ಕಟ್ಟಿ, ಅದೇನು ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಈಗ. ನೋಡೋಣ. ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ 21/1.
70 ಮೇಲೆ
70. ಯಾವತ್ ಬೇಕು ಹೇಳಿ.
ಪೂಜಾರಿ ಅವರು ಐ ಸರ್ಜರಿ ಆಗಿದೆ ಸ್ವಾಮಿ.
ವಿಶ್ವನಾಥ ಪೂಜಾರಿ. ಯಾವಾಗ ಬೇಕು ಡೇಟ್?
2 weeks.
2 weeks ಕೊಡಿ. 21/1.
Please.
Serial number 75, Lordship.
75. ಹೇಳಿ ಏನು?
I am for the respondent.
ಯಾವತ್ ಬೇಕು ಹೇಳಿ.
Some discussion of settlement going on.
ಯಾವತ್ ಬೇಕು ಹೇಳ್ರಿ.
2 weeks, Lordship.
2016 after 2 weeks ಇಲ್ಲ. 21/1. ಅಷ್ಟೊಳಗೆ ಸೆಟಲ್ಮೆಂಟ್ ಇದ್ರೆ ಮಾಡ್ಕೋಬಹುದು, ಇಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕು. 2016ನೇ ಇಸ್ವಿ ಮ್ಯಾಟ್ರು. 78 ಹೇಳಿ ಯಾವಾಗ ಬೇಕು? ಕೊಡ್ರಿ, ಡೇಟ್ ಕೊಡ್ರಿ. 23 21/1. 21/1 ಮುಂದಿನ ವಾರದಲ್ಲಿ
Serial number 77. 78. 78 there is an interim order.
ಎಂಟ್ರಿ ಮಾಡು ಗ್ರಾಂಟೆಡ್ ಅರ್ಲಿಯರ್ ಇಸ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್. ಏನ್ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಾ? ಇದ್ರೆ ಮಾತ್ರ.
78 ಅಲ್ಲಿ ಇದೆ.
ಇದ್ರೆ ಮಾತ್ರ ನೋಡಿ ಮೇಡಮ್. 78 ಅಲ್ಲಿ 21/1 ಅಂತ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ. ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ ಅಷ್ಟೇ. ಆಯ್ತು.
7 ಮೇಲೆ.
ಹೇಳಿ ಯಾವ್ದು ಬೇಕು?
Any date in the first week of
ಫಸ್ಟ್ ವೀಕ್ ಆಫ್
February.
ಅಷ್ಟು ಕೊಡೋದಿಲ್ಲ.
22nd.
ಅಲ್ಲಿವರೆಗೆ ಕೊಡೋದಿಲ್ಲ. ಮುಂದಿನ
2022 meet.
21/1. 21/1. Yes, counsel, continue.
In the last date of hearing, I have read the entire client and
Client and return statement.
written statement, my lord. This is in respect of substantial question of law number 1, my lords. I am presenting this submission. Whether the courts below have committed perversity in the manner of consideration of the evidence available on record with regard to the proof of document of Exhibit D1, 1/1/1975, and in that regard, whether the reasons stated by the courts below would constitute suspicious circumstances as enumerated and decided by several decisions. In second question antu namdenilla Swami. Mugdogbiಟ್ಟು. Now I am addressing on question number 1. Later I will go to question number 3. Now, my lord, in the last state of hearing, I have read the entire plaint and the statement, my lord. Nowhere in the plaint, the plaintiff have disputed the will or pleaded the invalidity of the will. My lord, there are 3 occasions for the plaintiff to challenge the will, my lords. One is, my lord, on the date of filing of the suit, that is at the time of framing of the suit or filing of the plaint on 13/3/96. Suit file ಮಾಡುವಾಗಲೇ ಹಾಕ್ಬೋದಾಗಿತ್ತು ಅವರು, ಚಾಲೆಂಜ್ ಮಾಡಬಹುದಾಗಿತ್ತು ಒಂದು ಪ್ಯಾರಾಗ್ರಾಫ್. ಹೇಗೆ ಅಂದ್ರೆ, prior to filing of the suit on 15/10/92, ಅಂದ್ರೆ date of filing of the suit is 13/3/96. Prior to filing of the suit, plaintiff has issued legal notice on 25/9/1992 to the defendant. On 15/10/92, the defendant replied the said legal notice and propounded the will dated 1/1/1975.
ವಿಲ್ಲಿನ ಬಗ್ಗೆ ಆಲ್ರೆಡಿ ಹೇಳಿದ್ದಾರೆ ಅಂತ.
Will ಬರ್ದಿದ್ದಾರೆ ಅಂತ ನಾವು ಅವತ್ತೇ ಹೇಳಿದ್ವಿ 4 years back, much prior to filing of the suit. So on the framing of the suit, that is on the date of in the presenting the plaintiff kudanu, they have not disputed the will. First manner. And the second one is on 15/10/92. No, my lord. After filing of the suit, the defendant filed a WS written statement on 22/8/1996, my lord. 22/8/1996.
WS.
On that, in the written statement also, the defendant have propounded the will and reminded the earlier legal notice, my lord. So even after filing of the written statement also, they have not chosen to dispute the will or plead the invalidity of the will. And on the next third occasion, my lords, the suit filed on 13/3/1996 and decided on 18/8/2007, my lords. That is after 11.5 years, my lord. During the pendency of the suit before the trial court, my lord, the plaintiff did not choose to challenge that will. Third occasion, my lord. Now, my lord, the other side is arguing only on the invalidity of the will without any pleadings, my lord. That is my submission. Then your lordship may kindly take the trial court judgment, my lord, at para 45, page 43, my lords. This is very. My first submission is there is no challenge to will. When there is no challenge to will, there is no occasion, there is no suspicious circumstances, my lord, for the. That's it. Kindly see para 45 of the trial court judgment, my lord. Oh, I will 45. Page 33. There is serious dispute about execution of will by deceased Kamaya. This is the only sentence, my lord. This has no foundation. This is the only one sentence regarding dispute of the will by the trial court, my lord. Nowhere in the plaint or nowhere in the evidence, there is no dispute about the will. There is no challenge to will. There is no challenge to invalidity of the will. Therefore, my submission is there is no constitute of suspicious circumstances in this case. And the FSL reports, my lord, both on the signature and the thumb impression of testator Kamaya have detailed, the authors have detailed the circumstances and the scientific report has been given, my lord, that I will agree in toto, my lords. Therefore, there is no suspicious circumstances. And regarding the deposition of PW 1 to 4, my lord, kindly see. This is very important. PW 1 to PW 4. From page, my lords, 112. This is PW1 is Nagaraja, my lord. He is age 32 years on 2002. At the time of execution of the will, he is just hardly 5 years, my lord. Earlier also I have stated, I argued that. So he is not competent to depose the will, depose on the point of 1175 will, my lord. And your lordship may kindly see from starting from first paragraph till the end, they have only said about the will dated 5597, that is exhibit P2, not on exhibit P1, D1, my lord. Kindly note. That is the will executed by the original plaintiff. Will dated 5597, exhibit P2. Your lordship kindly
ಏನದು exhibit P2 ಏನು?
ಅವ್ರದ್ದು will, ಸ್ವಾಮಿ.
ಅವ್ರ will.
Pendency of the will, pendency of the suit.
Will was executed.
Plaintiff was submitted a death certificate stating that the plaintiff is dead. Before expiry, she executed a will. On the basis of that will, they were contesting. And the reliefs was granted in favor of the present respondents on the basis of exhibit P2. Your lordship may kindly 114 ಬನ್ನಿ ಸ್ವಾಮಿ, one sentence ತೋರಿಸ್ತೀನಿ. I have produced the registered will at exhibit P2. Third line, my lord. 114 ಅಲ್ಲಿ. Third line.
Examination in chief ಅಲ್ಲ?
Chief ಅಲ್ಲಿ ಸರ್. ಅದೊಂದು ಹಾಕಿದ್ದಾರೆ. Then, my lords, ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ 115 ಬನ್ನಿ.
ಅದ್ರಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ರು 114 ನಿಮ್
ಅದು ಅವರು ಅಂದ್ರೆ ಇದು
ಟ್ಯಾಲಿ ಆಗ್ತಾ ಇಲ್ಲ ನಿಮ್ ನಂಬರ್ ಮೋಸ್ಟ್ಲಿ 114 ಅಲ್ಲೇ ಕಮೆಂಟ್ಸ್ ಆಗೋದು ಎವಿಡೆನ್ಸ್.
ಹಾಗಾದ್ರೆ
ಈ ಕೊಟ್ಟಿರೋದ್ರಲ್ಲಿ
16 ಬನ್ನಿ 116. 116 ಅಲ್ಲಿ ಫೋರ್ತ್ ಲೈನ್, ಐ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ ದಿ ರಿಜಿಸ್ಟರ್ಡ್ ವಿಲ್ ಡೇಟೆಡ್ ಆಸ್ ಪರ್ ಎಕ್ಸಿಬಿಟ್ P2. ಅಂದ್ರೆ ಈ ಎಂಟೈರ್ ಎವಿಡೆನ್ಸ್ ಚೀಫ್ ಎವಿಡೆನ್ಸ್ ಆಫ್ ಚೀಫ್ ಈಸ್ ಬೇಸ್ಡ್ ಆನ್ ಎಕ್ಸಿಬಿಟ್ P2. ಆಮೇಲೆ ನಮ್ದು ಹೇಳಿದರೆ ಇದನ್ನ ಆಮೇಲೆ ತೋರಿಸ್ತೀನಿ. ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಬನ್ನಿ. ಒಂದು ಕನ್ನಡದಲ್ಲಿ ಮಧ್ಯ ಒಂದು 5-6 ಲೈನ್ ಆದ್ಮೇಲೆ, ದೊಡ್ಡ ಕಾಮಯ್ಯನವರಿಗೆ ಮಕ್ಕಳು ಇಲ್ಲದೆ ಇದ್ದುದರಿಂದ ಸಿದ್ದಮ್ಮನವರನ್ನು ದತ್ತು ಮಗಳಾಗಿ ಪಡೆದುಕೊಂಡಿದ್ದರಿಂದ ಮತ್ತು ಕೊನೆ ಕಾಲದಲ್ಲಿ ದೊಡ್ಡ ಕಾಮಯ್ಯನವರ ಯೋಗಕ್ಷೇಮವನ್ನು ದೊಡ್ಡ ಕಾಮಯ್ಯನವರು ನೋಡಿಕೊಳ್ಳುತ್ತಿದ್ದರಿಂದ ದಿನಾಂಕ 1/1/75 ದೊಡ್ಡ ಕಾಮಯ್ಯನವರು ದಾವಾ ಸ್ವತ್ತುಗಳ ಬಗ್ಗೆ ಸಂಬಂಧವಾಗಿ ಸಿದ್ದಮ್ಮನವರ ಹೆಸರಿಗೆ ಒಂದು ವಿಲ್ಲನ್ನು ಬರೆಸಿದ್ದಾರೆ ಎಂದರೆ ನಿಜವಲ್ಲ. ಅಂದ್ರೆ ನಮ್ಮ ಅಡ್ವೊಕೇಟ್ ಒಂದು ಕ್ರಾಸ್ ಮಾಡಿದ್ದಾರೆ, 1175 ವಿಲ್ ಇದೆ ಅಂದ್ರೆ ಈವನ್ ಅವರು ಇಲ್ಲ ನಿಜ ಇಲ್ಲ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಅಂದ್ರೆ there is no dispute about the will dated 1/1/1975. ಅವ್ರ ಏನಂದ್ರೆ ಹಂಗೆ ಹೇಳ್ಕೊಟ್ಬಿಟ್ಟಿರ್ತಾರೆ ಇಲ್ಲ ಅಂದ್ರೆ ಅಂತ. ಅದು ಬಿಟ್ರೆ ಇನ್ನೇನಿಲ್ಲ ಸ್ವಾಮಿ. ಇದರಲ್ಲಿ 1/1/1975 ವಿಲ್ ಬಗ್ಗೆ ಏನಿಲ್ಲ, ಎಲ್ಲ ಬರೀ 5597 ಕೇಳ್ತಾರೆ. ಶಿ ಇಸ್ ದಿ ಡಾಟರ್ ಆಫ್ ಟೆಸ್ಟೇಟರ್ ಅಂತ. ಆಮೇಲೆ ಈಸ್ ದಿ ಬೆನಿಫಿಷಿಯರಿ. ಆಮೇಲೆ PW2 ಬನ್ನಿ. ನೆಕ್ಸ್ಟ್ 119 ಇವರು ಕೂಡ ಹಂಡೆ ಚಿಕ್ಕನಹಳ್ಳಿ ವಿಲೇಜ್, ಕುಂಟೇಗೌಡನಹಳ್ಳಿನವರಲ್ಲ. ಯಾಕಂದ್ರೆ ನಮ್ಗೆ ಹೇಳ್ತಾ ಇದ್ರು ಬೇರೆ ಬೇರೆ ಊರಿಂದ ಕರ್ಕೊಂಡು ಬಂದು ಎವಿಡೆನ್ಸ್ ಹೇಳ್ಸಿದ್ದಾರೆ ಅಂತ, ವಿಟ್ನೆಸ್ ಹಾಕ್ಸಿದ್ದಾರೆ ಅಂತ. ಅವ್ರು ಕೂಡ ನೋಡಿದ್ರೆ ಹಂಡೆ ಚಿಕ್ಕನಹಳ್ಳಿ ಈಸ್ ಬಹಳ ದೂರದಲ್ಲಿರೋದು. ಇದು ಕೂಡ 5597 ಬಗ್ಗೆನೇ ಹೇಳಿದ್ದಾರೆ ಸರ್. 5597 ಬಗ್ಗೆ 1197 ಬಗ್ಗೆ, 1175 ಬಗ್ಗೆ ಇಲ್ಲ. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ 121 ಬನ್ನಿ. ಇಲ್ಲಿ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಕೈಂಡ್ಲಿ ನೋಡಿ. ಒಂದು 8 lines ಫ್ರಮ್ ದಿ ಟಾಪ್. It is true, Kamaya was healthy and he was possessing sound mind till his death. ಅಂದ್ರೆ ನಮ್ ಸಪೋರ್ಟ್ ಮಾಡಿ ಹೇಳಿರೋದು, ಅದನ್ನ ನೋಟ್ ಮಾಡಿ ಸ್ವಾಮಿ. ನೆಕ್ಸ್ಟ್ ಸೆಂಟೆನ್ಸ್, ಇಟ್ ಈಸ್ ಫಾಲ್ಸ್ ಟು ಸಜೆಸ್ಟ್ ದಟ್ ಡ್ಯೂರಿಂಗ್ ಹಿಸ್ ಲೈಫ್ ಟೈಮ್ he executed will in favor of defendant in respect of his properties in the year 1975. ನಮ್ಮ ಕ್ರಾಸ್ ನಲ್ಲಿ ಅವರು ಇದನ್ನ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡೋದೇ ಇಲ್ಲ, ನೋ ಅಂತ ಹೇಳ್ತಾರೆ. ವೆರ್ಬ್ಯಾಟಮ್ ಫಸ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದಾರೆ DW1 PW1 ಅದನ್ನೇ PW2 ಹೇಳ್ತಾ ಇದೆ. ದೆನ್ 123 ಬನ್ನಿ. ಇವರು PW3 ಇವ್ರ ಹೆಸರು ಎಂ ರಂಗಪ್ಪ ಅಂತ. ಕೈಂಡ್ಲಿ ನೋಟ್ ಮೈ ಲಾರ್ಡ್, ಈಸ್ ದಿ ಫಸ್ಟ್ ವಿಟ್ನೆಸ್ ಟು ದಿ ಸೆಕೆಂಡ್ ವಿಲ್ ಅವ್ರದ್ದು. ನೆಲಮಂಗಲ ತಾಲೂಕು ಮಾಕೇನಹಳ್ಳಿ ಮೈ ಲಾರ್ಡ್. ಸಿರಾದಿಂದ ನೆಲಮಂಗಲಕ್ಕೆ 100 kilometers ಆಗುತ್ತೆ ಮೈ ಲಾರ್ಡ್. ಕೈಂಡ್ಲಿ ನೋಟ್ ದಟ್ ಮೈ ಲಾರ್ಡ್. ಇಲ್ಲಿ ಏನೋ ಬುಕ್ಕಾಪಟ್ನ ಅವರು 10 kilometer 20 kilometer ಕರ್ಕೊಂಡ್ ಬಂದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ. ನೆಲಮಂಗಲ ತಾಲೂಕು ಬೆಂಗಳೂರು ಇಲ್ಲೇ ಪಕ್ಕದಲ್ಲಿದೆ ಸರ್. 100 kilometers ಫ್ರಮ್ ಸಿರಾ. ಇದು ಕೂಡ ವೆರ್ಬ್ಯಾಟಮ್ ಸರ್. 5597 ವಿಲ್ ಬಗ್ಗೆನೇ ಹೇಳ್ತಾರೆ. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಅಗೈನ್ ಇದು ಇಂಪಾರ್ಟೆಂಟ್ ಸ್ವಾಮಿ. 126 ಮೇಲೆ ಒಂದು 6 lines ಮೇಲಿಂದ. ಇಟ್ ಈಸ್ ಫಾಲ್ಸ್ ಟು ಸಜೆಸ್ಟ್ ದಟ್ ಲೇಟ್ ಕಾಮಯ್ಯ ಹ್ಯಾಸ್ executed a registered will in favor of defendant on 1/1/1975 and bequeathed the suit. ಅಂದ್ರೆ ಜಸ್ಟ್ ನಮ್ ವಿಲ್ ಬಗ್ಗೆ ಕ್ವಶನ್ ಕೇಳಿದ್ರೆ ಡಿನೈ ಮಾಡ್ತಾರೆ, ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಲ್ಲ. ಆಮೇಲೆ ಅನದರ್ ಟ್ರೂ ಲೈನ್, ಇನ್ನೆರಡು ಕೆಳಗಡೆ ಲೈನ್ ನಲ್ಲಿ, ಇಟ್ ಇಸ್ ಟ್ರೂ ದಟ್ ಅಟ್ ದಿ ಟೈಮ್ ಆಫ್ ದಿ ಡೆತ್ ಆಫ್ ದಿ ಲೇಟ್ ಕಾಮಯ್ಯ ವಾಸ್ ಇನ್ ಸೌಂಡ್ ಹೆಲ್ತ್ ಅಂಡ್ ಸೌಂಡ್ ಸ್ಟೇಟ್ ಆಫ್ ಮೈಂಡ್. Therefore, PW2 and 3 support the case of the defendant, stating that the testator was sound health and is having a good state of mind till death. Verbatim, my lords, 1 to 4. Then PW4, my lords, 128. ಇಲ್ಲಿ ಯಾರು BC ಬಳೆಪ್ಪ ಅಂತ ಹೇಳ್ತಾರೆ. ಈಸ್ ಫ್ರಮ್ ಬಾಲೆನಹಳ್ಳಿ, ಒಂದು 15 kilometer ಆಗುತ್ತೆ ಅವ್ರ ಊರಿಗೆ. ಸೊ PW ಇಲ್ಲೂ ಕೂಡ ಸೇಮ್ ಈಸ್ ಡಿಪೋಸಿಂಗ್ ಆನ್ 5597, ನಾಟ್ ಆನ್ 1/1/1975 ವಿಲ್ ಮೇಲೆ ಹೇಳೋದಿಲ್ಲ. ಅವರು ಕಾಮಕ್ಕ ಇದು ಪ್ಲೇಂಟಿಫ್ ಕಾಮಕ್ಕನ್ ಮಗಳು ಅಂತ ಹೇಳಿಸ್ಕೋತಾರೆ. ಅದಕ್ಕೆ ಅದು ಬಿಟ್ರೆ ಇವರು ಕೂಡ ಒಂದು ಕ್ವಶನ್ 131 ಬನ್ನಿ ಸ್ವಾಮಿ. 131ಗೆ ಲಾಸ್ಟ್ 10 lines ಸ್ವಾಮಿ. I do not know that Kamaya has bequeathed the suit scheduled properties under a will in favor of defendant in the year 75. ಅಂದ್ರೆ ಒಂಥರ ಕೋರಸ್ ಇದ್ದಂಗೆ, ಯಾರು ಕೂಡ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡೋದಿಲ್ಲ ಸ್ವಾಮಿ. ಅಂಡ್ ಮೋರ್ ಓವರ್ PW1 to 4 deposed only on the facts of the will exhibit P2 dated 5/5/1997. Second will, first will ಗಂತೂ ಇಲ್ವೇ ಇಲ್ಲ. Then your lordship may kindly come to the issues framed by the trial court, my lord, at page 31. Page 31. Calgadation, from the following facts. Whether the plaintiff proves that she is the daughter of Kamaya, whether the plaintiff proves that she is the owner of suitable properties, whether the defendant proves that Kamaya executed registered will dated 1175 in her favor bequeathing the suitable properties. ಅಂದ್ರೆ ಇಶ್ಯೂ ಇರೋದು 11-1975 ಸ್ವಾಮಿ ನಮ್ ವಿಲ್ಗೆ. And whether the plaintiff is entitled to declaration so and so. Next, whether the plaintiff is entitled for possession of the suit, so next page, my lord. Whether the plaintiff is entitled for mean profits. Additional issue, whether the defendant, second defendant proves that his mother Kamaka purchased the item number 2 of the suit properties under registered date 18/10/1960, my lord. Nowhere in the issues, there is no issue framed by the trial court regarding the will dated 5/5/1997 executed by the plaintiff in favor of the present respondents. But the trial court as well as the first appellate court recorded the entire findings on the will dated 5/5/97, which is not in issue. Which is not in issue, my lord. Only on the basis of oral evidence of the PW 124. Here, my lord, the deposition of PW 1 to PW 4, my lords, as per law, my lord, there is no evidentiary value, my lord. Without pleading, without an issue on 1/1/1975 will, the deposition of PW 1 to 4, PW 4 have no evidentiary value in the eye of law. What they have stated in the deposition, there is no issue, there is no pleading. Then, my lord, you will ask me kindly turn to my defendant's witness, my lord. 133. Here, my lord, DW1, Siddham, original defendant, deposed in the chief verbatim as in the written statement and reply notice, my lord. Here, on number of occasions, the other side posed the question, do you know plaintiff is the daughter of Kamaya? For that, the witness stated that I do not know. When there is no children to the testator, how can she admits, my lord? And nothing has been in the cross-examination. Nothing has been transpires. She has categorically stated exhibit D1 was executed by Kamaya and all the properties are transferred in my name and I am enjoying the suitable properties as the. In the cross-examination also, my lords, there is no discrepancy because she is the original defendant and she is the beneficiary. Then, my lord, attesting witnesses, DW2, page 142, my lord. But he is the V.E. Ishwarappa. He is none other than the father of the beneficiaries. That is the appellant number 1 and 2, my lord. He has stated that as per the directions of the testator, I came to Sira and I have put my signature and I have identified his signature, my lord. And my learned friend state that he is settled in, his native is Bukkapatna, he is 30 kilometers distance. What is the necessity for the testator to call him? They are all hypothetical, my lords. Then, my lords, ಸ್ಟಾಂಪ್ ಪೇಪರ್ ಯಾವಾಗ ತಗೊಂಡ್ರು, ಬೆಳಿಗ್ಗೆ ತಗೊಂಡ್ರ, ಸಾಯಂಕಾಲ ತಗೊಂಡ್ರ, ರಿಜಿಸ್ಟ್ರೇಷನ್, ದೇ ಆರ್ ಆಲ್ ಅರ್ಥಮೆಟಿಕಲ್ಸ್. Next, my lord, your lordship may kindly turn to this witness, DW 3 minutes. Marikamaya. And cross examination, your lordship, 153. Middle al barutte samay, 10 lines to 12 lines admele. The deceased Kamaya has affixed his signature. Lordship got my lord? On the 12 lines admele. This is very important. The deceased Kamaya has affixed his signature on each page of Exhibit D1. After the affixing the signature of deceased Kamaya, nothing was written in Exhibit D1. It is not true to say that the deceased Kamaya never affixed any signature in our present on Exhibit D1. ಇದೊಂದು ಕ್ವಶನ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಚೆನ್ನಾಗಿ ಕೇಳಿದ್ದಾರೆ ಅದರ್ ಸೈಡ್ ನವರು. ಬೇರೆಯವ್ರಿಗೆ ಇದು ಯಾವ ತರದ್ದು ಕ್ವಶನ್ ಕೇಳಿಲ್ಲ. ಅಂಡ್ ದಿಸ್ ವಿಟ್ನೆಸ್ ಹ್ಯಾಸ್ ಗಿವನ್ ಎ ಆನ್ಸರ್ ಆಸ್ ಪರ್ ಸೆಕ್ಷನ್ 63, my lord. Madam, recent judgment, my lord. Not this. Probably your lordship's. A small judgment. Irli. Here, my lord. First, there are two judgments, my lord. In the first judgment, the testator lived only for 7 days, my lord, after execution. First judgment. And the apex court, my lord, has cut short the details, elaborate in the considering the will, my lord. Your lordship may kindly turn to page 5, ink page 5, my lords. Idra last sentence al one kade heltare. We can, you got, my lord?
Yes.
We can infer the following principles required for proving the validity and execution of the will. Then, my lord, the apex court has pointed out in nutshell, my lord, what are the points to be considered. First one is the court has to consider two aspects, my lord. First, the will executed by the testator, and secondly, that it was the last will executed by him. Second one is very important, kindly note, my lord. Roman 2. It is not required to be proved with mathematical accuracy, but the test of satisfaction of the prudent mind has to be applied. And a will is required to fulfill all the formalities required under Section 63 of the Succession Act. That is to say, the testator shall sign and affix his mark to the will, or it shall be signed by some other person in his presence and by his direction, my lords. Kindly note. By his direction, and the said signature or affixation shall show that it was intended to give effect to the writing as a will. It is mandatory to get it attested by 2 or more witnesses, though no particular form of attestation is necessary. Each of the attesting witness must have seen the testator sign or affix his mark to the will, or has been some other person sign the will in the presence and by the direction of the testator, or has received from the testator a person acknowledgement of such signature. Each of the attesting witness shall sign the will in the presence of testator. Your lordship may kindly note. However, the presence of all the witnesses at the same time is not required. Nam case nalli my learned friend is canvassing that you sign ಮಾಡುವಾಗ ಅವರು ಇರಲಿಲ್ಲ, ಅವ್ರು sign ಮಾಡುವಾಗ ಇರಲಿಲ್ಲ. It is not required at the same time. And then, my lord, for the purpose of proving the execution of will, at least one of the attesting witness who is alive, subject to the process of court and capable of giving evidence.
Yes.
The attesting witness should speak on not only about the testator's signature, but also that each of the witnesses had signed and the will in the presence of the testator. If one attesting witness can prove the execution of the will, the examination of other attesting witnesses can be dispensed with. Where one attesting witness examined to prove the will fails to prove its due execution, then the other available witness has to be called and to supplement his evidence. Then whenever there exists any suspicion or as into the execution of the will, it is the responsibility of the propounder to remove all legitimate suspicious before it can be accepted as the testator's last will. In such cases, the initial onus on the propounder become heavier. The test of judicial conscience has been evolved for dealing with those cases where the execution of the will is surrounded by suspicious circumstances. It requires to be factors such as awareness of the testator as to the content as well as the consequences, nature and effect of dispositions in will, sound, certain, and disposing state of mind and memory of the testator at the time of execution. Testator executed the will while acting on this will. 10th one, my lord, is very important. Kindly note, my lord. One who alleges fraud, fabrication, undue influence, etc. has to prove the same. ಇಲ್ಲಿ ನಮ್ಮಲ್ಲಿ ಬರೀ ಬೋರಲ್ಲಿ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ, ಏನು ಬರೆಯೋದಿಲ್ಲ, ಬರೆದಿಲ್ಲ, ಅದ್ ಮಾಡಿದ್ರು ಇದ್ ಮಾಡಿದ್ರು ಫಿಲ್ಅಪ್ ಮಾಡಿದ್ರು ಅಂತ. ಅದನ್ನೆಲ್ಲ ಅವತ್ತೇ ಹೇಳ್ಬೇಕಾಗಿತ್ತು ಫೈಲ್ ಮಾಡುವಾಗ. However, even in absence of such allegations, if there are circumstances giving rise to doubt, then it becomes the duty of the propounder to dispel such suspicious circumstances by giving a cogent and convincing explanation. Suspicious circumstances must be real, germane, and valid, and not merely the fantasy of doubting mind. Whether the particular future would qualify the suspicious would depend on the facts and circumstances of the case. Any circumstances rising specimen suspicious, legitimate in nature would qualify as a suspicious circumstance. For example, a shaky signature, a feeble mind, an unfair and unjust disposition of property, the propounder himself taking a leading part in the making of the will, under which receives a substantial benefit, etc. These are all the guidelines, my lord, all nutshell. Then your lordship may kindly turn to paragraph 12, other lines. Next, paragraph 12. Coming to the facts of the case, a careful perusal of the relevant material and record and applying the provisions and the case laws, it is evident that the will was duly executed by the testator in the presence of witnesses out of his free will in a sound, disposing state of mind, and same stands proven through the testimony of one of the attesting witnesses, namely Suraj Bahadur Limbo, who was examined as PW2 by the civil court. The witness categorically states that the testator executed the will in question, and both he and the testator signed the will in the presence of each other. In my case also, my lord, in our case also, DW3 categorically state that I have signed, the testator signed the will in presence of me, and I have signed the presence of attesting witness as in his presence. And the execution of the will is upheld by the apex court, my lord.
Yes.
And ಇದರಲ್ಲಿ second marriage ಇರುತ್ತೆ, even that also ಅದನ್ನ ಕ್ಯಾನ್ವಾಸ್ ಮಾಡಿದ್ರೆ the apex court has refrained to entertain such. ನಮ್ಮಲ್ಲಿ ಹೇಳ್ತಾರಲ್ಲ ಸರ್, ನಮಗೂ ಬೇರೆ ಮಗಳಿದ್ರು ಇವ್ರಿಗೆ ಯಾಕೆ ಕೊಟ್ಟು ಅಂತ. ಆತರ ಓನ್ಲಿ ದಿ ಫ್ಯಾಕ್ಟ್ಸ್ ರಿಲೇಟಿಂಗ್ ಟು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಆಫ್ ದಿ ವಿಲ್ ಈಸ್ ಕನ್ಸಿಡರ್ಡ್, my lord. Next judgment, my lord. Testimony of next
ಕಂಟಿನ್ಯೂ ಆನ್ ಮಂಡೇ.
ಹಾ,
ರೆಫರೆನ್ಸ್ ಇದೆ ಆಗಲೇ ಟೈಮ್.
ಪ್ಲೀಸ್, ಜಾಸ್ತಿ ಇಲ್ಲ.
Sorry, madam, heard. Further arguments, this and posted for further arguments on Monday. Meaning ಎಲ್ಲ date ಕೊಟ್ಬಿಡಿ. ಇನ್ನೊಂದು ಇದೆಯಾ ಪಾರ್ಟ್ ಆರ್ಡರ್?
ಹೌದು ಸರ್.
64 ಒಂದು ಇದೆಯಲ್ಲ ನಾಗರಾಜ್ ದಾಮೋದರ್ದು. ಮಂಡೇ ಆಗ್ಬೋದಾ? 64 ಮಂಡೇ 13-1 ಅಲ್ಲ, 13-1 ನಾಗಭೂಷಣ್ ಅವ್ರದ್ದು ಮಂಡೇನಾ 13-1. ರಿಮೈನಿಂಗ್ ಎಲ್ಲ ಡೇಟ್ ಕೊಡಿ, ಇಯರ್ ನೋಡ್ಕೊಂಡು ಮೇಡಮ್. 16
ಕೈಂಡ್ ಪರ್ಮಿಷನ್ ಸೀರಿಯಲ್ ನಂಬರ್ 77 21st ಕೊಟ್ಟಿದ್ದೀರಿ, 23rd ಕೊಡಿ ಸರ್.
ಅದರ್ ಸೈಡ್ ಇದಾರಾ?
ಅದರ್ ಸೈಡ್ ಬಂದಿಲ್ಲ ಸರ್.
ಸತ್ಯನಾರಾಯಣ್ ಚಲ್ಕೆ ಇದ್ರ ಇಲ್ಲ? ಆಯ್ತು,
ಹೇಳ್ತೀನಿ ಸ್ವಾಮಿ ನಾನು.
ಆಯ್ತು. 23-3
23
23-1 77 ಹಾ ಇದೀರಾ? 23-1 ಪ್ಲೀಸ್ ಮೇಡಮ್. ಏನ್ ರಿಕಾಲಿಂಗ್
ಇಶ್ಯೂ ಆಗಿರೋದು ಸರ್.
ಅದು ಬೇರೆ ಇದು ಏನಾಯ್ತದು? ಹಾ
I have prepared.
ಒಂದು
ಹಾ ತೊಳಿ ಏನಾಯ್ತು ನೋಡಿ.
Already he has undergone 2.5 years imprisonment, my lords. 3 ವರ್ಷ ಶಿಕ್ಷೆ ಮಾಡಿದ್ರು. 3 ವರ್ಷ ಶಿಕ್ಷೆ ಮಾಡಿದ್ರು, my lords. 2.5 ವರ್ಷ already under trial prisoner ಆಗಿ.
ಏನ್ ಅಫೆನ್ಸ್ ಏನು?
457 and 380 of IPC, my lords.
ಮತ್ತೆ ತೊಳಿ. The counsel for the petitioner has filed an application on section 483 of DNSS. He prayed the court to release him on bail. The reason assigned in the application is that ಏನ್ reasons ಕೊಟ್ಟಿದ್ದೀರಿ?
My lords, NOC ತಕೊಂಡಿದ್ದಾರೆ.
Advocate has given no objection. To
Without
counsel who
intimation.
was on record before the trial court and he also passed away and hence could not communicate the same.
Apprehension of the respondent police, my lord. If he released on bail, he may be absconded.
On perusal of the order sheet, it discloses that the earlier advocate has given no objection, but subsequently non-bailable warrant has been issued and he has been brought before this court. And hence warrant has been recalled, warrant and hence he has been brought before this court. And for the reasons stated in the accompanying application, he has been ordered to release, directing to execute a fresh bond for a sum of rupees 1 lakh with 2 sureties.
Please, my lords.
With fresh sureties.
Please, my lords. Much obliged, my
ಇದ್ರಲ್ಲೇ
lords.
ನೋಟಿಸ್ ಜಾರಿ ಆಗಿತ್ತಲ್ಲ, sureties ನೋಟಿಸ್ ಆಗಿತ್ತು.
Please, my lords.
ಇದಲ್ವಾ? ಇದರಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿಲ್ವಾ? ಬರೀ ಕರ್ಕ ಬಂದಿರೋದು ಅಷ್ಟೇನೆ ಇದು ಅಲ್ಲ?
Condition
ಬೇಡ ಹಾಗಾದ್ರೆ. ಆಯ್ತು. 13
Condition may be
ಆಯ್ತು.
imposed, my lord.
ಆ?
Condition may be imposed.
ಅದೇ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಫ್ರೆಶ್ ಅಲ್ಲರಿ ಇದ್ರಲ್ಲಿ ಏನೋ ಲಾಯರ್ ತಿರ್ಕೊಂಡಿದಾರೆ ಆಮೇಲೆ ಹಿಡ್ಕೊ ಬಂದಿದ್ದಾರೆ.
My lords, ನಾವು
ಅಲ್ಲ, ಅವ್ರಿಗೆ
petitioner
ಏನಿದೆ
ಇದ್ದೇವೆ.
ಅಂದ್ರೆ-
Revision petition ಅಲ್ಲಿ ನಾವು petitioner ಆಗಿದ್ದೇವೆ.
ಹಿಡ್ಕೊಬರ್ಬೇಕಾದ್ರೆ ತುಂಬಾ ಪ್ರಯತ್ನ.
ಹಾ?
he has been absconded.
My lords, recovery ಎಲ್ಲ.
ಅಬ್ಸ್ಕಾಂಡೆಡ್.
ಹಾ, ಅದಕ್ಕೆ ಅವ್ರು
My
ಹಿಡ್ಕೊಬರೋದು
lords.
ಭಾರಿ ಕಷ್ಟ ಆಗಿದೆ ಅವ್ರಿಗೆ ಅದಕ್ಕೆ.
ಎಲ್ಲಿಂದ ಹಿಡ್ಕೊ ಬಂದವ್ರು? ಎಲ್ಲಿಂದ ಹಿಡ್ಕೊ ಬಂದ್ರಿ ಅವನ್ನ? ಹುಣಸೂರು.
ಹುಣಸೂರು.
ಎಲ್ಲಿದ್ದ? ಮನೇಲಿ ಇದ್ನ ಎಲ್ಲಿದ್ದ? ಮತ್ತೆ ಕಷ್ಟಪಟ್ಟಿರೋದೇನು?
ಅಲ್ಲಿ ಅವರೇ ಹೇಳಿದ್ರು
ಕಷ್ಟಪಟ್ಟೆ ಅಂತ. ಮನೆಯಿಂದ ಕರ್ಕೊ ಬಂದವ್ರಂತಲ್ಲ,
ಕಷ್ಟಪಟ್ಟು.
ಹೊರಗಡೆಯಿಂದ ಏನಲ್ಲ. ಆಯ್ತು. ಹಾ, ಏನಾಯ್ತು ಹೇಳ್ರಿ? Execute a fresh bond before the trial court with fresh 2 sureties within 2 weeks from today. This matter, criminal petition 22
Please, my
admission
lords.
ಆಗಿದೆಯಾ? ಏನಾಗಿದೆ? Admit
My
ಆಗಿದೆ.
lords, admit ಆಗಿದೆ. Next 13th ಗೆ ಡೇಟ್ ಇದೆ.
This the matter for ಆಯ್ತು. ಆಯ್ತು. Call on this matter on 13th ಅಂತ ಹಾಕಿ ಅವತ್ ನೋಡ್ರಿ. ಮತ್ತೆ ಇಲ್ಲಿ ಆಲ್ರೆಡಿ ಬಾಂಡ್ ಬರ್ಕೊಟ್ಟಿದಾರಲ್ವ ಅಲ್ಲಿ? ಮತ್ತೆ ಹಾಕ್ಬೇಕ್ರಿ? ಆಲ್ರೆಡಿ ಬಾಂಡ್ ಇದೆ, ಮತ್ತೆ ಹಾಕಿ ಲಾಯರ್ ಕಮ್ಯುನಿಕೇಶನ್ ಆಗಿಲ್ಲ ಅಂತ ಹಂಗಾಗಿರೋದು ಅಷ್ಟೇ. ಯಾರು ಅಡ್ವೊಕೇಟ್ ತೀರ್ಕೊಂಡಿರೋದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದ್ದವರು?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನೋ ಐಡಿಯಾ, my lords.
ನೀವ್ ಹೆಂಗ್ ಹೇಳ್ತೀರಿ
ಹೈಕೋರ್ಟ್
ಅವ್ರು ತೀರ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ?
ಸೂರಿಟಿಗೆ ಪಿಕ್ಚರ್ ಆಗಿದೆ.
ಆಗಿಲ್ರಿ ಇದು. ಬರೀ ಇಮಿಡಿಯೇಟ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಏನಾಗಿದೆ, ಅರ್ಲಿಯರ್ ಅಡ್ವೊಕೇಟ್ ಇದ್ದಾರೆ, ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದೀರಿ
Please,
ಅಂತ
my
ಹೇಳಿದ್ದಾರೆ.
ಹೌದು.
ಅದಕ್ಕೆ NBW ಇಶ್ಯೂ ಆಗಿದೆ
Please, my lords.
ಅಷ್ಟೇನೆ. Brought before the court and hence by the way application is allowed. ಬರ್ಕೊಡ್ಲಿ ಬಿಡಿ, ಫ್ರೆಶ್ ಆಗಿ ಒಂದು ಬರ್ಕೊಡ್ಲಿ. ಫ್ರೆಶ್ ಬಾಂಡ್
Please not.
with 1 surety ಅಂತ ಹಾಕಿ ಸಾಕು. 1 surety before the trial court within 2 weeks from today.
Obliged, my lords.
Release this matter on 13th. ಹೇಗಿರೋ ಆಲ್ರೆಡಿ ಡೇಟ್ ಇದೆಯಲ್ಲ, ಇಲ್ಲ ಬೇರೆ ಡೇಟ್ ಕೊಡಿ. ಬೇಡ, ತರ್ಸ್ಕೊಂಡ್ರೆ ತಗೊಳ್ಳಿ. ದಿ ಫಸ್ಟ್ ಹಾಕೊಳ್ಳಿ. ದಿ revision petitioner is brought before this court on warrant and application is filed ಅಂತ ಅದು ಹಾಕೋಬಿಡಿ. Allowed enlarged on bail subject to executing a personal bond for rupees 1 lakh with 1 surety before the trial court within 2 weeks. This matter on 21st of January 2025.
Obliged, my lords.
ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ ಇನ್ಯಾವ್ದು ಇನ್ನೊಂದು ಇದೆಯೇನ್ರಿ? ಯಾವ್ದು? 17 ಏನದು ನೋಡಿ.
ಅದೇ ಅದ್ರಲ್ಲಿ ಒಂದು ಅಯ್ಯ ಹಾಕೊಂಡು ತರ್ಸ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿದ್ರು. ಇದ್ರಲ್ಲೂ ನಾವು
ಇದ್ರಲ್ಲಿ ವಾರೆಂಟ್ ರಿಕಾಲ್ ಆಗಿಲ್ಲ, ಹಿಡ್ಕೊ ಬಂದಿಲ್ಲಲ್ಲ? ಯಾರು ಕೌನ್ಸಿಲರ್ ರೀ?
We are presenting the petitioner.
ನೀವ ಕೌನ್ಸಿಲ್? petitioner counsel filed an application on section 70 sub clause 2 of CRPC, and petitioner is also present before this court. And in this case, notice was issued in spite of issuance of notice. The petitioner did not appear before this court, and hence warrant has been issued, and hence warrant has been recalled with cost of rupees 10,000.
My lord,
And cost is payable before this court.
my lord, the cost may be lowered, my lord, because he's a lorry driver and he has two
ಲಾರಿ ಡ್ರೈವರ್
daughters.
ಆದ್ರೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ ಕೋರ್ಟಿಂದ,
Yes, my lord,
ನೋಟಿಸ್ ಕೊಟ್ಟಾಗ ಯಾಕೆ ಅಪಿಯರ್ ಆಗ್ಲಿಲ್ಲ ಅವನು?
cost may be little bit lowered, my lord.
No, no such ಇದು. This court also issued notice against the sureties, and sureties also, ಇದೆ ಅಲ್ಲ ಮೇಡಮ್? And notice also issued against the sureties are also served. ಕಸ್ಟಡಿ ತಗೊಳ್ಳ ಅಥವಾ ಏನ್ ಕಟ್ತೀರ 10,000?
Yes, my lord.
ಕತೆ ಹೇಳ್ತೀರಾ ಬಂದಿಲ್ಲಿ? ಸೂರಿಟಿ ನೋಟಿಸ್ ಆದ್ ಜಾರಿ ಆದ್ರೂ ನೀವು ಬರಲ್ಲ, ಅಲ್ಲಿ ತಪ್ಸ್ಕೊಂಡು ಓಡಾಡ್ತೀಯ.
My lord,
ಮತ್ತೆ ಕೋರ್ಟ್ ನೋಟಿಸ್ ಕೊಟ್ಟರು ಜಾರಿ ಆಗಲ್ಲ. ಇಲ್ಲಿ ಬಂದು ಕಾಸ್ಟ್ ಹಾಕ್ಬಿಡಿ. ಹಾ. ಫೋನ್ ಬಂತ? ಆಯ್ತು.
My lord, one submission, my lord. ಬೆಳಗ್ಗೆ memo
ಸಬ್ಮಿಷನ್ ಎಲ್ಲ ಆಮೇಲೆ ನೋಡೋಣ.
Ma'am, 71. 72.
Final
ಹೇಳ್ತೀನಿ madam. ಒಂದ್ ನಿಮಿಷ ಇರಿ, ಹೇಳ್ಬಿಡ್ತೀನಿ ಮಿಕ್ಕಿದ್ದು.
final hearing.
ಒಂದ್ ನಿಮಿಷ ಸರ್ ಹೇಳ್ತೀನಿ. ಯಾವ್ದು? ಅದು ಏನ್ ಗೊತ್ತಾ, ಇದು ಲಿಸ್ಟ್ ಆಗದೆ ಇರೋ ಕೇಸ್ ಇದೆ. 226 ಅದು ಆಕ್ಚುಲಿ ನೆಕ್ಸ್ಟ್ ಇರ್ಬೇಕಾಗಿತ್ತು 13th ಇವಾಗ ಕೊಟ್ಟಿದ್ದಾರೆ, ಬಂದು ಆಯ್ತಾ? ನಾನು ಹೇಳ್ತೀನಿ 65, 66 ವರ್ಗೂ ಆಗೋಗಿದೆ. ಹಿಂಗಾಗಿಲ್ಲ, ಆಗೋಗಿದೆ ಅಂದೆ. 13 ನಿಮಿಷ